Come tomorrow.
Milord, only one thing, Milord, item 640, your Lordship had fixed it today at 2 p.m. It is not a, Milord, the interim order your Lordship had directed to expire today. In your Lordship's last order, it directed to appear today, and the interim order is expiring today, Milord. That is, it will not be taken up today, maybe tomorrow if it comes under the heading hearing. It is to judge.
My lord,
6th, na? So today we are on.
Both.
You know the today is not the mentioning date. I will allow you, then I have to allow all. You keep it in mind all these things. What is the mentioning date?
Lordship, paragraph 5. Paragraph 5, Lordship had said it will expire
It
today.
is not listed as 2 p.m.
No, Milord. Milord, even if that is not possible, Milord, tomorrow if it is under the heading hearing, at any time if it can be taken up, Milord. The interim order expires today. Otherwise, Milord, I wouldn't have disturbed your Lordship on a non-mentioning day.
It is today's list, it is there.
Yes, item number 640.
Okay, before rising, you mentioned that. I will
my lord,
inform the other side. I will
Inform the other side, Milord, at 1:15 should I come or at
Yes.
4:30?
Huh?
my lord, it is
1:15 or 4:30 or should I?
No, not 4:30. At 1:15 you come.
1:15.
Before Raja.
Great,
Before
my
that.
lord, my lord, this is the interim order today expire.
Huh?
The interim order that was passed on last 8 January
Huh.
today expire.
Today expiring. Why you not mentioned before that? If today expiring, it is not in the list.
It was told that it will
It is in
continue.
the list or not?
No, today not list, but it was ordered that it will continue in list.
Give that.
Continue list.
Where is the order? Yes, call the list.
Yes, sir.
Lordship,
First
under-
order,
No, I'm mentioning today.
I'm seeking leave to
My lord,
file an
first
urgent
order,
matter,
my
Your
lord.
Lordship.
my lord, this is the order, my lord. Please, my lord, kindly continue.
You that
This
you.
is the first order. And second order, it was extended.
So why you not mentioned yesterday?
My lord, it was expected that today it will be appeared as per the order. It will continue in the list.
8th January. Where till
It was for 1st January.
8th January. So it will be listed. Not the today's not the 8th January. Then
No.
Such
Your
Lordship.
Sir, my lord, thereafter it was heard on 8th January. That was extended.
Read the order. Yes, call the
Lordship,
list. Call the list.
under the compelling circumstances, Your Lordship, I'm seeking leave to file an urgent matter, Your Lordship. The urgency
Call
that
the
Your
list. Nobody is appearing. As none appears inside of the order. In spite of the order passed by this court.
I am here, my lord.
So why they are not appearing?
My lord, because my lord, forgive. My lord, I apologize, my lord.
Why the matter has been called? Why you are not appearing? Yes.
My lord, the money has been, my lord, paid to my lord, the learned advocate, my lord.
Who is the finance secretary?
My lord, he is present in the court, my lord. He is just.
Sir, you all senior officers of the administration. Why this type of the you know the what have been done in the matter? First day when the matter was called, advocate has stated that the amount has already been transferred. Then I have put after 1 week, see that. 1 week they are coming now, it has come to the other account. Then they ask for the another date. Then they came before the court, yes, the judicial department taking care of it. One day AG has come, he has made an assurance, yes, but amount will be. Now tomorrow your assistant secretary have seen the letter. Can this is the proper way of the your subordinate officers to like this? Once the advocates are assuring before this court the amount will be, and in the letter they are asking that no, he has to submit an application before the judicial department. Then 1 week time will be taken for transfer of the amount. This is not the way. That's for the compelling circumstances. This court has passed an order for appearance of you in personal. Otherwise, the court is not any grievance against all of you. Please see to that, you all senior officers of the administration, please see to that. Genuine case, you have to deal with that.
No, only thing may I tell. I was not present in court yesterday, madam. I'm very sorry.
My lord, yesterday's submission on behalf of the my lord, the bar or my lord, or my lord, the junior advocate was not to some extent correct whatever my lord, the information that he received or instruction that he received. My lord, the instruction was that my lord, that to my lord, the, for the purpose of refund of that money, my lord, a specific account number is required and other thing. That is why he
Mr.
was,
Sen,
my lord,
I totally
asked to my
appreciate.
lord,
That's why I'm telling. I am totally appreciate
My-
your submission. I was that side. I was that side, and I had represented the government for 5 years as a government pleader. I know the predicament of the government, but once the advocates are telling before this court on thrice, and the AG has also came before this
Yes,
court and
my
given the assurance that amount. Now, then the last occasion they're telling them that they have to file their application before the department. Then
my lord, that was not the my lord, the correct my lord, the submission on the basis of the my
Okay,
lord,
no problem.
information received.
no
And
problem.
not application, may I tell you, Your Lordship? Only thing that should be the my lord, the correct my lord, the expression should be information,
Correct.
not
That's
application. Information should be given that to which account it should be credited because through internet service it was done. So only that thing, that
Okay,
only
whatever.
that thing.
Okay.
And my lord, that was not the my lord, the correct my lord, lordship instruction, that application, information. That is only thing. Otherwise, my lord, we were ready. Otherwise, we were ready.
So whether amount is transferred
Yes,
or
my
not?
lord,
Yes, it has been
transfer.
transferred today. One thing I'll be praying, my lord. This is one example where we have been able to approach this honorable court. I'll be praying that a my lord, comprehensive affidavit may be filed so that for future use,
Well,
Lordship may
he-
kindly lays down the guidelines.
You are
He
concerned
could
with the
have
this
drafted
case.
I
You
am
are concerned with
concerned
this case.
I'm
You
concerned
got the
Yes,
amount. You
amount.
got the relief.
This
Yes.
is not public.
This is not the
interest
public
litigation,
interest
it is appearing.
litigation. This court
So,
cannot pass in the open
Yes,
air.
scope of
Any
the
order
matter
in the
cannot
open.
be my lord, wider in that
In
sense.
terms of the order passed by this court dated 3rd February 2026, comma, the Secretary Finance of the Government of West Bengal is present in person, full stop. Learned Counsel appearing for the state submit that the amount has been transferred in the account of the petitioner and the petitioner has accepted the same. According, this court find that the grievance of the petitioner has been complied with by the authorities and nothing remains in the present writ application. The writ application disposed of. The personal appearance of the Finance Secretary, Government of West Bengal is dispensed with.
People only.
Get.
Thank
Only
you.
because of the
My lord,
because of the fact that we are advocates, my lord, we could have. Had this been a person
That-
who is
that's
not
why you
advocate,
take-
I'm not saying common person, we are all common persons.
Okay, thank you. Thank you. Give the name. Yes.
Item number 2, my lord, this matter is appearing at my instance for correction, my lord.
Yes, what is the correction, sir?
my lord, matter is since disposed of. So is there any my lord, necessity to record that personal have been dispensed with? Because the matter is disposed of.
Dispensed with.
Might get.
Tomorrow there will be no conflict.
Lord, under peculiar circumstances, my lord, I am seeking correction of a correction.
Yes, which portion?
My lord, what happened? On 22nd, my lord passed an order. In that order, there were 5 or 6 typographical errors. I
All the
mentioned this
numbers.
matter for correction.
Ah,
My lord, on 29th, when the corrected order was passed, my lord, at the time of passing that order, my lord, a new typographical error has arisen. My lord, kindly see the original order, paragraph number 4.
yes.
My lord, in the paragraph number 4, my lord will find the mentioning of respondent number 5 in the second line and in the fifth line. My lord, in the fifth line, respondent number 5, it should have been respondent number 8. I mentioned this matter for correction, but my lord, in the corrected order, if my lord
No, you have mentioned in paragraph 4, line number 2, the respondent number 5 to be read as respondent
No,
number
but-
8.
the correction should have been in the paragraph number 4, line number 5.
No, kindly see, I have recorded because what you have made a submission, I have made the pencil entry.
My
I
lord,
have made the pencil entry. You made a wrong submission. What can be done?
due to some
Every time you are coming, one or the other advocates are making a submission. That cannot be, sir.
my lord,
See, it is my duty. Either I am taking the corrected order from the advocates, or you are making asking for the correction. I am taking note of in the original order itself.
my lord.
I know. I faced this problem earlier occasions also.
My lord, the difficulty is now my sanctioning authority and disbursing authority, those have been changed.
What?
My lord, The correction
Who is
should
the
have,
sanction on respondent number 5?
respondent number 5 is the CMOH Nodia.
Huh?
CMOH Nodia. My lord, the respondent number 5, that should have been the sanctioning authority. The second line, respondent number 5, that is all right. But my lord, in the fifth line, that should have been respondent number 8. But correction has been made in the second line.
That has not been made. We got an order. This court by an order dated 22nd January 2026 disposed of the matter. Full stop. On 29th of January 2026, the petitioner has mentioned the matter for correction in the order. And accordingly, by an order dated 29 January 2026, this court has corrected the order dated 22nd January 2026. Now today, again, the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner and submit that in paragraph 4, line number 2, it should be remain the respondent number 5, but in the line number 5, instead of the respondent number 5, it should be read as respondent number 8. But in the corrected order dated 29 January 2026, in paragraph 4, line number 2, it has been recorded as respondent number 5 instead of respondent number 8 instead of respondent number 5. That is to be corrected, is to be remain as respondent number 8 and respondent number 5. And line number 5, it should be read as respondent number 8 instead of respondent number 5. Considering the submission made by the counsel for the petitioner, the order dated
My lord, if my lord
21st of
allows,
January
my lord, in paragraph number 5, in third line, there is a date.
2026, 29 January, 22nd January 2026 and 21st of January 2026 is corrected by recording that in paragraph 4, line number 2, the respondent number shall be read as respondent number 5, and in line number 5, the respondent number 5 shall be respondent number 8. Yes.
My lord, in paragraph number 5, third line, there is a date. In place of September 20, it will be 28.
28 already recorded here.
My lord, the correction has been made in the first
in paragraph 5 of the order dated 22nd January 2020, the date shall be read as 28 September instead of 22nd.
28 September.
28 September instead of 20 September 2021. This order may be read along with the order dated 21st of January 2026 and the corrected order dated 29 January 2026. Yes, call the other
Deeply
matter.
obliged.
My lord, this is the order.
Call
Kindly
the
grant
letter.
allow my lord, otherwise it will be irreparable loss to my lord.
Though the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner, but the matter, when the matter is called, none appears for the petitioner. Let the matter appear in the combined monthly list of June 2026.
Lordship, I am for the petitioner, Lordship. Lordship, I am for the
Matter is
petitioner.
called, why you're not mentioned? Why you're not appearing?
Lordship, I am appearing through the online, Lordship. There is some technical glitches, that's why, Lordship. Lordship, this matter is only for non-prosecution, Lordship.
Where is your instruction in writing?
Lordship, I do have the email instruction, but as Lordship, I am appearing through online. I cannot hand
So
over.
that
hand
is
it
the
over.
problem. You are appearing online. There is no instruction. And tomorrow the other advocate will come say, no, we are not given any instruction.
Lordship, no, Lordship, I am the advocate on record. Lordship, kindly keep this matter on tomorrow. I will appear, Lordship. I will give the written instruction,
So the
Lordship.
prayer made by the petitioner, matter is adjourned. Let the matter appear tomorrow under the same heading. Next.
Deeply obliged, Lordship. Deeply obliged.
Four Millard, I appear for the Millard petitioners. Millard, this is for restoration.
Lordship, I am appearing for the opposite party number 2, but no restoration application has been submitted.
I'll give a copy, Millard. We have served. This is the affidavit of service. But Millard, if my learned friend wants, I'll give another copy to my learned friend, Millard.
My office has instructed that no copy was served.
No, it
Let him
was
serve.
served, but I'll give you a copy. Stitch kora nahi karna. Millard, it was dismissed for default, Millard. Thereafter, Millard,
When
We
it
have-
was dismissed for default.
Milord, it was dismissed for default on 19th of May 2022.
Yes.
We filed the restoration on 27th of September. There was some delay, Milord. We have filed a section 5 as well, Milord.
Hmm. So, but you are not appearing on 27 January matter was listed, they are not appeared.
True, Milord.
Yes. And 2010 matter, you are enjoying the interim order.
No, Milord, there is no
Ah.
interim order.
What is the matter?
There was initially an interim order, Milord.
Ah.
Milord, this relates to, Milord, the RPUP Act, Milord.
Hmm.
On the basis of statement of a co-accused, Milord, the petitioner, who is a director of a particular company, was implicated.
Hmm.
Milord, the legal issues, Milord, involved are whether, Milord, at all, Milord, on the basis of statement of a co-accused, Milord,
Hmm.
a person can be prosecuted. This is number one. And number two, Milord, whether there is any vicarious liability, Milord, in respect of offences under the RPUP Act. And thirdly, Milord, so far as, Milord, the warrant of arrest, which was also a subject matter of challenge, is concerned, Milord, that warrant of arrest was executed during pendency of this revisional application. Petitioner was arrested. He was later granted interim bail. That interim bail was confirmed. And subsequently, Milord, the prosecution has filed, Milord, a report, Milord, in final form, Milord, which,
So you are appearing for whom?
Milord, I am for the petitioner, Milord.
No, you are accused.
I am the accused.
So final, it is on
Final form, Milord, in the nature of, Milord, case made out.
charge sheet.
Charge sheet.
Not
Now,
the-
Milord, this is RPUP Act, so they call it, Milord, a prosecution report, prosecution complaint. Milord, I was today requesting your Lordship, Milord, if your Lordship may be minded to restore my application, Milord, fix a
No.
date for
Yes,
hearing.
you are appearing
I'll
for
give another
I
notice.
am appearing for the opposite party number 2
Ah,
railways.
who is for the state?
I don't know whether
State,
it
Milord,
has
may
been
not be
served
a-
or not.
Yes, yes.
But
State,
was
Milord, is
appearing-
not a very necessary party, Milord. My learned friend, Milord, the
The
railways
CR case.
is basically a CR case, Milord, and railways is the necessary party, Milord.
No, who has filed the charge sheet?
Milord, the railways, they have filed the charge sheet.
Who is for the railway?
My learned
You are not
But
the,
I am appearing for
you are appearing. You are the complainant.
I am appealing for the state one.
You are for the, that's why I'm asking, you are
I-
not appearing. So what I propose to do, let
But-
all the application along with, what about the lower court and this trial court record?
Milord, that is not before your Lordships, Milord.
That is a problem, that is.
Your
to be
Lordship
taken-
can call for it, Milord.
So what I propose to do, I will keep this all application pending.
Very well,
I will
Milord.
take the total revisional application at a day, so that matter can.
Very well. Or Milord, subject to correction, Milord, if your Lordship, Milord, allows my restoration today, Milord, my CRR becomes alive, Milord.
I will allow, I will make the alive,
Very
let the lower court record come,
Very well.
because 2010 matter.
No. It's absolutely, Milord, subject to my Lord's discretion, Milord.
You got an order. The petitioner has filed an application being granted 6 of 2022 praying for recalling of the order dated
Milord, 19th May 2022.
19th May 2022, wherein this court has dismissed the criminal revision for default for non-appearance of the
Copy hai
parties.
extra.
The petitioner also filed an application being granted 7 of 2022 for praying for condoning the delay in filing the application. Full stop. This court find that the criminal revision application is pending since the year 2010.
Okay, wo order sheet pe supplementary dal.
In view of the above, the 10 and no lower court record has been called for. Accordingly, the department is directed to call for the not lower court record, trial court record is directed to call for the record of what is the case number?
Milord, the case number is CR
CR
360 of 2010.
CR 360 of 2010 pending before the London Additional Chief Judicial Magistrate Durgapur Bardwan, arising out of RPF with /Andal within bracket proper post crime serial number 12 of 2010 dated 19th June 2010 under section 3 within bracket small a of the Railway Property Unlawful Possession Act 1966. 6 on before the next date of hearing. This court is of the view all the application along with the criminal division application will be taken up for hearing. Give the date. अप्रैल में दो फर्स्ट वीक में
Then we fix it a date in the month of March. Because
छोड़ो ना यार, ये ऑर्डर पास हो रहा है, रिकॉर्ड ही चले আসছে এখানে, it's more than stay.
देखो कौन सा डेट है कौन सा डेट है देखो, 7 तारीख, 8 तारीख, 9 तारीख, 9th April at 2 p.m. as a specially fixed matter.
That's the only thing, that's it's case of 2010, I was in 2010. I don't have the copy of the
Send it today itself. Have it, no?
copy of
the.
So why didn't you
In the
tell me
meantime, the
before
petition is directed to serve the copy of the original application and connected application along with the document to the state and the railway authority.
But also grant me my lord liberty to file a supplementary affidavit just to my lord keep the records my lord correct. My lord, I have 10 my lord the certified copy of the my lord.
Bring that, I will see to that. Because I am not restored, so
I'm the
no consequential order can pass.
okay.
Yes, next.
9th April. কাগজ দিন না। My lord, this is my restoration.
I appear for the respondent.
How the matter will be before this court?
It is irrespective of classification, your lordship is taken.
2013, CD 2023
Yes.
onwards.
My lord,
This cannot, I am releasing it.
one.
Not 2020, no. Irrespective of 2023 onwards.
My lord, it's not there in this today's.
And they say,
2023 onward, with respect.
yes.
My lord, it's not 2023 is not here in the list today. That's the problem. It's not.
Three, serial number 3. Hearing of writ petition irrespective of the classification, including application connected thereto 2023 onwards.
It's a problem. My lord,
This
it's a
court
pro
find
bono
that
matter
this
I'm running
matters,
from.
this court is not having the determination to hear the subject matter of the writ petition. Accordingly, WPA number so and so is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination. Next.
Appearance. By an order passed by my lords, dated 3rd December 2025, which is at page.
Give. Yes.
With Millard's order of 3rd December 2025
is
is at page 114 of the application.
There is a contempt application.
It's a contempt application, Millard.
Yes.
Page 114, Millard. So this was the issue pertaining to making the stalls in the trolleys at the railway co-terminus.
Hmm.
So Millard had set aside stayed the impugned order and had directed the railways to allow me to commence my business.
Hmm.
So the relevant portion is at page 117, Millard.
Impugn order is still till 7 January and the respondent
It's
director.
been extended from time to time. Millard, the latter portion,
Yes.
the respondents are directed to allow the petitioner to continue with the business till 7 January.
Yes.
So by subsequent orders, Millard, in the writ petition, the interim order has been extended up to 3rd March, Millard.
Yes.
Now, Millard, we had communicated the order by an email at the following page 118 on 5th December itself. But nothing has been done. They have not allowed me to operate. But at page 119 is my communication to the Senior Divisional Commercial Manager as well as the ACM to allow me to operate the stall subsequent, but in continuance of my Lord's order.
Yes.
Still, Millard, they are not doing so, Millard. Every day's business is being hampered, but we'll see the impugned order, which is there at page 109, the operative portion at page 112. Then we'll see the last portion, the last paragraph, Millard, in compliance of the order. Hence, keeping in mind all the above facts and railway guidelines, undersigned came into decision that all MPA stalls, tables, and trolleys has been given 7 days time to close. It has stayed this order and had allowed me to operate.
Yes. Yes, sir.
So would you allow me to submit?
Huh?
The first time, even your lordship directed to allow me. Your lordship, I will see. I have filed immediately vacating interim order is there.
Maybe, but you may have filed the vacating order, you may have filed the appeal, might have been. Yeah, either you show the interim order, you have stay out.
Ordinance bench directed that to pay the such amount. Your lordship, I see the order that
in pursuant to the order, they have the respondent authority complied the order, but directing the petitioner to pay the such and GST and such amount on condition they will be allowed to cut. That is I have my submission, but that has not been complied.
The wrong submission.
That is
If
with
it is wrong, then I will be punished. If it is wrong, I have stated everything in his vacating in team order. So, this is first time, appearing the contempt application.
So you have a instruction that you will not comply with the order passed by this court. No question of complying with the order.
Comply with some.
This court has stated the order, operation of the order dated on page 11, 112, and allow the petitioner to continue. Rightly or wrongly, you have neither preferred an appeal, not got an order of stay. The matter is pending. You file the application for vacating. That is also pending. But whether filing an application for vacating will give you a right not to obey the.
Yes, certainly not.
Then let the officer come and say
Order
when he will come. When your officer will come, who is the authority? Who is the officer?
The officers will see.
Let the come and say
the cost
he will
item.
not allow.
One is Vishant Kumar, the other one being the Babban Kumar, and the third one is Upendra Singh.
Yes.
Page 3.
I take instruction why the order was not complied. May I take instruction? I want to take some instruction why the order was not complied. This is the first time,
Not first time. 3 dates before. Please hear this court. 3 dates when the matter was taken for extension of time, the learned counsel appearing for the petitioner specifically alleged before this court you are not complied with, but there is no application. This court has not passed an order. Now they have filed a contempt application before this court, and from FSI, and as per your submission, you are not complied the order till date, whether it is wrong order or right order. So what can be done? Either rule is to be issued, or I am fixing tomorrow, take instruction. The railway authority make an email and take instruction. Why you are not coming? Before this court, the contempt is very harsh.
Yes, I know that. I know the mind of the court.
This court has passed an order, and I cannot shut my eyes, but not complying the order passed by this court also.
Your Lordship, I will visit on Friday,
The PH filed these writ petition, the contempt application on 17th December itself.
The petitioner has filed the present contempt application on the allegation that the respondent authorities have violated the interim order passed by this court dated 3rd December 2025 by not allowing the petitioner to continue with the business. Full stop. Learned counsel for the alleged contemners pressed for time to take instruction. According case is adjourned, let the matter appear on 6th February 2026 under the same heading.
6th February.
Yes. Yes.
Respondent petitioner,
Big petitioner.
the point involved in this matter, my lord, what is the effect of an act declared repugnant to the central act by the Supreme Court and a decision made? This is the short point involved in this matter.
You are for the private respondent.
I filed the vacating application because the stay was granted, so I filed the vacating application. That is kind one. My lord,
You are for the petitioner.
I am for the writ petitioner.
Yes.
my lord, the short fact is that I am a purchaser of a flat under the agreement with the developer. Upon purchase of the flat, it is found that the flat was delivered to me not according to the agreement between the parties. The area was short, the common space has been sold, so on and so forth. Well, there is a law that under that law of 1993, I can make a complaint. And in fact, I made that representation by an application that was considered, and thereafter, number of writ petitions were filed in this court. My lord, fortunately, one of that matters came before your lordship in 2021. Your lordship was also pleased to pass an order directing that let it be heard before the authority before whom it was pending. Ultimately, the authority has finally passed an order, declared that this is the wrong, and my lord, the necessary order for compensation and other things were passed. Now, my lord, after that order was passed, now, my lord, first of all, may I take your lordship to the page number 194, your lordship's order.
This my writ petition, my lord.
And my vacating application. If my landlord wants, I do not have any.
Now, whether affidavits completed in the writ petition? Writ petition. Who is for the respondent authorities?
My lord, Mr. Amol Sen was appearing, my lord, on behalf of the state of West Bengal.
বইগুলো কোথায়?
Now, if your lordship, my lord, permits.
So, shall I take the total application?
Yes, it is better.
Then he start.
Let him start. I don't know.
My lord, the writ petitioner before your lordship, my lord, is a developer. Altogether, 64 flats were developed by him and were handed over to various parties. My lord, the issues, my lord, emanate from mainly twofold allegations of handful of customers who have been added as private respondent in this regard. Allegation number 1, that my lord, they were handed over with flats having lesser size than what was depicted in the agreement. Number 2, they were provided with lesser proportionate share of land than what was promised. Now, my lord, thereafter, there were several rounds of litigation. This is basically, my lord, the 4th round of litigation. My lord, in this writ petition, the subject matters of challenge, my lord, are 2 orders passed by the Principal Secretary, Housing Department, dated 3rd of July and 31st of July 2023, in exercise of powers conferred under the 1993 Promoters Act and the, my lord, 2017 West Bengal Housing Industries Regulation Act, whereby, my lord, the first allegation, my lord, was, my lord, found to be correct, and, my lord, huge amount of compensation was sought to be levied on us. That is the subject matter of challenge in this writ. Now, my lord, the principal issue we are seeking to canvass, my lord, is that in view of, my lord, the West Bengal Housing Industrial Regulation Act of 2017 having already been struck down by the Honorable Supreme Court in 2021, the entire proceeding was, my lord, without jurisdiction. And the concerned authority was quorum non-use. My lord, since the matter is ready for hearing, lordship may kindly allows me to apprise your lordship with regard to the brief, my lord, factual matrix, my lord, which has necessitated filing of this. My lord, the construction was made, my lord, in 2004.
Who are you? You are the flat owners.
I am the flat.
Who are you?
Senior colleague is, I am the developer.
You are the developer.
Yes.
Correct.
Now, my lord, 2004, 2005, my lord, these flats were, my lord, the building and the flats were, my lord, constructed. Possession was also handed over, my lord. My lord, the entire consideration amount, my lord, was not received from the private respondent. 2005 to 2007, my lord, no one raised any objection, either with regard to quality of construction or with regard to the size of the flats. 2007, my lord, first time the writ petitioner, he started making communications to the private respondents asking for the residual payment. In January 2007, my lord, the agreement contained an arbitration clause. So, my lord, the arbitration clause was invoked at the instance of the writ petitioner. But as a counterblast, my lord, in February 2007, the writ petition, the private respondents, they approached the, my lord, authority, concerned authority under the promoters. Now, lordship may kindly, as the documents are concerned, lordship may kindly allows me to draw your lordship's kind attention to page 60 first. 60 of the writ petition.
Yes.
We find this is a communication issued by the respondent number 4. the communication issued by the respondent number 4, my lord, to the developer. My lord, lordship kindly allow to place we hereby confirm that we have taken his full vacant possession of the flat of our flat in good condition and complete in all respect as per agreement of sale executed on 10th March 2005. So this, my lord, conveys unequivocal satisfaction of the purchaser regarding the quality and size of the construction.
Yes.
Next, my lord, is the 61 is the occupancy certificate. Was issued by the writ petition to the respondent number 4. Lordship will find that there is a note, my lord, countersigned by the respondent number 5 regarding receipt of the occupancy sign.
Yes.
So no objection was raised at this. Now, lordship kindly comes to page 65.
Yes.
My lord, this is the letter dated 7th May 2005
Yes.
issued by the developer, the writ petitioner, seeking for residual payment of the consideration amount. Now, my lord, page 65 onwards up to page 72, my lord, are my lord various letters issued to my lord various purchasers. Now, lordship may kindly straightway comes to page 73.
'65 to '73.
72. Now, 73, my lord, is important. Whereby, my lord, an attempt was made by the writ petitioner.
What is the 72?
73, my lord. 73, my lord, is a letter by dint of which the writ petitioner sought to invoke the arbitration clause contained in the agreement.
Yes.
My lord, immediately thereafter, this is, my lord, lordship may kindly take note of the date, my lord, 19th of January 2007.
Yes.
My lord, page 74, my lord. This is the first complaint addressed to the authorized officer under the Promoters Act, my lord, of 1993 by the purchasers, my lord.
74.
This is, yes, 74, my lord, 86. There is no date, my lord, but lordship may kindly record it, my lord. This was filed on 15th of February 2007.
Who has made the complaint?
My lord, some of the purchasers.
Flat owners.
Yes. The names
Yes.
of the complainants, your lordship will find at the left-hand side of the page. And, my lord, at page 86. The last name, my lord, Iracharan Najirani, my lord, is the respondent number 4, page 86.
Yes.
My lord, thereafter, my lord, there were, my lord, several rounds of litigation. Lordship may kindly, straightway, I shall not, my lord, trouble your lordship with all the, my lord, facts. Lordship may kindly, straightway, my lord, comes to page 190.
Yes.
119, my lord, is an order passed by this honorable court, my lord. Relation apropos a writ petition filed by the writ petition.
Yes.
Whereby this honorable court was pleased to, my lord, set aside. Lordship may kindly turns over to page 120. The order dated December 19, 2008. My lord, this is an order of the authorized officer is set aside and the matter is remanded to the divisional authority for a fresh consideration. Upon affording all parties due opportunity of hearing, the final order should be passed within a period of 6 weeks from the date of communication of this order. And the order must include reasons to indicate both the applications of both application of mind of the divisional authority and the manner of working of the mind.
Correct.
Now, my lord, page 121 is the, my lord, order of the divisional authority
In terms of the High Court order.
in terms of the in compliance of the order passed by the Honorable High Court. It starts from page 121. I would like to draw your lordship's kind attention, my lord, to page 124. An observation made at page 120.
124.
124.
Yes.
First, second, third, fourth paragraph. It starts with on 7th of April 2010. The joint measurement of the flats in question was taken by the parties in presence of the government officials. A copy of the measurement sheet was submitted to this authority. After perusing the measurement sheet and hearing the parties, this authority found that said measurement was inconclusive as the super built up area of the respective flats was not determined. As per the agreement entered between the purchasers and the promoter, every purchaser would get flat having a particular super built up area. In view of the above, further direction was issued by this authority by number such and such dated 18th April 2011 to the parties to appoint a surveyor by mutual consent, and the surveyor so appointed will prepare measurement sheet of super built up area of each flat under dispute. The purchasers prayed for a review and modification of the said direction through a letter dated 18/5/2011 on the ground inter alia law does not qualify or define super built up area. On the other hand, the promoter suggested the name of a surveyor such and such to the purchaser in compliance of the order dated 18th April 2011. So, my lord, this, my lord, direction for appointment of a surveyor for joint measurement was objected to by the purchasers who were complaining of receiving flats of lesser size.
Correct.
Now, lordship may kindly comes to the last paragraph. In view of the above, it may be said that actual measurement of the flats in question having regard to the agreement for sale deed is essential to resolve the issue, but the purchasers could neither show this authority what is the actual measurement of the flats in question, nor they appoint a surveyor mutually with the promoter and get the actual measurement done, so that how much less in size the flats in question are ascertained having regard to agreement for sale deeds. Hence, it is not proved that the flats in question are less in size than the agreed size. There was another issue with respect to these applications. It is submitted that the promoter sold 3 kata of land out of total 45 kata approximately of land to the project, and thereby the purchasers are adversely affected. The promoter pointed out there was actually 72 flats to be constructed on 45 kota of land. At that stage, the promoter entered into agreement with the purchasers. Subsequently, they sold 3 kota disputed land and revised the plan to construct 64 flats in the remaining land. In the view of this authority, had there been 45 kota of land, then it would have been divided among 72 flat owners. The share of each flat owner would have been 0.65 kota. In the revised scheme, 42 kota of land is shared by 64 flat owners. On calculation, it comes to 0.65625 kata per flat owner. Thus, in the new scheme, the purchasers stand benefited by 0.03 kota of land. Hence, the promoter has not made any wrongful gain out of the sale of 3 kata land. With the above view, both the divisional applications are disposed.
Yes.
Now, my lord, this order, my lord, was assailed by the purchasers before this honorable court and was ultimately, my lord, disposed of by your lordship by a judgment and order dated 6th of January 2022, which starts from page 194.
Any order?
This is your lordship's order. Lordship may kindly straightway comes to page 206, my lord, the ordering portion.
Page 206.
Yes.
Internal page 13 of the Malord. Not the first, second, third paragraph. Now, before I place this, I must indicate this, Malord. Unfortunately, when this order was passed by your lordship, it was not pointed out to your lordship that the Promoters Act of 1993 and the 2017 Housing Industry Regulation Act, my lord, both were, my lord, struck down by the Honorable Supreme Court by, my lord, a judgment and order, my lord, dated 4th of May 2021.
Okay.
And this judgment was delivered by your lordship, my lord, on 6th of January 2022.
Yes. Yes.
Now, my lord, the third paragraph of the order. The order passed by the authorized officer dated 11th July 2011 is contradictory to the order dated 18th 4/2011 and the reports available on record. The authorized officer by order dated 18th April 2011 has held that it is necessary that the parties have a fresh joint measurement of the flats under dispute, including super built-up areas, through a surveyor for proper adjudication of dispute. But there is no report received by the authorized officer while passing the order dated 11th July 2011. The authorized officer had also not decided whether the report submitted by the official engineer earlier is acceptable or not, and also not taken into consideration of the earlier reports. After considering the above, this court is of the view the order passed by the authorized officer is not sustainable under law, and accordingly the same is set aside and quashed. The authorized officer, that is Secretary, Government of West Bengal Housing Department, New Secretariat Building, is directed to hear the review applications of both the parties afresh after giving an opportunity of hearing to the parties and pass appropriate reasoned and speaking order within a period of 3 months from the date of communication of this order. My lord, in pursuant to this order, in compliance of your lordship's order, my lord, the issue was once again, my lord, taken up afresh and adjudicated by the concerned authority. Initially, my lord, an order in the nature of a show cause dated 3rd of July 2023 was issued, which your lordship will find at page 208, my lord. This is 208 is the forwarding letter. Starts from page, my lord, 209. Lordship may kindly take the trouble to come to page 209, paragraph 14, 219. Stand corrected, man.
This is the impugned order, yeah.
This is also, man, there are two impugned orders.
Okay.
The order dated 3rd of July and the subsequent order dated 31st of June. 219, paragraph 14, my lord, several issues were framed, my lord, by the authorized officer.
Yes.
My lord, next page, page 220. My lord, clause A deals with the allegation of the purchasers regarding receipt of lesser proportionate share of land.
Yes. Page 220.
Page 220.
Yes.
My lord, first, second, clause A, lordship may kindly takes one of my lord, the 5th line from the bottom of clause A.
Yes.
On calculation, it comes to 0.703 katha per flat owner. Thus, in the new scheme, the purchasers do not appear to be adversely affected. However, the total quantum of land should have been rectified in the subsequent agreements, and the matter must also have been brought to the notice of the authorized officer, which was not done by the promoter. You know, this I say is a new allegation, and the allegation regarding receipt of lesser proportionate share of land, my lord, was found not to be correct. My lord, page 222 onwards, my lord. Yes.
My lord, penalties were proposed. Lordship will find, my lord, first, second, third. 8th line from the bottom of the first paragraph. Hence, the promoter may be directed to pay a compensation which will be the amount equal to 10% of the purchase value of the flat with a simple interest of 12% from the date of making over possession of the flat to the respective petitioner to the date of paying the compensation. The amount may also be set off against pending payments on the part of the petitioners, if any, in which case interest will not be applicable on the amount so set off. The payment will have to be made within 3 months from the date of this order. Next page, my lord. Page 223. Last paragraph. Now, in terms of the provisions of Section 6, capital A of the Promoters Act 1993, the promoter is directed to show cause as to why the above orders shall not be passed against him. Let both the petitioners and the promoter present before me on 6th of July 2023 at such and such time for hearing against the show cause. So, my lord, apart from the legal issue which I am seeking to canvass before your lordship, my lord, this is also my submission that the authorized officer, even at the stage of issuance of the show cause notice itself, my lord, arrived at a conclusive finding of guilt. At the stage of issue, this is, my lord, in the nature of a show cause. But while issuing the show cause, he had already made up his mind and had arrived at a conclusive finding of guilt against the writ petition. So he had basically prejudged the issue, rendering the requirement of issuance of show cause, my lord, and futile exercise.
Yeah.
Now, my lord, page 224 and 225 is the response of the writ petitioner.
Yes.
And page 226, my lord, is the final order. 226 to 228. 226 is the, my lord, forwarding letter.
Yes. So
227,
227.
yes. Paragraph 4, my lord, speaks of the penalty. Therefore, considering all the above and in continuation of the
Order date.
order dated 3rd of July 2023 passed in the matter, it is hereby ordered that the promoter shall pay to the petitioners mentioned in para 3 above a compensation which will be amount equal to 10% of the purchase value of their respective flats with a simple interest at the rate of 12% from the date of making over possession of the flat to the respective petitioner to the date of paying the compensation. The amount may also be set off against pending payments on the part of the petitioners, if any, in which case interest will not be applicable on the amount so set off. Payment will have to be made within 3 months from the date of this order. Next, the promoter shall pay to the petitioners mentioned in para 3 above further compensation at the rate of 12% per annum simple interest on the total payment received from the respective petitioners till the completion date mentioned in their agreements for the period commencing from the date following the date of completion as specified in the agreement to the actual date of handover of possession of flat, and such compensation may be adjusted against any pending payment from the respective petitioner to the promoters. The payment in this regard will also have to be made within 3 months of the date of this order. In the event of the promoters not paying the compensations as determined under paragraph 1 and 2 above within the time stated therein, the petitioners may file complaint with the appropriate authority for taking action against the promoters in terms of section 13 of the Promoters Act 1993 if they are so advised, in addition to taking reports of any other remedy as may be available under the laws for realizing the compensation amount. So the entire proceeding, my lord, was initiated and undertaken under the 1993 Act Promoters Act and the 2017 West Bengal Act. Now, may I draw your attention, my lord, to the, my lord, judgment of the Honorable Supreme Court. It is reported in 2021 8 SCC 599. Lordship may, I shall not trouble, it's a voluminous judgment, my lord, I shall not trouble.
Almost a book.
Now, Lordship may, a kindly straightway comes to my lord.
I can use this at the time of traveling in the flight. Yes.
My lord, only one paragraphs, my lord.
Almost
Yes.
Justice Chandrachud's all judgment Lordship will find is much bigger. Then let me judge.
Lordship may kindly straightway comes to the last page of the. My lord, second paragraph, the above provisions are repugnant.
Yes.
The above, my lord, the above.
Provision repugnant corresponding so and so, so and so.
Provisions, my lord, refer to the provisions of the West Bengal Housing Industries Regulation
Correct.
are repugnant to the corresponding provisions which are contained in RERA, that is the Central Act. These provisions of the West Bengal Act 1993 impliedly stand repeal upon the enactment of RERA in 2016 in accordance with Section 88 and 89 read with Article 254(1) of the Constitution. Hence, we clarify with abundant caution that our striking down of the provisions of West Bengal RERA in the present judgment will not in any manner revive West Bengal Act 1993, which was repealed upon enactment of West Bengal RERA, since West Bengal Act 1993 is itself repugnant to RERA and would stand impliedly repealed. For the above reasons, we have come to the conclusion that West Bengal RERA is repugnant to RERA and is hence unconstitutional.
Yes.
We also hold and declare that as a consequence of the declaration by this court of the invalidity of the provisions of West Bengal RERA, there shall be no revival of the provisions of West Bengal Act 1993, since it would stand impliedly repealed upon the enactment of RERA. Since its enforcement in the state of West Bengal, the West Bengal RERA would have been applied to building projects and implemented by the authorities constituted under the law in the state in order to avoid uncertainty and disruption in respect of actions taken in the past, recourse to the jurisdiction of this court under Article 142 is necessary. Hence, in exercise of the jurisdiction under Article 142, we direct that striking down of West Bengal RERA will not affect registrations, sanctions, and permissions. Proceedings were not saved. Previously granted under the legislation prior to the date of this judgment. So, my lord, this is basically my fundamental challenge that, my lord, since the Act itself was, my lord, struck down and it was found by the Honorable Supreme Court that, my lord, striking down of 2017 Act, my lord, will, my lord, the West
in the so-called notice you have taken that plea.
No,
Why?
my lord, I did not, my lord.
And second thing, first thing, okay, it is repealed. The first thing, you have not taken the plea before this court when this court has passed an order.
Correct.
And both the parties not brought to the notice of this court. And second thing, before the authorities are not stated that you are not competent. Correct. Third is, once this proceeding is initiated prior to the quashing of the repealing of the act, what would be the effect?
That is only point.
My lord, your lordship was pleased to, my lord, set aside the proceedings, the order passed.
Remanded.
Yes.
Not set aside only. That because when the proceeding was initiated.
My lord, the proceedings were initiated in 2007.
2007.
Yes.
Before the authority.
Yes.
And it is continuing, coming, going, with this
Yes.
filing the repetition, remanding back. First 2006 it was remanded, then 2022 it was remanded. Now this is the third order. So once the matter is pending before the authority, in the meantime, it has been repealed. It has been repealed. So what would be the effect? pending proceedings?
My lord, pending proceedings, my lord, my first humble submission is that pending proceedings, my lord, were consciously not saved by the Honorable Supreme Court.
No, that's why. See, it is not done. Whatever the proceeding initiated, the court has Supreme Court has not taken the proceedings. So all the proceedings gone. It cannot be. There are two ways. Either the authority will dispose of the proceedings, or under the RERA, it has to be transferred to the RERA. These are the two ways. Correct. These are two ways. Once because admittedly the proceeding, it is not from order of this court or to after the repealing of the order, the act, the proceeding has been initiated. That is, it is pending before the authority since beginning. So you have to satisfy whether the pending proceeding with its continuation can be treated as a repealed and the has no authority, or if it is yes, it is authority have passed without any authority after the order passed by the Supreme Court. Whether the if you are raising this question, why you have not raised the question for sending the matter to RERA? You are also silent over there.
My lord, before the authority.
Ah.
My lord, before
Because
the
your
authority-
SOCAS was noticed, SOCAS was issued. Okay, you by mistake on whatever it is, both the party. It is not the case that one party has suppressed the fact, other party has placed the matter, court has not gone. That is not. That is also before the authority. It is not that one party has stated and other party has taken, but the authority not consider. Both the party has not brought to the notice of the authority or before this court with regard to the order passed by the Honorable Supreme Court.
Fair, my lord, unfortunately, it was not brought to
Okay,
your lordship.
okay. That's why I am not blaming all of the court is not blaming to any of the party. Now that is the two things. Either the old proceedings which is continuing with the authority that has to be continued, or it has to be, if it is said that no, it repealed, the authority has seized this jurisdiction, then it has to be sent to the RERA. So on these 2 points, you satisfied where it is to be. This is the Mr. Dutt.
Absolutely, that since the act was repealed, my lord, the authority did not have any jurisdiction. My lord,
Now that's what I'm telling. Keep it in mind. The 2021, it was repealed by the order of the Honorable Supreme Court, and the proceeding initiated 2006, 2007. So what would be effect pending proceeding?
My lord, which was entrusted with the duty, my lord, to adjudicate the dispute, derived its jurisdiction from the statute which stood repealed due to the order of the Honorable Supreme Court. Now, my lord, conferment of, as my lord, we have learned from your lordships that conferment of jurisdiction, my lord, is necessarily and mandatorily a legislative action.
Correct.
It cannot be, my lord, conferred either by consent of parties or, my lord, with the best of respect by orders of court.
Correct.
And my lord, to respond to your lordship's query, my lord, pertaining to not having raised this point before the authority, my lord, admittedly it was not raised. Now, my lord, my only answer is that this is a question of jurisdiction pertaining to the subject matter, which, my lord, in my humble submission can be raised at any stage, even at this stage.
No, that's why one it has been raised. Then the question is that if the old proceedings pending, what would be effect? What would be effect?
If fair, it should have been, my lord, remanded to the RERA. It should have been sent transferred to the authority, my lord, constituted under the Central Act. I am being, my lord, candid to your lordship. My instruction is, my lord, since the matter is pending for a, my lord, substantial period of time, in the event, my lord, your lordship finds that it is necessary to transfer the pending proceeding to, my lord, authority constituted under the RERA, lordship may also direct the authority, my lord, engage or appoint a surveyor, my lord, to bring a conclusion to this dispute. Because this is a proceeding which is pending for a substantial period of time, and this is strenuous for both the parties to some extent. My lord, only apart from this judgment, my lord, so far as, my lord, the issue of conferment of jurisdiction is concerned, my lord, it is my duty, my lord, since I have got it, to show it to the lordship, my lord.
Yes.
And 2012 and 2012 4 SCC 307
2012 4 SCC
307.
307.
Only one paragraph, my lord. May I read it? And my lord,
Para.
paragraph, my lord, 22.
Yes.
Page 207. That there can be no dispute regarding the settled legal proposition that conferment of jurisdiction is a legislative function and it can neither be conferred with the consent of the parties nor by a superior court. And if the court passes order or decree having no jurisdiction over the matter, it would amount to a nullity as the matter goes to the root of the cause. Such an issue can be raised at any belated stage of the proceedings.
Admitted. Settled position. Not dispute on that. What about the pending proceedings?
Nothing. My lord,
If a proceeding is pending before one authority, in the meantime the act has been amended or repealed, what would be the effect of the pending proceeding before the authority?
my lord, in this
That
case,
that
my lord,
that proposition is correct. One person has filed without jurisdiction of the court has taken and you've given the consent, that is different. The question is now the pending proceedings, the act has been amended or repealed. What would be the effect of the pending proceeding before the authority?
my lord, right to sue, my lord, subject to correction made by your lordship and my learned senior friend, my lord, right to sue, my lord, does not stand diminished.
Huh?
Does not stand diminished.
Correct.
My lord, I have been candid to your lordship that it ought to have been transferred to the authority.
Okay, I will take care of it. I will take care of submission. I will hear Mr. Datto.
The principal grounds of challenge in the writ petition is, my lord, the act has been declared repugnant. That is ground number 1, 2, 3, and 4. That is the principle. As it has fallen from your lordship that the principal point which requires to be consideration what would happen to the pending proceedings in case of repugnancy declared by the court or by the parliament. Now here the court has declared that HIDA has been declared repugnant to the Central Act, and the court has also made some provision with regard to the registration and two other things. I am coming to that. Now, my lord, before I take your lordship to that, my lord, kindly consider the provisions contained in the General Clauses Act.
General Clauses Act?
Yes. But I have got a book. Effect of repeal.
That's why I asked. You are for the private respondent.
I am for the private respondent. Where this act or any central act or regulation made after the commencement of this act repeals any enactment hitherto made or hereafter to be made, then unless a different intention appears, the repeal shall not, my lord, kindly come to see, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed. So that will remain this kind. So therefore, if a parliament or the court, my lord, declares an act is repealed or repugnant to any other act, but the court has to specifically declare that yes, that the pending proceedings or any other things will not proceed further. But unless that is done, the whatever obligation, whatever the right has been accrued in favor of the party, that remains.
Yes.
That cannot be touched by that. And the Supreme Court has also not touched that. Supreme Court, on the contrary, my lord, if you see the last
As like the Companies Act, transferred to all.
absolutely. So therefore, it cannot be affected. My lord, there is one judgment before I take your lordship to the Supreme Court judgment. A judgment of the Supreme Court, my lord, reported in 2008, volume 12, Supreme Court cases 112.
Government of Higher Education.
Yes.
Yes.
Page 112, paragraph 14 and 16. Boi dao, lordship ke. Paragraph 16, my lord, kindly state it. It is now well settled that a change in the substantive law as opposed to adjective law would not affect the pending litigation unless the legislature has enacted otherwise, either expressly or by necessary implication. That is the answer, my lord.
Correct.
That is the answer. So therefore, the principal challenge in this writ petition is that in view of the order passed by the Supreme Court, so my lord, entire right of the private respondent, whatever is there, is gone. And second thing, my lord, in terms of the order of the High Court, the entire proceedings has come to a conclusive there before the authority, whereby after the joint measurement and all other things, the authority has directed the compensation to be made. And today my learned friend has sought to make an afterthought submissions with regard to the pending payment. What I have stated in my affidavit in opposition. My lord, kindly take my affidavit in opposition, paragraph 8. My lord, I am not troubling your lordship by placing the entire paragraph. But the last 3 lines of my paragraph 8 of my affidavit in opposition.
Yes, paragraph 8.
Paragraph 8. I say that there was no proceedings as against the respondents for non-payment of the consideration alleged in the paragraph under reference. And afterthought defense sought to have been made that money is pending from him, so not a single demand, no single proceedings, nothing of the sort. The last 3 lines, lordship, kindly see.
Yes.
And my lord, for your lordship's convenience, in my affidavit in opposition, I have also, my lord, set out the list of dates. Page 5.
Yes.
The page 5, my lord, I have set out entire list of dates, my lord, from the date of initiation of the proceedings under section 6 of the 93 Act till the end. So lordship will get the entire fact from there. And in any event, my lord, that is not under challenge today. The only point of challenge is with regard to the act or the order of the Supreme Court. And this authority I have cited before, it made the position clear. And those are my submissions.
Thank you. Yes, yes, I taken note.
Section 6 of the General Process Act, my lord, has been referred to by my learned senior friend. Lordship kindly allow me to place it for my satisfaction. One second.
Yes.
The effect of repeal where this act or any central act or regulation made under the commencement of this act repeal any enactment either to made or hereafter to be made, then unless a different intention appears, the repeal shall not clause C affect any right, privilege, obligations, disability or liability acquired, accrued, incurred under the enactment so repeal. E affect any investigation, legal proceeding, remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture or punishment as aforesaid. My lord, this in my humble submission, my lord, perceives a situation when, my lord, a central act is promulgated subsequent to an existing state legislation. The situation does not speak of, my lord, the situation conceived of in section 6 of the act, my lord, does not refer to a judicial pronouncement.
Oh my God. That is the law also.
My lord,
Law
as
also
I
made by
have
the
already
parliament as also by
intimated
the
to your
court.
lordship that there is, my lord, a clear distinction between, my lord, the powers exercised by the judiciary and the legislation, and act of conferment of jurisdiction, my lord, is a legislative action and not, my lord, an act which is to be undertaken by the judiciary.
Yes.
Malad, with the bola hai gaya? Malad, on
Yes.
behalf of state, Malad, may I, Malad, make some submission, Malad, after?
Yes. Sure.
May I start?
State has the right to.
State is one of the parties.
বইটা দাও। এই বইটা দাও। না না আমার ওখান থেকে কোনো বই লাগবে না। না না এখান থেকে সুবিধা হবে।
Yes.
My lord, just, my lord, may I draw your lordship's, my lord, kind attention to, my lord, some paragraphs in the read petition. Because, my lord, may I tell one thing? I think, my lord, the bone of contention in this matter is that, my lord, actually, my lord, what, my lord, under Article 142, because the judgment delivered under Article 141. But the exception carved out, it has been stated under Article 142. Now, my lord, the true sense of meaning and, my lord, the scope of this, my lord, the exception, to what extent exception, my lord, that would, my lord, appear from the, to some extent, from the facts. The actual, my lord, the intention of the Honorable Supreme Court, while, my lord, carving out that exception under Article 142, because, my lord, knows that to render the real justice to the parties concerned and to the, my lord, my lord, to the entire world with regard to that 142. To render the final justice. Now, the judgment delivered by striking down the two statutes. Now, my lord, the first statute of 1993.
Yes.
Now, 1993, after having been repealed.
Yes.
By way of 2017 Act. Now, my lord, the Supreme Court thought that 2017 Act, if it is, my lord, the striking out, then 1993 may
Yes.
survive. So, no, both. But the one situation that was hovering in the mind of the, my lord, the judges was that what would happen since 1993 till, my lord, when the judgment was delivered, the steps taken under the 1993 Act and the subsequent Act may be or may not be, but under 1993 Act, what would happen? Some right that percolates, some rights already exercised, the rights percolate may go. No question under the new Act, the same right. But the rights which have already accrued and exercised
Or continue.
and yes, fructified to some extent, then what would happen?
And concluded.
Then what would happen? That simple striking down. So that is why, my lord, I think, my lord, exception.
Okay.
Now the question is, so far the present matter before your lordship is concerned, the present issue, how, my lord, it can be said that the flat owners or the private parties or who were the litigants before the authority concerned under 1993 Act, they are saved. Now, my lord, to come to the conclusion that how and to what extent they are saved because of that exception carved out, my lord, I think, my lord, the facts enumerated in the writ petition, at least, my lord, that will, my lord, bail out us. Now, lordship, kindly 2 or 3 paragraphs and the, my lord, 1993 statute, some, my lord, this section, I think that will, my lord, that will, my lord, the help us.
Okay.
Now, lordship, kindly come to, my lord, the paragraph 1 in the writ petition.
Yes.
Paragraph 1 in the writ petition, Lordship kindly come. My Lord, the second sentence in the middle. Your petitioner number 1, that is the writ petitioner, was registered as a promoter in terms of section 3 within bracket 5 of West Bengal Building Regulation of Promotion of Construction and Transfer by Promoters Act 1993, hereinafter referred to as the said Act of 1993. Petitioner is one of the directors. May I pause here for a moment?
So he's taking the benefit of that.
Taken the benefit. So admittedly registered under 1993 Act. Then Lordship kindly come to paragraph 2. The respondent number 1 is the state government. The respondent number 2 and 3 are officials of the state government. The respondent number 2 has acted, Lordship kindly, it is their own version. The respondent number 2 has acted, that is the authority, in the capacity of the revisional authority in terms of section 6 within bracket capital A of the said Act of 1993, and has passed the orders dated 3rd July 23 and 31st July 23, which constitute the subject matter of the lease involved in the writ petition. So, the writ petitioner, authority, and admittedly the private parties who raised the, my lord, the actual, the, my lord, on whose representation the foundation of the case started from beginning, everybody acted on the basis of that.
Yes.
1993. Now, to what extent all these activities are saved?
Yes.
That has to be, my lord, that they must find out. Now, next, paragraph number 3. Also important, paragraph 3. In terms of permission granted by the authorized officer under the said Act of 1993, dated 30th June 2005, your petitioner, that is the writ petitioner, the promoter, constructed buildings containing 64 flats and 45 car parking spaces at premises number 196D2 Picnic Garden Road, Kolkata. Took advantage of the Act.
Yes.
Acted upon, my lord, on the basis of the, my lord, whatever the benefits percolates from the Act, they took advantage of the Act.
Correct.
Now, may I pause here for a moment? My lord, I know that the Act repealed by a subsequent Act, there is a saving clause normally, and my lord, we can read it with the jail clause Act. Now, suppose, my lord, it is not a repealing by a statute, subsequent statute, by a legislature. No, it is a striking down of a statute. Now, it was in the mind of the court that a similar provision, what is in General Clauses Act, or what normally we see, and it is drafted in the, my lord, the subsequent repealed Act, that is the saving clause, that should be there.
Correct.
That should be there to save whatever steps have been taken, whatever benefits have been taken by some parties, and are, my lord, the rights accrues. The right accrues under the, my lord, the repealed Act. Now, my lord notes that the accrual of right, lordship, there are also, my lord, the several judgments regarding accrual of several stages. Accrual of rights under a statute, lordship knows that there are several stages, maybe.
Correct.
May not be that final stage.
Pending or whatever.
Yes, suppose, my lord, accrual of right, my lord, in a middle stage. To reach the finality, the stage is also something there. Then, my lord, accrual of right up to that stage is safe. And normally it is done, my lord, in case of procedural law. Normally, procedural law. Now, this is, my lord, not that procedural law. Lordship, kindly consider one thing. If that is so, and when the stage is also completed, to, my lord, to get benefit of my accrual right, my right accrued under the 1993 Act, not only accrued, but all the benefits arising out of that, my lord, fructified to the, my lord, the judgment and the final order passed, which is before your lordship, challenge only on that ground that because of the Supreme Court order, the, my lord, authority have had no jurisdiction.
Correct.
Now the question is to what extent save? Because of that, my lord, it is not saving clause, but the, my lord, the exception carved out therein, my lord, akin to that saving clause.
Okay.
Now, my lord, kindly come to now the right accrued, one thing, and the accrual right, my lord, finally
Culminated
to the order itself and the reach final stage.
culminated into a decision.
Suppose, my lord, right accrued, yes, one can say the right accrued under this act can be transferred in the other act. You will get benefit from that act which comes later, or the act which is saved by the Supreme Court because of recognition in the state act. So suggestion may be given that for the same purpose, one can avail the benefit of the other act.
Correct.
Now the question is that when there is a finality, what I say that the right accrued not stage wise. Here, the right accrued up to last stage, the finish the entire thing, but not concluded and reach finality. Then why again the same person would say, then yes, to avail your right under the new act, you have to avail the benefit in this way. Another avenue is open.
Yes.
That cannot be taken.
Now,
Yes.
যাচ্ছি.
Next.
Yes. Now, my lord, kindly come to, my lord, that Promoter Act, Section 2G. দিয়েছো জজ সাহেবকে একটু? Promoter Act দিয়েছো?
ওই প্রমোটার ওই 93 Act
93 Act. হ্যাঁ, 93 Act. 93 Act. Because everything, my lord, that was done under the 93 Act. Now, my lord, Section 2G is the, my lord, the definition.
Yes.
My lord, where it is said, any building or structures or part thereof. 2G. That is all industrial building and, my lord, that require, my lord, the permission under the act. And they admitted that under the act, permission was, my lord, the permission required, and they, my lord, the obtained the permission.
Yes.
Then, lordship, kindly come to Section 3 within bracket 1. Section 3 within bracket 1.
Yes.
My lord, kindly come. Subsection 1. Every promoter
Yes.
Who constructs or intends to construct in any area in which the act comes into force a building for the purpose of transfer of such buildings by sale, gift, or otherwise, shall at least 90 days before the commencement of the construction of such building in such area make an application to such officer of the state government, hereinafter referred to as the authorized officer, as the state government may appoint, for registration of his name and for permission for construction of such building.
Yes.
So
Permission by the
unless
authority.
this, my lord,
This is not granted.
Yes.
Then
First of all, the petitioner before your lordship
so they have
had
already,
applied for that,
correct. They have
then
admitted they have
obtained,
got. Yes.
admitted on the basis of this.
Correct.
And my lord, kindly come to section 4 within bracket 1.
Yes.
Section 4 caption is period of validity of certificate of registration and cancellation thereof. Then subsection 1. The certificate of registration granted to a promoter under section 3 shall, subject to the provision of subsection 2 of this section, remain valid for a period of 10 years from the date of issue of such certificate. Why I am drawing your lordship's kind attention to
3
this
years.
provision? Then,
For a
my
period
lord,
of 3 years.
and yes, yes, subsequently. Now, why I, my lord, draw your lordship's kind attention to this provision is this, that on the basis of this act of 1993 Act, my lord, the writ petitioner acted upon on the basis, and the language, now I am coming to your lordship, my lord, kind of the judgment. Only one paragraph, I think, sufficient or suffice, my lord, to come to a conclusion that the private respondents, they accept. Now, lordship, kindly come to, my lord, the paragraph number.
Same citation.
My lord, that is the judgment of Forum for People's Lordship. That is the, my lord, the Supreme Court 2021 8 SCC.
Yes. Paragraph.
Paragraph, my lord, the 183, my lord, the last part. Paragraph 183, last part.
Yes.
Just, my lord, before 184 starts.
Correct.
It starts the above provisions. The above provisions are repugnant to the corresponding provisions which are contained in RIDA Central. These provisions of the West Bengal Act 1993 impliedly stand repealed upon the enactment of RIDA in 2016 in accordance with section 88 and 89, read with Article 254(1) of the Constitution. Very good. Hence, we clarify with abundant caution. This is the vital. Hence, we clarify with abundant caution that our striking down of the provisions of West Bengal HIRA in the present judgment will not in any manner revive West Bengal Act 93, which was repealed upon the enactment of West Bengal HIRA, since West Bengal Act 93 is itself repugnant to HIRA and would stand impliedly repealed. Very good. Then 184. For the above reasons, we have come to the conclusion that West Bengal Act is repugnant to RIDA and is hence unconstitutional. We also hold and declare that as a consequence of declaration of this court of the invalidity of the provision of that West Bengal Act, there shall be no revival of the provisions of 93 Act and it will stand impliedly repealed. Very good. Then, my lord, they come next. Since, very important, lordship, the language used and the words choose, my lord, by the Honorable Supreme Court judges, very important. Since its enforcement in the state of West Bengal, the WBHIRA would have been applied to building projects and implemented by the authorities constituted under the law in the state. First of all, this sentence should be read, my lord, that is, my lord, independently.
Correct.
This sentence should be read independently.
Because the enforcement of the state West Bengal HIRA
would have been applied to building projects and implemented by the authorities constituted under the law in the state.
Correct.
And it has happened in the present case. Then, in order to avoid uncertainty
and disruption,
the further clarification,
and disruption,
in order to avoid uncertainty and disruption in respect of actions taken in the past. May I pause here a moment? Suppose, my lord, the next clarification, there is nothing. Then this is suffice to say everything. In order to avoid uncertainty and disruption in respect of actions taken in the past, recourse to the jurisdiction of this court under Article 142 is necessary.
justice, Lordship knows, under Article 140, to render the complete justice.
Correct.
Hence, in exercise of the jurisdiction under Article 142, we direct that the striking down of West Bengal Hira will not affect the registration, sanction, and permission previously granted under the legislation prior to the date of this judgment. Three words used here, very cautiously used. Lordship, kindly see.
Registration,
In a,
sanction,
yes,
permission.
registration. Yes, they took registration, they admitted,
Correct.
registered. When it is registered and they took registration, all subsequent activities on the basis of the registration, that should be saved.
Correct.
Because of this carve-out exception.
It is not necessary. Again, they have to go to the RERA. And
Yes, not necessary. Because when this particular word use registration, if the registration saved, let's kindly consider, if the purpose, the registration saved, then all purpose for registration, that should be saved. That is a all consequential act on the basis of registration.
Yes.
Then there is, my lord, that the structure comes because of certificate.
Yes.
Then, my lord, the sale of flat. Then sale of flat means, my lord, the consequential that the agreement.
After this.
All are saved. Registration saved means everything what have been or what has been done on the basis of registration, all saved, including, my lord, the judicial decisions on the basis of the agreement, because the foundation is registration. Let's kindly consider. Then further, sanction. My lord, sanction, lordship, this word has, my lord, wide meaning, wide scope. Sanction, that is permission. Lordship, kindly consider. Sanction means that sanction, if not punishment, other word meaning, but sanction means sanction. Yes, you go ahead on the basis of 1993 Act. Sanction means that, my lord, the time to time, the court passes the order. My lord, Lordship, kindly consider one thing. The first order by the authority concerned. Then, my lord, the flat owner, they came up, and, my lord, the court again remanded. Then, my lord, what happened? Again order. Then again remanded. Then two, my lord, revision petition from both sides. Then two revisions petition. So then order passed. So then read petition.
So that continues.
So with one after another. My lord, this is also, my lord, the word sanction means is permission. Sanction means also permission.
Yes.
If the word sanction does not mean that sanction means under the, my lord, the criminal law, that is the sanction, then in civil, that is sanction means permission. So each stage is permission granted to go ahead under 1993 Act. How can it be, my lord, the abolished in one go? Lordship, kindly consider. And that is why all are saved. And then
permission.
Another word, permission. Permission, not for permission for, my lord, the for my lord, the permission to construct the structure.
Whatever.
Permission mean permission in every stage.
Yes.
Permission means permission under the Act. You have agreed to sell out the flats.
Yes.
You entered into agreement with the buyers. Now, under the 1993 Act, there is a provision with regard to any, my lord, the non-compliance of any terms of the agreement between the parties to that, and that was followed. Then permission granted by the court, one after another proceeding. So at every stage, so these three words, my lord, the registration, sanction, permissions previously granted under the legislation prior to the date of this judgment, saved everything. Saved everything.
Correct.
So, my lord, my humble submission is this, that, my lord, so far, my lord, these proceedings are concerned. These proceedings are concerned. My lord, these proceedings are saved because of this, my lord, the final, my lord, verdict, my lord, that is, my lord, carve out under Article 142. The judgment delivered under Article 141. But the justice finally rendered under Article 142.
Correct.
And, my lord, I think, my lord, the entire proceedings, whatever, my lord, the done so far, this all are saved. Again, that is all.
Won't take, my lord, more than- Lordship, may once again, my lord, take the trouble to, my lord, look into, my lord, the second paragraph of the, my lord, judgment that has been handed over to your lordship. Fourth line onwards, my lord, from the top, my lord, hence we clarify, it starts with the expression. Hence we clarify with abundant caution that our striking down of the provisions of West Bengal era in the present judgment will not in any manner revive West Bengal Act 1993, which was repealed upon the enactment of West Bengal era since West Bengal Act 1993 is itself repugnant to RERA.
Correct.
So this judgment, in my humble submission, my lord, is, my lord, a declaration of repugnancy. But 1993 Act actually, my lord, became repugnant to the 2016 Act the moment 2016 Act was promulgated by the Parliament and notified by operation of, my lord,
Yes, there is no
Article
doubt.
54(1) and by
Correct. That is not dispute. Only now they have raised the contention. There is no dispute. They are not telling that the RERA is continuing. RERA has been repealed after this Act of 93 is repealed by way of when this RERA has come into force. But they have interpreted this paragraph 85, the last 4 lines. Last 4 lines they have interpreted.
consciously three, my lord, situation, three.
Because
sanction and permission.
what you have made a submission, 3 has been given: registration, sanction, and permission. So your contention, what the contention you raise, you have in the judgment, it is not mentioned with regard to the proceedings pending before any authority. So if the proceeding is not, the court was very aware. The proceedings, it is not taken into consideration, only these 3 as per your submission.
And, my lord, after 2021, after this judgment, my lord, the authority
Ceased to be, yes,
ceased.
ceased to be exist.
May I leave, lordship?
Thank you. Thank you. Thank you.
May that book remain with your lordship. I will take it back.
Okay. Okay. Hearing concluded, CAV.
My lord, my
Fix up the matter at fixed at 12 p.m. my lord.
Yes.
my lord,
Fix up the matter at fixed at 12 p.m. my lord. My lord, remember the Chinese school matter. 14th February is the Chinese New Year. My matter will be infructuous. 69. I am saying that tomorrow can it be taken up at 2 p.m.
Item number
69.
This is not the time to listen. Yes.
Under extreme urgency, my lord, I am doing. I mean, I am very unwell. I have come only to mention before your lordship. Try this pestering me like anything. I do not naturally do this. Matter.
Which matter?
69. Chinese school.
Who is for the other side?
I have taken the consent.
Nobody will come.
State government has given the consent.
69. 69 kal na within 5 minutes kar dena.
my lord, in the morning, my lord, 4:33, my lord, my learned
Yes, call the
friend mentioned the matter, my lord.
I have changed. Library's book, I will have.
Give the copy.
I will.
Give the copy.
Item 11.
Call the list. Call the list.
Item 11.
Yes.
Item 11, my lord, say before lordship, my lord.
The other side. On the last occasion, my learned friend for the other side raised the question of maintainability of the writ application on the grounds of delay. I have duly argued and submitted a bunch of judgment with copy of the same to my learned friends or reference of the judgment. I have handed over that bundle of the judgment to my lord. When my lord's pleasure was to fix the matter today, Lord, I don't know whether
Led by ASG, my lord, he is unwell today, my lord. I subject to your lordship convenience, my lord. Your lordship kindly take up the matter Tuesday, Thursday, Wednesday, any day, subject to lord. And my lord, before my learned friend has not completed his argument, my lord,
I have completed
Yes,
the
completed. Yes, relying upon the judgment.
he has,
I
my
have
lord,
not completed
as
the
I remember,
argument.
my lord, he,
So far the main writ application is concerned, but so far the maintainability of the concern, I have completed my argument. It has also been recorded.
he is supposed to hand over the, my lord, supposed to hand over the set of judgment, my lord, reference, that has been given to me, my lord. Your lordship kindly, subject to your lordship kind sanction, my lord, your lordship kindly.
On that very day I have given to my lord and also my land.
Counsel for the Union of India press for time. According to Sir John, let the matter appear on 12th February under the heading.
Can it be instead of 12 any date earlier or thereafter? I got some other.
Then 16th February? 16th February. No, 17th February. 17th February as item number 2.
May another matter be fixed in
Then
apex court. It can be 16, 11, 13, I don't know.
no, 16. Why I am not fixing 16? Your bar will take the time of 1 hour for the mentioning. Then
I will not. 12. 12 আমার অসুবিধা আছে।
huh?
16.
16. Okay. 16 within as item number 2 in the urgent motion.
Or time may be 16.
Time. That's why I am not item number 2 in the urgent motion. Then it.
As your lordship.
Yes. Next. Call the matter.
My lord, 13, my lord, I am for the petitioner, my lord. It was that reservation regarding that 100-point roster of person with disabilities matter, my lord. On the last occasion, the learned advocate general submitted that they will publish.
Yes, ma'am. The notification has been published.
কি করেছিস রে?
But I'm handing over, my lord, a copy to my learned friend and one to the court.
ঠিক আছে?
No, sir.
ঠিক নেই?
That they have reserved 4% overall, not 1% each. Then it is violation of the act.
ও
Unreserved PWBD. 12th vacancy.
My lord, the
Blind
law requires that, my lord, 4%, my lord, there must be vertical reservation. I'm sorry, horizontal reservation. Now, please have a look to, my lord, the new one, 12 vacancy, new roster that I've handed up today. 12 vacancies unreserved WBD. Then, my lord, 42nd vacancy.
BD.
That is
blind-
persons.
Blind.
Yes.
Blind disability. Then
No, this is not blind. This is generic.
BD. What is the BD?
Persons with blindness, benchmark disability.
Benchmark
Disability. That is 12th vacancy, then 42nd vacancy, then 72nd vacancy.
Then 30.
These are and the 90th.
Then 32nd.
Then the 72nd, 72.
72. After 12. After 12.
12, 32. No, sorry, 12, 40, 72. These three are, my lord, unreserved.
Yes.
And the fourth one is 90th. 90th, your lordship finds schedule caste, PWBD.
And here, schedule caste PW.
So 3 plus 1, 4. Now please take, my lord, the note below that. Please come to, my lord, paragraph 12, my lord, after the roster.
Paragraph?
Paragraph 2.
Yes.
The governor is pleased to also pleased to direct that the reservation of persons with disability as per section 34 shall be implemented as follows. A. 4 roster points reserved for PWBDs in the Model 100 roster will be generic in nature and hence not earmarked disability category wise. Disability category wise allocation will be determined only at the stage of recruitment based on actual appointments and maintenance of a disability certificate category wise register in every government establishment. Detailed guidelines regarding the implementation of the reservation of persons with benchmark disabilities for the services and posts under the government of West Bengal in the model 100-point roster of vacancies and maintenance of a disability category wise register in every government employment establishment will be published by the department of so and so in due course of time after issuance of this notification. Therefore, Miller, as I was submitting on the last occasion, that horizontal has to cut across vertical. It cannot be other way, right? Number one. Number two, Millard, your lordship may now come to, Millard, the writ petition which my learned friend has filed. First, Millard, your lordship may kindly take, Millard, the prayer at page 19. Then, Millard, I'll take your lordship through pleading in one paragraph. Prayer B is
Yes.
issue a writ in the nature of mandamus commanding the respondent so and so to quash the notification dated 8/7/2019 and correspondingly the notification dated 13th June to the extent it provides for, this is important, to the extent it provides for reservation of persons with locomotor disabilities only within the scheduled caste category at the 32nd at the 32nd point of
Model
100-point roster. So this is the grievance. Now kindly take my paragraph 23 of my learned friend's petition at page 13. 1-3.
13.
1-3. Page 1-3, para 23.
Yes.
Your petitioners further state that since the 32nd point in the 100-point roster is reserved for scheduled caste, locomotor disability including cerebral palsy, leprosy cured, dwarfism, acid attack victims and muscular dystrophy, the petitioners, although being under the purview of locomotor disability and not belonging to the scheduled caste category, are not being able to participate in any recruitment process under the government of West Bengal under the locomotor disability reservation. It is stated that such reservation of SC locomotor so and so is preventing the petitioners for availing the benefit of PH reservation, that is locomotor such and such, in any recruitment process conducted by the government of West Bengal or its agencies so and so. But now that grievance has gone because 32nd vacancy. Now, if you have lordship may kindly comes back once more.
So it is open to the all.
Everyone. Now the establishment wise, Millard, they are going to Millard reserve it.
Yes.
Kindly comes back to the new one where 32nd vacancy has now become for scheduled caste. Yeah. Therefore, locomotor disabled benchmark or other benchmarks, they will get their turn.
32nd schedule caste is normal one.
Now it's open for all scheduled caste. Yes.
And with regard to the reservation is the 12th, 42nd, 72 and 90.
90.
Out of 4, 3
Yes.
have given
Yes.
the free to the general category unreserved, and for the 19 it will go to the scheduled caste.
Therefore, so far as the present cause of action is concerned, that the 32nd vacancy being reserved for locomotor disabled scheduled caste, where that grievance cannot survive anymore. These are my submissions.
Okay. Yes.
So sir, may I, sir, or
বলো you আগো
My lord, with deepest of respect, my lord, kindly, your lordship, kindly come to the act for section 30. At page, my lord, 101.
104
Of the writ petition. Page
31, yes, 101.
Section 34, my lord, may I? Every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies, cadre strength in each group of posts meant to be filled percent with benchmark visibility, of which, my lord, it is important, 1% each shall be reserved for percent with benchmark visibilities under clause A, B, and C, and 1% for percent with benchmark visibilities under clause B and mainly blindness and low vision A. B is deaf and hard of hearing. C is locomotor disability, including cerebral palsy, so. D is autism, identity. Multiple disabilities.
Correct.
So, my lord, what the section 34 says that there are 5 kinds of disabilities. For A, there has to be 1% reservation, B 1%, C 1%, D and E 1%. So, my lord, in the previous roster, what the authorities did, my lord, they reserved 1% each for this. But for locomotor disability,
they come to the scheduled caste.
They come to that was information. Now, my lord, in the new what they have done, they have not given 1% each to everybody. So, my lord, this is in complete violation of section 34, which is not permissible.
No. Why I am saying subject to this first 12th vacancy will come, it will go to the unreserved. It will go to the unreserved.
Unreserved, my lord.
Just unreserved. Unreserved, then the authority then has to act in accordance with the section 34. He has to consider 1% to the low vision, deaf, and this cannot be given here in the notification that at the time of considering of the case, at the time of recruitment, then the authority has to see whether the 1% is to be provided to which
category.
That cannot be here because the total percent has been given to you. Total percent is given to the unreserved category. In the unreserved category, if suppose it is a 400 post, correct? So 400 post, 4%. So how it will come? 10. 10. So if 10 will come, so 10 will come, it has to be decided, and the authority will decide it in terms of the section 34. 1%, 1%, 1%, 1%. 1% will be taken into consideration with regard to the merit. If the blindness 4% are there, who is having the meritorious, he will get that. Then you will come to the deaf and hearing, then he will get suppose 5%, who will get the highest merit, he will get that percent. Then come to the autism and multiple disability, then you take the who is having the meritorious, then he will get that.
May I most humbly reply what is following?
Yes.
Let us say, there are 10 posts reserved for
PWD.
Total 4% is 10.
Correct.
Out of those 10%, let us take a case, where 20% are applied for PWD.
Correct.
This 20% includes clause A, clause B, clause C, clause D.
Correct.
Now, there can be two situations. According to the merit, first 10% will get the job. This can be one. Another thing, what can be done, my lord? From those 20%, out of those 10%, A category will get 1%, B category will get 1%. But, my lord, in that event, that is
not possible with deepest of respect. Why? What is there in this notification that is not possible? Why? Suppose my lord, 12th vacancy is for PWD generic.
Correct.
All PWD unreserved will apply.
Correct.
Now, my lord, now after everybody applies, so if there is suppose 10 posts and 1% of 10, let us say 1. Let us take as 1 is the seat for PWD low vision. Then how much seat will be there for locomotive or for deaf and hard
That's
of
why
hearing? There cannot be any.
no, because the percentage is already decided in this act. Correct. So authority cannot override the act.
Alright, yeah.
Correct. So percentage is already there. And the authorities have already given the unreserved vacancy for the PWD. That's what I'm telling, if please understand, if the 10 persons are there, and today, if suppose the all have been taken into consideration, the first is the blindness and the low vision, and second is the deaf and hard. So 1% each shall be reserved for the person benchmark A, B, and C. So 1, 3%. So 1 will come to A, B, C. That is the blindness, deaf, and locomotor. So if 10%, 10 persons are there. Out of 10%, 2 are blindness, 1 is deaf, and 3 is deaf, and locomotor is 5. 10 has come. So if the 10%, so out of this 5% or 4% of the blindness, so it will be taken on merit. 1% will be given, one seat is to be given to the blindness. 1%.
Yes.
Correct. Then now come to the deaf. They will take the merit of the deaf and dumb. If it is 6%, 6% deaf and dumb, then it will be a merit on deaf and dumb. 1% will be given. Third, locomotor. Locomotor also, if suppose it is a 4%, who is the meritorious, it will be given to them. So where is the difficulty?
Yes, ma'am. In a recruitment notification, in every recruitment notification, the vacancies are maintained, my lord, by virtue of this 100-point roster.
Correct.
Now, my lord, a recruitment process, advertisement, my lord, when the recruiting authority will publish an advertisement, they will go by this 100-point roster. They will say, suppose 30 seats are reserved for PW, only PW.
Correct.
30 seats are PW.
Correct.
All PWDs will have.
Correct.
So, my lord, thereafter the bifurcation, that is not permissible if it is not mentioned specifically that out of those 30 seats, 1% will go to that.
That already in the act. Already in the act. Kindly see.
That is the procedure, but the 100-point rosters are being maintained, my lord, for maintaining, calculating the vacancies and maintaining vacancies. My lord, the act is the mandate for which by this act, this 100-point roster has to be prepared.
Correct.
And any recruitment authority will go by this, not by section 34.
Why? Why not?
Yes,
How
ma'am.
the percentage will be taken into
Yes, my lord, with deepest of respect, that is what has happened, subject to correction. My lord, if that be the case, that would have been the case, we ought not to have approached this honorable court. My lord, section 34 says 1% each for everybody. Now, in all these recruitments, I can come up with all the advertisement. In violation of this section 34, the authorities, before they are following the old 100-point roster without reserving 1%. They are, my lord, defense is bound by
the
this 100-point roster.
repetition which you challenged the earlier notification, your main contention was the 30-second vacancy. The 30-second vacancy because the locomotor has not been given to the general, unreserved. Now they have taken out all these things. All persons will get in all either 12th or 34th or 42nd or 91. 72 or 91.
Subject to correction is SC 1
Huh?
98 is SC, subject to
98.
Right. 98 is again SCP. Yes, man, that is our very challenge.
And the last for this honorable.
98 vacancy.
Uh-huh.
What was there in 30-second is
now being categorized
as 90.
Correct.
So, my lord, where is the
So, what is your contention with regard to the 90th?
Now, we firstly say horizontal reservation, my lord.
Horizontal reservation, as your lordship knows, cuts across vertical reservation.
Milord, may I interrupt and submit, Milord? Let us, Milord, file an affidavit Milord, after the new notification. Then it will be easier for the court, Milord, to decide.
Okay, you filed it.
Yes,
But
that
I
will
have
be
a
important.
suggestion, subject to consideration by the court and Mr. Bhattacharya. Now that a new roster has been introduced, they need to challenge it. Let them challenge it by way of a fresh writ petition.
That
Because
will
in
create
this
trouble.
writ petition, they have to file an amendment. Supplementary affidavit will not do.
No. We will try to explain the new notification. Let us see. Like Advocate General, this is not a Milord adversarial thing. It is Milord in for general public interest, which the AG will kindly
No,
consider.
definitely. I have no, yes.
No, okay, in that case, you take whatever the.
Yes, well, let us
file the
Milord
affidavit.
explain our situation by an affidavit.
7 days we can come up with this affidavit.
Malad, to add on to my learned friend, Malad, already in the ongoing selection process, the categorization that we are talking about and the learned advocate general, that has been left to the department, but it has been already categorized. HCLD has already been categorized, panel has been published. Malad, on the last occasion, we were praying for a stay of this panel since this week.
Where?
Yeah, and about the
No, that Milord cannot be done. Then it is
You are not challenged here.
Yes. Then it will be converting itself into a service matter.
Yes, it is during the pendency of this, Malad, that
So you're not challenged this. How this court can go into that?
we have said, my lord, in the petition that this entire exercise done by the state authorities is not in conformance with section 34 and the rules 27. My lord, this is absolutely staring at that way.
Milord, may I say one thing, Milord? I did not raise this objection. This is essentially a service matter. Now, if my learned friends stretch it far, I have to take that point.
Lordship, may I submit? Lordship, item number 14 is not connected. Lordship, I'm appealing for the primary report led by Mr. Sharma.
Udipto, at affidavit code.
The Advocate General has filed the notification dated 27 January 2026 after serving the copy to the learned counsel for the petitioner. Counsel for the petitioner prays for time to file affidavit in opposition. Let affidavit in opposition be filed by filed an affidavit with regard to the notification date, not affidavit in opposition. To file affidavit in connection with the notification dated 27 January 2020. Let the affidavit be filed by
10 days.
By today we are on 5th. By 16th February 2026. Reply, if any, there to be filed by 24th February 2026. List the matter on 26th of February 2020.
My lord, at a time, my lord, only a time, my lord.
Item number 14 is
Deep level.
My lord, only any time, please.
Time, then it will be difficult.
My lord, then at the top, like the previous order under the heading,
Within 3 matters.
Deep level.
Urgent. Come, I will hear. I told you. Let the complete. Let the complete. Within 3 months.
Lordship, may I submit? Lordship, may I submit? Item number 14 is it is not at all similar, Lordship. Because if item number 13
Who is for the item number?
Item number 14 is they are challenging the process, Lordship.
What process?
The recruitment process.
So I am releasing the matter if the recruitment process.
Not at the wrong time.
Give the WP 14.
It's a missing term.
Please. You 14.
That this matter has been assigned to your lordship, for your lordship. So kindly see my prayer, page 40. Lordship, this can be hard. Are bhai, আমাকে বলতে দাও আমারই petition.
Yes.
So kindly see page 40, my prayer. Number, I have challenged the 100-point roster so far relates to 32nd vacancy. Number, a recruitment process is going on for the post of primary teacher in primary school. Number, in that recruitment process, in view of this 100-point roster, vacancy has been created. That's why why I filed the leave petition, saying that, look, since I have challenged the 100% roster, and since your vacancy, since the recruitment process is going on, that has been given details of the prayer. There is no challenge to the recruitment process. I am only prayer, my interim, but I prayed.
What is the prayer? The same roster?
Yes, no.
Along with the roster, Lordship recruitment process is there.
My first prayer.
So Lordship can hear it out individually,
To the
Lordship.
effect that the model 100% roster is notified under so and so, subsequently into notification that is so and so, issued by the labor department to the extent of earmarking the point 32nd vacancy only for scheduled caste, leprosy is ultra high risk. Kindly see my second prayer. Second side and for the subsequent.
The same prayer.
Lordship, they are into the recruitment process. It can be heard individually, Lordship. I'm just praying before Lordship not to tag with them.
Let this matter appear, item number 14, appear along with WPA number 21556 of 2025 on the same day. Kya date diya tha?
No.
Next.
Lord, I beg to appear for the petitioner, my Lord. But this is my affidavit of service.
WBSSC.
Yes.
My Lord, petitioner herein are before your lordships are continued EWS candidates, my Lord.
Huh?
My Lord, they are continued EWS candidate.
Ah.
The petitioner before lordship, my Lord.
Ah.
Now, my Lord, she had participated in the selection process of second SLST for recruitment as assistant teacher.
Which post?
My Lord, assistant teacher for classes 9 and 10, my Lord,
Ah.
under EWS category.
Ah.
Now, my Lord, her application for EWS had been rejected by the concerned ADM by an impugned order on 11th of December 2025, my Lord. That particular order has been challenged herein, my
Where
Lord.
is the order?
My Lord, that order is at page 31 of the application, my Lord.
31. This time establish the petitioner belongs to
Lord.
Sadhgop community,
Yes, my Lord.
which is recognized OBC in the state list. Eligibility for EWS is an extra format is explicitly restricted to the person who do not fall under the list of SC, ST, OBC as the petition. Yes. So
No, my Lord, the thing is that, my Lord, I have participated in second
but
SLST.
I think
Dismissed.
Huh?
You have dismissed, my lord. In previous occasions, my lords have been pleased to dismiss.
No,
the
I
petition.
dismissed. No, now some notices or notification has been issued by the authorities. Yesterday, 2-3 notice have been shown.
Oh, my lord, that I don't. I am appearing for the
No, I'm not,
It is recorded that in the candidates who were having the EWS category will continue with the other for the year 23, 24 or 23, 24, 24, 25 onwards also.
That I
No,
am
that I'm
appearing.
not.
Lord,
You are appearing for whom?
I am appearing for the West Bengal Central School Service Commission, my lord. Here, my lord, in prayer 3, for prayer A and B, I have nothing to say. Whether the EWS certificate can be maintained or not, my lord, that, my lord, it is for the state to reply, my lord. So far as prayer C is concerned, my lord, it is a nature of mandamus such and such, my lord. More particularly, the West Bengal School Service Commission for.
So it's for the state.
State is, my lord, Mr.
Yes.
Bose.
What is the status?
Well, just a minute, no. My lord, may kindly take the order impugn.
Yes, I have gone through page 32, 33.
Yes. So, my lord, may I just please watch this? Lord, till
So how you can pressure the government to issue certificate once you are the OBC?
No, my Lord. And
What is the ground?
no, my Lord, may I please come to the notice?
You were earlier OBC, EWS.
I was a
Now your
continu-
category has been changed.
No, my Lord, during the pendency of this recruitment process, my Lord, my category changed in the year 2025, my Lord. I was a continued EWS candidate. I had never applied for any certificate at any relevant point of time before the authorities, my Lord.
What is your income?
But it's below the.
Where is the income certificate?
But I have the certificates of the previous preceding years, my Lord. That's annexed at page 14 and
How
15
the
of the
category is changed?
Lord, why the
Yes.
issuance of the fresh.
So the category is changed.
my lord, may I please this once? My lord will kindly take the impugned order once again.
Yes.
Lord, it says at page 31.
Yes.
Second paragraph may read from accordingly a notice for personal hearing issued with this office memo number so and so, which was duly served on the petitioner. Next to next paragraph, during the course of hearing, the petitioner submitted that she belongs to Shodgop community. And a UWS certificate has been issued to her by this authority in the financial year 24-25. She also submitted that for the financial year 25-26 online application, the UWS certificate has not been issued. Thereafter, my lord, kindly takes point number 1 thereafter. The petitioner submitted an online application for issuance of UWS certificate financial C. It was submitted, my lord, on 4/7/2025. Now, my lord, written notification which was published on 3/6/2025 issued by the Backward Classes Welfare Department, Government of West Bengal. The community Shodgop stands included in the state list of other backward classes.
Correct.
Now, my lord, once this is done, he is entitled from, my lord, getting this, my lord, certificate, which has been said in the subsequent paragraphs. The said Shodgop community, however, does not find a place in the central list of OBCs for the said state of West Bengal. 4, my lord, thereafter, with a memorandum number so and so dated 18/5/2023 of the Backward Classes Welfare Department, Government of West Bengal, it was notified that an EWS certificate in the Annexure C format may be issued only to those persons who are not covered under the scheme of reservation for SC/ST OBC, subject to fulfillment of certain other prescribed criteria. The memorandum further clarifies that if a person belongs to a community included in the state OBC list, but not in the central OBC list, he or she may be considered for issuance of an EWS certificate in Annexure D format, subject to fulfillment of certain other prescribed criteria. The historical status of the Shodgop community prior to the inclusion in the state OBC list on so and so is immaterial for the adjudication of the present application. This authority is required to consider the petitioner's eligibility strictly on the basis of her current community status. Previously, they may have been entitled.
Yes.
Now they are not because of the inclusion of Shodgop community in the list of OBCs. Now, my lord, in fact, the officer concerned, Lord, will kindly take up the last point of page 32 along with the other points at page 33. Lord, I start from page 32, point number 1 at the bottom.
Yes.
It stands established that the petitioner Srimati Nikita Mondal belongs to the Shodgop community, which is recognized as an OBC in the state list with effect from 3/6/2025, that is from last year. The eligibility for an EWS certificate in Annexure C format is explicitly restricted to the persons who do not fall under any of the reserved categories of SC/ST or OBC. As the petitioner is now a member of a state notified OBC community, she is covered under OBC reservation scheme of the state and is therefore eligible for availing an EWS certificate in Annexure C format. The petitioner may be eligible for grant of an EWS certificate in the Annexure D format, subject to fulfillment of specified criteria as prescribed, as her community is not included in the central OBC list for the state of the West Bengal. Now, my lord, the next paragraph, point number 2, my lord, this order shall not preclude the petitioner's right to submit a fresh application for a EWS certificate in Annexure D format, provided she fulfills the other prescribed eligibility criteria. Since, my lord, for the inclusion of OBCs, inclusion of Shodgop community in the state list of OBC, my lord, now it has disentitled the petitioner from getting, my lord, a EWS certificate by dint of, my lord, applying in the format of Annexure C. However, Annexure D, which relates to, my lord, since, my lord, the central, they can apply. This has also been clarified in this order.
Yes.
That has not been done by them.
My reply to that. But if your lordship kindly comes to point 4 of page 32, they have, by the dint of this memorandum dated 18th of May 2023, my lord, my application has been rejected, my lord.
Correct.
What does it say, my lord? The persons who are not covered under the scheme of reservation for SC, ST, OBC, subject to the fulfillment of certain other prescribed criteria. So, my lord, not at any material point of time I possessed any such certificate, my lord. I was never covered under the scheme of SC, ST, and OBC. Now, by the dint of the memorandum dated 3rd of June, my lord,
memorandum has come into force.
my lord, how can they preclude me, my lord, from getting the certificate now, my lord?
Where is the memorandum? Have you challenged the memorandum? You are not coming under the.
But I've challenged this. I have challenged
the
the
memorandum.
The memorandum.
Where you have been brought under the OBC category?
Yes, that I have annexed, my lord.
Where is the memorandum?
That I have annexed. Annexed,
where is the application?
Perhaps memorandum is not annexed, my lord.
So, where is the application that to the authority that you will not claim the OBC and you are not coming under the OBC?
I shall give that undertaking before this honorable
What
court.
shall you? Once you appear before the authority, first of all, you are not challenge your memorandum where you have been declared as a OBC category. That group. Correct. Second thing, you have not challenged that memorandum. Third, you have not made the representation. Yes, I am not challenge. I am not claiming the OBC, and I intend to continue the EWS.
But
Where is
in
that?
case that liberty is given, my lord, I shall make an application.
But
that I will
liberty, last occasion, the liberty was given. This court has disposed of. You had appeared before the court, and you have
But on the
admitted.
last option, it had been
You had
adjourned.
admitted before the authority that yes, I am the Sadgop community. So the Sadgop community is
But
coming under the
my lord,
purview
if I make that application, they will be rejecting it on the very same ground, my lord, on the memorandum dated 18th of March, May.
Sir, once a notification has come and you find that you have been, though earlier you are the EWS, now you have been given as a OBC, correct? You have not challenged that OBC first. Second, you have not made any representation. No, sir, I don't want the OBC category. I am satisfied with the EWS. My income is so and so, so and so. I will continue and I will not claim any benefit under the EW. That's why the authority, once you have been declared, the caste has been declared under the OBC, then tomorrow you will go to that OBC and you will get the benefit.
So let I shall give that undertaking before this honorable court only, my lord, that I will never be claiming any such benefit, my lord.
How? How at this stage? Where is the challenge of the memorandum?
Well, I've challenged the impugned order in its entirety, my lord.
Entirety, where is the memorandum challenge? We have been made as a OBC.
What is mentioned, my lord, in the impugned order, my lord? That 3rd of June, 3rd of
Where is the prayer? Show me the prayer.
My lord, prayer A.
Yes. Have you challenged the memorandum?
But not the memorandum, but this impugned order in its entirety, my lord, along with the memorandum dated 18th of May 2023, as well as the new state OBC list.
So, that memorandum is not challenged before the authority. That's what I'm telling. You have made a representation. No, you have made me as a wrongly. You have been included your name in the OBC. Have you made this representation
But
to
I
the
was,
authority?
my lord, I had verbally at the time of hearing, I had verbally told the
Verbally you
concerned.
admitted. If your word is taken into the verbally,
But
then you will not be entitled to file the writ application because you have admitted, sir. You had admitted. Kindly come to the page 31, fourth
But
paragraph.
I had only submitted that I belong to the Sadgop community. It's an admitted fact, my lord.
Sadgop community. Then Sadgop community had come under the purview of the
But I had
OBC
also
under the-
submitted that I'm an continued EWS candidate, and I will not be availing any benefit of SC, ST,
That's
or
why
OBC, my lord.
24, 25 you are the EWS. When this notification has come into force,
New
when
state
the
OBC
not-
list.
Huh?
New state OBC list, my lord.
Ah.
3rd of June 25, my lord.
25. So what would be the financier subsequently? 25, 26?
Yes, my lord.
Then? So that's why can again she also submitted the financier 25, 26 despite the submission online. So you want the 25, 26 EWS.
Yes, ma'am.
24, 25 you are having.
Yes, my lord.
So 25, 26 EWS, the authorities contention is that once you have been in the category of OBC, so you cannot get the EWS.
My lord, I do not want to avail that benefit, my lord. I have never obtained that certificate at any material point of time.
Yes, I am disposing of. If you want, if we make
But kindly
give an
liberty-
undertaking, authority will consider.
But kindly that liberty may be given that we shall file an undertaking before the authorities.
If I may say this, just my lord has seen that the authority has already told him that he can apply in Annexure D.
But I will be required Annexure C. She has participated in the second
Annexure
SLST,
C,
my lord.
not Annexure D.
Then, my lord, if he makes up the application and undertaking, then the authority may consider it in accordance with law.
That I am telling. So I am not setting aside here.
Yes.
So I will give the liberty if the petitioner will file an undertaking that he will not claim the OBC category in future and he will remain as a EWS, consider and pass appropriate order. If the authority considered in his favor to issue the EWS certificate, otherwise.
Yes, my lord. If I give that undertaking, my lord, kindly the certificate may be granted in my favor, my lord. Now, no, my lord, why I'm saying this, my lord? The document
So you
verification-
do one thing. You go to the ministry, get an order of appointment of SDO in my name. I will go and sit in that chair and I will issue the OBC.
Well, kindly
But a
give a
junior member is trying that.
but
That
kindly
is the
give an order.
applicable part. That is good enough. That is a
Sir, I am alive.
Yes, yes.
I am direct. I'm giving a liberty to make a representation to the before the SDO and assistant district. magistrate, and if application is filed, the magistrate will consider the undertaking whether you will, if he will not claim the OBC in future, whether you will be entitled to the
Yes, my lord.
OBC.
Kindly that observation may be
If you will, if you will entitled to OBC, then take appropriate step for each one.
Yes, my lord. Yes, my lord.
My lord, may I kindly take your lordship's leave?
The petitioner has challenged. The petitioner has challenged the impugn order dated 11th of December 2025, issued by the additional district magistrate within bracket development Jhargram, wherein the request of the petitioner for grant of EWS certificate in annexer dash capital C format is rejected. On the ground that the EWS certificate in Annexure C format is explicitly restricted to the persons who do not fall under any of the reserved category of SC, ST and OBC. It was further observed by the additional district magistrate that the petitioner is now a member of state notified OBC community, C is covered under the OBC reservation scheme of the state, and as such, C is not eligible to availing EWS certificate in Annexure C. However, the additional district magistrate has rejected the claim of the petitioner for issuance of the EWS certificate under Annexure C, but given the liberty, but it was also clarified that the order passed by the authority shall not preclude the petitioner's right to submit a fresh application for EWS certificate in annexer dash capital D format, provided she fulfills the other prescribed eligibility criteria. The number next. The contention of the petitioner in the present writ application is that the authority have issued the EWS certificate for the year 2023-24 or 24-25?
24-25.
24-25. But all of a sudden, by a notification, the petitioner has been brought under the category of OBC. But the petitioner is not intending to continue with the OBC and intending to continue with the EWS category. Full stop. The authority has considered the request of the petitioner and found that as per the notification, the petitioner is coming under the OBC category in the state list, and thus the petitioner is not entitled to get the EWS under Annexure C format. Consider the submission made by the counsel for the petitioner. Peruse the Learned counsel for the state submits that the authorities have given a personal hearing to the petitioner, and at the time of hearing, the authority found that the petitioner has been brought under the reserve category of OBC, and as such, the petitioner is not entitled to get the EWS certificate. Consider the submission made by the counsel for the respective parties, peruse the materials on record and the impugn order. Admittedly, the authorities have issued the EWS certificate to the petitioner for the year 2024-2025. But in the meantime, a notification has been issued by the government wherein Sadgop community is recognized as OBC in the state list with effect from 3rd June 2025. It is also admitted that the petitioner is the Sadgop community, and thus the petitioner is coming under the OBC category in the state list with effect from 3rd June 2025. Now the petitioner submit that he will make an submit that he not intend to continue with the OBC in the state list, and he intend to continue with the EWS category. In view of the above, the petitioner is given liberty to file a necessary application with an undertaking before the additional district magistrate Jhargram Jharkhand with an undertaking that he will not claim any benefit under the OBC category if an EWS certificate is issued to the petitioner for the year 2024, 2025, 2026. Full stop. If the petitioner made any application with an undertaking, the additional district magistrate shall consider the request of the petitioner and pass appropriate order. And if the consider the request of the petitioner, and if the authority found that if the petitioner will not claim any benefit under the OBC category, if an EWS certificate can be issued, this certificate can be issued in favor of the petitioner within 3 weeks from the date of receipt of this order.
One thing, Lord, that order that shall not be. And the order December 20, that shall not be.
That's a recorder. Yes. Petitioner is an advocate. So what do you want? Voter list of? Voter list of? Page 17. 17. This is a epic card. Correct. What is your epic number? Correct. Correct. Where is the name in the voter list? Page 19. काली अक्षर बैंच बराबर है मेरे साथ. Yes. 320? 325. I don't know. 325. I don't know where is the 324, where is the Shiv Shankar Das.
Third row tick mark is there, Your Lordship. It's a dark.
Where? Page 18. Page 18, the photographs. Serial number 459. That one. That one. 459. That is your MLN 2562. Yes. Then page 20 also.
After delimitation of the assembly constituency seat, my name continuation of the earlier voter list, my name listed as a voter of Jogapal assembly constituency. Till 2020.
No, earlier which under which constituency you was the voter?
2002, Dongjul assembly constituency in the district of
Howrah.
Thereafter, after delimitation to the year 2009, my name continuation of the earlier voter list, my name listed as a voter of Jogapal constituency assembly constituency in the district of just beside constituency. I have with my family member.
Okay. Then
I cast my vote in 2021.
Correct.
In the year 2023 state of West Bengal Panchayat election, when I went to cast my vote, the polling officers told me your epic card number is matched with another person of Calcutta assembly constituency in the district of not 24 provinces. In the year 2024 last parliament election, the same of the same.
So if the last election it was done, why you not challenge that?
Just thereafter, I have made representation because the opportunity concern. But no effect, I came here. The extra form also not given to me.
2021, it was you found that your name was not there. You cast your vote.
In 2022, it was brought that same epic number has 2 people had been given. So it has been deleted now. The procedure is that after deletion, he has to submit form 6. He has been informed. I have personally informed my learned friend that he has to submit form 6. Immediately, the BLO would upload his documents and he would be given a new epic number. Your Lordship, that is not possible. The system has deleted it. There's no provision for it. So now we have an electronic database.
What is
This is the Form 6. It a Form 6 study.
what you have done? Ah. Ah. Ah.
I want that my name to stay as a voter of Government constituency with this epic card. With this epic card number.
How this epic card will give? Already the epic card number is there in the name of other person.
For giving after, whether it is given before me or after, this is required to be justified. For directed my respectful submission, the private respondent is I am sir, but it was not, it was returned back that insufficient because he was not found in that particular locality. After filing the petition, I filed this Form 6 as per advice of the Land Senior Council of the and my respectful submission before your worship that whether private respondent name was included in the 2000 voter list because the admitted fact he is aged about 50 years and my age is now 42 years. So he is senior than me. If he has got the epic card prior to me, I said my name should be, my epic card number should be changed. But if he has not got the epic card prior to me, my number is given unchecked, which number will be? This is my specific option.
So what?
SIR form which are updated by the
Correct. SIR form you have to first you have to your epic card is to be corrected. Then the SIR will come. Otherwise, how the two persons' name will be registered in one epic number? And your epic number is already been deleted. So once your epic number is deleted, in which number you are now?
Deleted.
In which number your name will be registered?
Your Lordship, the last, in the third row, the last column, his epic number has been deleted with his name.
Yes.
There cannot be a fresh entry with the same epic number and name. He has, as per form.
When you submitted this Form 6, but you are telling that the same number.
After filing of this writ petition, not a problem, Your Lordship. A specific BLO has been appointed for his case. The first page, here the BLO's contact numbers are there. If he submits, immediately his in present SIR, his name would be included. But with a new epic number, not with that same
epic number, first epic number is to be issued.
He would be issued a fresh epic number.
Who will issue?
The Election Commission of India will.
How it will be issued?
Because he has submitted Form 6 now. So accordingly, the procedure is that it would be sent to the DM and accordingly he would be issued a new epic number, a new voter ID card would be generated and he would be accordingly communicated.
It will take?
Your Lordship, another 1 month. He has submitted.
That's what I'm telling. So with regard to the epic number, he has to apply for, then the procedure will follow and the new epic number will be, new identity card will be given with the new epic number.
Your Lordship.
Correct. So without the epic number, whether the BLO will be able to register the number?
Yes, he would be. He has a Aadhaar card and other details. His family members are there who could be traced from the other members that he is a citizen of India and he is there. There's only case of a duplicate, double epic number. In similar case had happened for Bihar and a person's epic number was matching with Haryana.
Consider page 3 of that Form 6 which I have just
Form 6.
So I am disposing of giving you liberty to approach the concerned BLO, correct? And you also concerned BLO for registered your name in the SIR, correct? And
I will personally update him when it is done.
With the epic card number.
So what do you want now, Phil? What do you want now?
I just need to submission kindly direct them to bring the record of the SIR of the respondent number 10.
All the persons are busy here and then one person will come here with the epic.
I have met party and they have received that
So that's why I am giving you liberty. You go and approach the BLO and make appropriate request to the BLO for inclusion of your name in the particular constituency. And in the meantime, you also make an application for issuance of the new election identity card with the new number. Till that time, the BLO will take appropriate steps for inclusion of your name.
I will personally update him with the epic number.
I have mentioned.
What you mentioned?
I did not able to mention epic card number because it was not uploaded because mismatch with the respondent number 10. I am able to mention. As a really constituency member 166 because it is the anti-allocation point has been was
Where the name of your family members? Your family members are there. How many members are there in the family? So that is there.
Yes.
Correct. Only your name is not there. And in which constituency your name is there?
Now,
let you go and contact with the BLO along with your.
I have already submitted the form.
Then
Your Lordship, page 2 is the report of the BLO, which has recognized that page 2 of this document which I had handed over, Your Lordship. There's a BLO's report. At the bottom, the BLO has signed, wherein he has stated that his other family members are there. It's a case of two similar epic number, and accordingly, it would be corrected. In the next page, last paragraph, Your Lordship, he had been informed by the BLO also over telephone to submit Form 6 back on 7th of January itself.
Yes.
As on this day, he doesn't have any grievance. It shall be disposed of accordingly. Your Lordship directs that.
Okay, I am keeping a repetition. Once your epic card will be granted, then
Your Lordship, Your Lordship.
I am keeping the repetition. Correct. As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear in the monthly list of April 2020, March 2026.
Your Lordship, could
In the meantime, the petitioner has liberty to take appropriate to contact the concerned BLO for inclusion of his name and for apply of the new epic card under Form 6.
Much obliged.
That's all. Affidavit service we kept with the record. Yes, next.
In this matter, I beg to appear in behalf of the state respondent, Lordship. May I be permitted? May I be permitted to use an affidavit, Your Lordship, because one of my submissions would be that there is an alternative remedy because the appellate provision is there.
Yes.
And in event there are factual, there's long fact history. I'll be bringing.
What is the case?
Yes, Lordship.
Huh? Where is the impugn order? 327. 327. Press renewed license.
Yes.
Under the clinical establishment.
Yes.
Correct. Huh?
Whatever.
Union of
State government has before procuring a
Correct.
Now, my first license was issued back in 1990. Till 2018, there was no problem in all of those licenses except for minor. Now, in 2018, in spite of my application, they have rejected that license. Now we have made appeals. Then
So this is to be decided on affidavit.
Yes, Lordship. That is my
decided on affidavit.
And keeping the point of maintainability open. Your
The counsel for the respondents press for time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks.
Lordship.
3 weeks. Reply, if any, there to be filed within a week thereafter. Full stop. The counsel for the respondents raised the question of maintainability. The same is kept open. Let's list the matter on 10th March 2026 under the heading adjourn motion.
Lordship, I am led by Mr. Somrat Sen, Lordship.
Give the name.
Yes.
I'm for the Union of India.
Give the name. Next.
Under the Bar Council of West Bengal.
Yes.
Matter has become infructuous because your lordship was last notification directed for the submission of the notification. One of the notification has been published. Now, the high powered committee has taken charge of the entire thing.
Yes, yes.
The high powered
Yes. Hmm. 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 So what is your prayer now?
Well, this matter, subject to
What is
correction.
the prayer in the writ petition?
Well, that in the notification, lordship will find. Now, this matter has become infructuous because.
Just a minute. Just.
Malad, Lordship will kindly see in the notification, there were time limits stipulated by the high power committee. Now, there was a specific window for 10 days for any grievances by any of the person whose name is either in the voter list or wrongly appearing in the voter list. Now, that period is over. Now, this notification was published. Your Lordship, on last occasion, directly, I have made an oral submission that the notification is yet to publish, but it will be published very shortly. The very next day, the notification was published. Malad, I have handed over the notification. Now, Malad, in pursuant to the direction passed by the Honorable Supreme Court, Malad, every authority is now before the high powered committee. Not even the Bar Council of West Bengal has now become defunct. Now, Malad, that window is over. Now, Malad, whatever demands he have, subject to what your lordship will say, well, he can approach before the committee, but the committee will decide whether they will accept it or not. But this writ petition, your lordship kindly dispose it of as
After filing of the present writ application, comma, a notification has been issued on 9th of January 2026. 2026. This court find that after the notification, after issuance of the notification dated 9th January 2026, the writ petition has become and counsel for the petitioner submit that still there are some grievances of the petitioner, as some of the names of the members of the bar has not been recorded correctly in the voter list. Consider the submission made by the counsel for the parties. The writ petition, as the authorities already, as the returning officer already issued the notification dated 9 January 2026. Accordingly, this petition is disposed of as infructuous, but the petition is a liberty, if any grievances, to make the grievances before the committee.
But the committee will decide, my lord, but it is not constitute that since your lordship has given them to agitate grievances where the window is now closed. My lord, they will constitute this that the High Court has given me the.
That's right. So what will be done?
Because your lordship will kindly see there was a window open for correction of names and for putting objection. Well, now he has an.
To take appropriate petitioners are liberty to take appropriate steps in accordance with the notification dated 9 January 2020. Affidavit to submit.
My lord, item 20 also is similar, my lord. Item 20, that is also similar, my lord. I am the appealing for the Bar Council of West
Because the
Bengal.
petitioner in 20, nobody is here.
I beg to appear in behalf of the Union of
But the
India.
petitioner is not here.
Petitioners. It will, my lord.
What? Item number? 6? 646. Who is for the other side? হুম হ্যাঁ
একটু পারি দাদা তোমাদের কাছ থেকে শিখেছি দেখে দেখে
till 4th February until further order. The counsel for the petitioner mentioned the matter. Get it in? Though the matter is listed as item number 40 of the today's list, 640 of today's list, but the learned counsel for the petitioner has mentioned the matter and submit that the interim order is still today and paid for extension of the interim order. Consider the submission made by the counsel for the petitioner. This court find that though the matter is listed at item number 640 in the today's list, but it is not possible for this court to take the matter for hearing due to paucity of time. Accordingly, interim order is extended till 20 March 2026 or until further order, whichever is earlier. Let the matter remain in the list.
We have applied the order where we government have already executed that the interim order apart from received the matter. We have contract on second year, even detect contract, but matter is good. This is a contract
Yes.
Yes, madam. Back to the interim order asked for
Item number?
item number 4.
Today's list.
No, oh my God. I'm not asking for order.
I am only asking whether four hundred 433 is now. Sudipto Day. Just a minute. Sudipto Day and others. So you are not aware of your case. The matter is all the advocates are mentioning for extension of the interim order 2 days before. You are not mentioned. What can be done today if the matter is not in the list? How it can be brought on list? Because the matter was heard in your presence. SMS might have been generated on that day. You are not present when the court has dictated the order. Okay. So what do you want now? How it is not in the list? It is not in the list. How it can be? So what can be done? You are the you have not mentioned the matter. In the morning you have mentioned the matter without the order. Now you are mentioning at the lunch hour. So how it can be taken into consideration? एक काम करो इसको 3:30 बजे लिस्ट करो सप्लीमेंट्री लिस्ट एक्सटेंशन ऑफ इंट्रीम ऑर्डर 3:30 बजे सप्लीमेंट्री लिस्ट फॉर एक्सटेंशन ऑफ इंट्रीम 4 बजे एक काम करो 4 बजे करो Today we are on which date? Today we are on today we are on 4. Tomorrow is one day. How many matters you have reached? Today how many matters have you reached? Then so tomorrow it will be taken. Continue. Yes. But I beseech your lordships, kindly take the compilation once more. I will take only 3-4 minutes to uh, wind up so far as the facts are concerned. Then I will take your lordship to the relevant judgments which I seek to rely on. Compilation segment. Yes. And on the last occasion, your lordship was pleased to put certain queries to my learned friend, and my learned friend made a submission that the decision has been taken on the basis of the expert opinion, technical experts, scientific experts, etc., etc. But I take your lordship to paragraph 9, page 9 of the compilation, which is part of the report, which is in fact the report. Kindly take, my lord, page 9, paragraph 6. Yes. National Institute of Nutrition, Hyderabad, presented the following views on the issue. But I am not taking your lordship to the entirety because, my lord, these are all technical terms, my lord. I am not conversant with these technical terms. But what I am on, kindly take III. Mustard oil has right proportion of fatty acids, and there is no evidence of toxicity from its consumption. The National Institute of Nutrition, Hyderabad, suggested that it is important to obtain the right amount of different fatty acids in the diet and avoid excess intake of any one group of fatty acids. Hence, to ensure optimal fat quality, the use of correct combination blend of 2 or more vegetable oil is recommended so as to ensure that the human body gets all the fatty acids in a balanced form. Thus, by blending different oils, the benefits of individual oils can be combined together. Based on the presentations made before the committee and deliberations made in the committee, the issue regarding blending and adulteration was discussed by the committee. So, this is the view of the National Institute of Nutrition. Kindly come to page 25 straight away, of the said compilation. Yes. Kindly take, my lord, paragraph 4 at page 25. And this is all part of, these are all annexures to the, my lord, the report. Yes. Kindly take the view taken by ICMR. Yes. Dr. Malad has got that? I'm sorry, Malad. I'm sorry. Paragraph 4. Dr. G.S. Toteja of ICMR informed that no major studies have been conducted in the field of blending. NIN Hyderabad, in a paper published in the year 2000, has suggested that blending groundnut and canola oil has its own advantages. Studies conducted on animals and consumption of blended oil shows no adverse impact on the health of animals. He was of the opinion that it can be safely presumed that there is no adverse impact of consumption of blended oil. He also mentioned about the study conducted on the issue by NIN in 2016. Has there been a study conducted which suggests that mustard oil is healthier than comparison to other oil? Is there any method to check the ratio in the present blended oil? Is there enough enforcement measure to check adulteration? Advisor Fasai, this is the advisor Fasai, said there is high proportion of uric acid in mustard oil which is not very healthy. There are standard there, though the ratio in blended oils can be determined, it is difficult to measure percentage of oil in blended oil. So this is what the Fasai's view is. There are standards of fatty acids prescribed in the Food Safety and Standards Act, and any deviation from these standards invite action. So, Malad, if there is any departure, so far as the manufacture of blended oil or the BEVO is concerned, obviously, my lord, the law will take its own course. Now, my lord, having regard to that, I take your lordship once again back to page 82 of this compilation. This is the final report. Page 82. Yes, my lord, kindly take the table which starts from page 85. Yes.
The panel, my lord, has got that. Now this is the table. This is the panel recommendation is the last column. The panel considered all the comments received and their observations, recommendations are as under. The panel noted that the Government of India issued a direction on 23rd September 2020 to bring specific regulation to prohibit blending in mustard oil and to facilitate manufacture and sale of pure mustard oil and for domestic consumption. This draft notification was issued as a consequence of this direction. The panel noted 487 comments received in favor of the proposed draft regulation and 24 comments received against it. Those in favor have broadly argued that they prefer pure mustard oil to be available in the market. Permitting blending leads to possibilities of adulteration of mustard oil, and that consumers should have a choice whether they wish to blend oils or rotate different single oils. Those against the proposed regulation state that the blending leads to a better fatty acid profile, better omega-3 to omega-6 ratio, and there is no scientific rationale for prohibiting blending of mustard oil. While there is some merit in the arguments given by those opposing the new regulation, it is a fact that the overwhelming public opinion is in favor of prohibiting blending of MO. Further, the panel also notes Bevo category per se is not being prohibited, but only use of MO in Bevo is prohibited. This leaves option open for those consumers who prefer Bevo. The panel is of the opinion that it is still open to the consumers to either blend. Now, this is kindly mark this, my lord. They say they are discouraging, my lord. They take it as a measure to prevent adulteration, and they are encouraging the consumers to blend edible vegetable oils, or it's rotate its consumption of various vegetable oils at their own level. The panel is of the opinion that it may be finalized as it is a direction. Well, I beseech your lordship, I have already
pointed
out. So this is all. Now, my lord, I take your lordship to the relevant judgments.
Because as per your submission, this is not the findings of the committee.
Yes, absolutely.
And
But
they have
I
taken
could
the
not have
decision
put-
as per the direction.
I could not have put it in a better way. That's all I can submit. So, my lord, I take your lordship directly to the authorities which I seek to rely on. For that, my lord, I beseech your lordship, kindly take two sections first. Section 18.
आराम से फूड सेफ्टी हाँ
Mayur has got it?
Yes.
Kindly take chapter 3, section 18.
Section
18 of the FSS Act. Section 18.
Yes.
General principles to be followed in the administration of Act. The central government, the state governments, the food authority, that is FSI, and other agencies as the case may be, while implementing the provisions of this Act, shall be guided by the following principles, namely, but I beseech your lordship to kindly take note of the expression namely. That means it would be restricted to the principles laid down therein. It cannot be anything beyond whatever is provided for in section 18. This is the policy and guideline laid down in the Act itself.
Correct.
Kindly take C. Where in any specific circumstance, on the basis of assessment or available information, the possibility of harmful effects on health is identified but scientific uncertainty persists, provisional risk management measures necessary to ensure appropriate level of health protection may be adopted pending further scientific information for a more comprehensive risk assessment. So, Malad, it is not about the commerce. It is all about the risk assessment study. It is all about public health being taken care of.
So, possibility of the harm effect on health of identified as scientific uncertainty.
Scientific. Well, it is all based on science. Whatever step they have to take must have backing of any scientific rationale.
Correct.
Kindly take subsection 2. The food authority, that is the FSI, shall, while framing or regulations or specific standards under this act, kindly take my lord C.
Undertake risk assessment based on the available.
Undertake risk assessment based on available scientific evidence and in an independent, objective, and transparent manner. My lord, today, my lord, I have why I, my lord, refer to page 9, page 25, and my lord, page 85, 86 onwards of this compilation. There is no scientific rationale behind, my lord, prohibition of use of MO in Bevo. And my lord, the regulations are to be framed. That means any amendment to the regulations would also be guided by the policy and guideline test laid down in section 18, subsection 2.
Yes.
So, my lord, now, first my lord, I take your lordship to the, my lord, the Article 14 test and the relevant judgments. Then I will come to this. Kindly take, my lord, the first judgment which I want to rely on. My lord, this is what we were taught when, my lord, when we were in college or when we joined profession. In fact, my lord, the Anwar Ali Sarkar, my lord, which is regarded as a locus classicus in its own way. Kindly take Anwar Ali Sarkar. My lord, what was the issue in Anwar Ali Sarkar? May I just summarize? Yes, 1952, 1 SCC, page 1. Mr. Kundolia is always, man, so good. He wants compilation of the judgments also. We will give that to him. We will give that to him. 1 SCC, page 1. My lord, what was challenged in this in the petitions, which it went from Calcutta High Court, in fact. It was first decided by a special bench of Calcutta High Court, which was challenged thereafter in Supreme Court by the state of West Bengal. Constitution of Special Court Ordinance, followed by West Bengal Special Courts Act and the notification. My lord, this act provided for bespoke trials, tailor-made trials for a certain class of accused. And that became the subject matter of challenge in the writ petition, which was finally carried to the Honorable Supreme Court. My lord, kindly take one. Well, I will not trouble your lordship with the entirety of this judgment. Your lordship will find that the facts are noted at paragraph 2. May I just quickly run through the facts? The material facts which are not controverted may shortly be stated as follows. On so-and-so date, an ordinance known as West Bengal Special Courts Ordinance was promulgated by the Governor of West Bengal under so-and-so Act. And on 15th of 1950, this ordinance was superseded and replaced by the West Bengal Special Courts Act, which contained provisions almost identical to that of those of ordinance. Section 3 of the Act empowers the state government to constitute by notification special courts of criminal jurisdiction for such areas and to sit at such places as may be notified in the notification. Section 4 provided for appointment of a special judge to preside over a special court, and it mentions the qualifications of the special judge should possess. Section 5 then lays down that a special court shall try such offences and classes of offences or cases or classes of cases as the state government may by general or special order in writing direct. This became the subject matter of challenge. Kindly take paragraph 6, my lord, Article 14 is quoted. I am not troubling with that, your lordship, with that.
Yes.
Kindly take paragraph 7. It can be taken to be well settled that the principle underlying the guarantee on Article 14 is not that the same rules of law should be applicable to all persons within Indian territory, or that same remedies should be made available to them irrespective of differences of circumstances. It only means that all persons similarly circumstanced must be treated alike, both in privileges conferred and liabilities imposed. Equal laws would have to be applied to all in the same situation, and there should be no discrimination between one person or another As regards the subject matter of legislation, their position is substantially the same. This brings in the question of classification. As there is no infringement of the equal protection rule if the law deals alike with all of a certain class, the legislature has the undoubted right of classifying persons and placing those whose conditions are substantially similar under the same rule of law while applying different rules to persons differently situated. It is stated that the entire problem under the Equal Protection Clause is one of classification or drawing lines. In making the classification, the legislature cannot certainly be expected to provide abstract symmetry. But this is what I'm on. It can make and set apart classes according to the needs and exigencies of the society and as suggested by experience. It can recognize even degrees of evil. Well, no evil has been pointed out in this case. But the classification should never be arbitrary, artificial, or evasive. Well, my case before Lordship, this is an artificial classification. And it must rest always upon real and substantial distinction, bearing a reasonable and just relation to the thing in respect to which classification is made. The classification made without any reasonable basis should be regarded as invalid. These propositions have not been controverted before us, and it is not disputed also on behalf of the respondents that the presumption is always in favor of the Constitution. My ultimately was struck down. But my Lord kindly takes now paragraph 17. My Lord, where my Lord, the provisions have been dealt with. My Lord, I'm just running through the paragraphs. I will not read the entirety because my this relates to the provisions of that act. 1721. But 21 I would like to read.
Yes.
At page 40 of the reports, the last sentence at page 21.
Yes.
But when the statute itself makes a discrimination without any proper or reasonable basis, the statute would be invalidated for being in conflict with the Equal Protection Clause. And the question as to how it is actually worked out may not necessarily be a material fact for consideration. As I have said already, in the present case, the discrimination arises on the terms of the act itself. The fact that it gives unrestrained power to the state government to select in any way it likes the particular cases or offences which should go to a special tribunal and withdraw in such cases the protection which the accused normally enjoy under the criminal law of the country is on the face of it discriminatory. So, my lord, arbitrary pick and choose method is abhorrent to the principles of reasonableness and equality as enshrined under Article 14 of the Constitution of India. Now, my lord, the next judgment would be, my lord, yes, AIR 19. Just 1 minute. 54. AIR 1954 Supreme Court. Just 1 minute. Yes, yes. 1954 2 SCC হয়েছে এটা তো ওকে দাও 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 না AIR ও আছে আমার কাছে AIR 1954 2 SCC দে ঠিক আছে আমাকে একটা কপি দে তো এটা আছে কপি না আমি কোথা থেকে গেল page yes my this is also my reported in AIR 1954 Supreme Court 747. Well, this is where, my lord, this SCC is equal to AIR. Sorry, SCC is what provision?
1954 to SCC 320.
320.
RM Seshadri.
RM Seshadri. Yes, RM Seshadri. My lord, kindly take, my lord, what was under challenge in this case. My lord, kindly take from paragraph 1. Well, what they challenged is the provisions contained in section 4 of the section 4 of the section clause 4 of the notification. Now, may I just read out first paragraph? The appellant is the owner of a permanent cinema theatre called so and so. and held a license from the DM Tanjore in respect of the same with effect from 50 to 51. The license is granted for 1 year at a time and is renewable from year to year. He objects to certain conditions in the license imposed by the DM, so and so, issued by the state of Madras purporting to act in exercise of the powers conferred under Section 8 of the Cinematograph Act of 1918. Conditions are like this: the licensee shall exhibit at each performance one or more approved films of such length and for such lengths of time as the provincial government or the central government may by general or special order direct. Well, it is like this, madam, when we go and to watch a movie, my lord, if there is a provision that before the movie is actually shown, well, there is a film. Well, we used to get those films divisions at one point of time. But my lord, if the length of the film is such, the approved films is such that will curtail the length of the movie which is ultimately shown in the theater, but that was held to be arbitrary. So kindly take, my lord, now the appellant moved the High Court of Judicature at Madras under 226 for an order and direction to the district magistrate to delete the said conditions from his license and to the state of Madras to rescind the notification issued by it. His contention was that the paragraphs are matching.
Yes, yes.
Paragraphs are matching. Imposed by the said notification are ultra vires and beyond the powers of the licensing authority, and they are void inasmuch as they contravene his freedom of speech and expression under 19(1)(a) and his right to carry on trade or business under 19(1)(g). Both the contentions were rejected. Malad, kindly now take, Malad, paragraph 4. Paragraph 4. From condition 4A. I do not know, my lord, whether it's a new paragraph under SCC. But paragraph 4 starts with the phrase, "We are of the opinion." My lord has got that. Your lordship will kindly skip over and take condition 4A. There is one paragraph or sub-paragraph, I do not know, in SCC. My lord has got that. Condition 4A.
Yes.
Condition 4A compels a licensee to exhibit at each performance one or more approved films of such length and for such length of time as the provincial government or the central government may direct. Neither the length of the film nor the period of time for which it may be shown is specified in the condition. Kindly, my lord, just few lines later, my lord, kindly take the fact that the length. My lord has got that.
Yes.
The fact that the length of the time for which approved films may be shown is also unspecified leads to the conclusion, in other words, the government may compel a licensee to exhibit an approved film which may say for an hour and a half and even for 2 hours. As the condition stands, there can be no doubt there is no principle to guide the licensing authority, and the condition as such as the above may lead to loss or total extinction of the business itself. My lord, I am a loss of the business. So any loss of business, any blockage of it may be contended on behalf of the, my lord, the answering respondents, that look, he is manufacturing other oils. So he is still in business. So what prejudice is being caused to them? Any loss in the business would also attract infringement of Article 19(1)(g).
Okay.
A condition couched in such wide language is bound to operate harshly upon the cinema business and cannot be regarded as reasonable restriction. It savors more of a nature of an imposition rather than imposition than restriction. It is significant that the condition does not profess to lay down that the approved films must be an educational, instructional character for the purpose of social or public welfare. We think, therefore, that condition 4A, as it stands at present, amounts to an unreasonable restriction on the right of the licensee to carry on his business and must be declared void as against the fundamental right of the appellant under 19(1)(g).
Yes.
So, this is how it has been held. But the next judgment in this series, my lord, kindly take the next judgment would be again a film matter. Ashirwad Films. This is 2007 6 SCC. 76 SCC 624. 624. Prohibitory directions were given regarding display of non-Telugu films. So, my lord, Hindi films became a target. I tell you, Lord. So, my lord, this matter went to the Honorable Supreme Court. My lord, kindly take only paragraph 1. My lord, why? Because only the facts, just for that reason. But different rates of entertainment tax were imposed.
You have intentionally chosen this judgment.
No, 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 no. My lord, I tell your lordship, many people did not, well, just 1 minute of your lordship's time. When many of us in all over India did not used to watch regularly, my lord, Telugu films, Tamil films, and the Malayalam films. Well, I started watching Malayalam films, Telugu films, Tamil films at least 10, 12 years ago. Name one Telugu film. Magadira. I will name on. No, no, no. Magadira is a 10-year-old movie. Sorry. Magadira is a 10-year-old movie. Then Magadira. Then this Nani's film. Nani's. I can go on. I can go on all the Rajamouli movies. Don't worry. Then Mahesh Babu. Mahesh Babu.
That is in action.
He is actually an absolute
Well,
film aficionado. If you want to know about any films in here in Bollywood or Hollywood, the first person you ask me, sir,
well, I love watching because my lord, this banging of cars, mashing of people. But there are some sensitive movies also. There are some sensitive movies also. But some Malayalam movies are very sensitive. Very sensitive.
Yes.
Because Shiva is a long time. Shiva to was made in Hindi also. Shiva is Nagarjuna. Shiva was Nagarjuna. You remember the song from Shiva? He stopped there. So, paragraph 1. If lordship kindly takes paragraph 1 for once. Constitutionality of a notification issued by government of AP levying different rates of entertainment tax in question in this writ petition filed by the
Where
petitioners.
from you are reading?
Paragraph 1, my lord, 627. I'm sorry, my lord. Paragraph 1. My lord, I take your lordship to Ashirvad Films. Your lordship has got Ashirvad Films, right? Ashirvad Films.
Yes, Ashirvad film.
Paragraph 1. It starts at page 627 of the reports. The judgment of the court was, my lord has got that? Constitutionality of a notification issued by our government of AP levying different rates of entertainment tax is in question in this writ petition filed by the writ petitioner under Article 32 of the Constitution of India. The petitioner herein carries on its business as a distributor of motion films at Hyderabad. The field of his activity is said to be distribution of Hindi films in the state of AP. It is not in dispute that the rate of tax in respect of Telugu films was fixed at 10% and the non-Telugu films was fixed at 24%. That was the grievance. Now, kindly come to paragraph 24.
Yes.
25. Kindly take 25. 24, your lordship may kindly note. I will read 25 for your lordship. Because my lord, there is, my lord, your lordship is taking up so many matters. Time is a presence, my lord. Kindly take paragraph 25. The purported, my lord has got that?
Yes,
633. The purported classification only on the basis of language without anything more and in particular having regard to the difference in the rate of tax in our opinion is expressly arbitrary. The burden was therefore on the state to show that the imposition was justified. Different rates of entertainment tax had not been levied having regard to the nature of theatre, the area where they were situated or the extent of occupancy, etc. It has not been explained as to whether cinema theatres exhibiting Telugu films suffer from any disadvantage which others had not been. It has not been shown as to why the same theatre where films in different languages are exhibited would be a class apart only because at different times it exhibits films produced in different languages. Moreover, how Telugu films have been treated as a separate class has not been stated. Although the legislature enjoys a great freedom and latitude in choosing persons upon whom and suggest upon which it can levy tax, it is tried that taxing legislations are not immune from attack Based on Article 14, it is also not the case of the respondent that in imposing different rate of tax, they intend to achieve the avowed object envisaged in Part 4 of the Constitution. So, no directive principles of state policy was sought to be achieved. So, this is how it was struck. Again, a case of discriminatory taxation, prohibitory taxation, rather, if I may say so. So, now the next judgment which I would like to rely on. Kindly take, my lord. This is 2015 10 SCC 681.
It is there.
But I will give. It is there.
Your stitch.
Unfortunately. What we will do, my lord, we will prepare a compilation. If so. Oh, it is there, my lord. It is there. Oh, I am so sorry, man.
That's why in the last time it was confused.
Oh, I am so sorry, man.
Pre-judgment is stitch.
I am so sorry, man. I am so sorry.
No problem, no problem.
My lord, kindly take, my lord, paragraph 1 of NS Ratnam. This is 2015 10 SCC 681.
Yes.
What was the fact of the matter? The respondent herein, my lord has got that?
Yes.
687. The respondent herein impugned the validity of notifications number 102 and 103 dated 27/3/1987, whereby the whole of the duty of excise was exempted in respect of iron and steel scrap obtained by breaking the ship, subject to the condition that customs duty should have been levied at the rate of 1400 per light displacement tonnage, that is LDT, with the stipulation of such a condition giving the exemption of payment of excise duty only to those who had paid customs duty at the rate of 1400 per LDT. Another class of persons who had paid customs duty under Section 3 of the Customs Tariff Act, albeit at a lesser rate, was excluded. So, those who have paid customs duty at the rate of rupees 1400 per ton per LDT, they were given the exemption, but those who were paying
Another class of custom is not.
was excluded since they were paying
Discrimination.
lesser duty. Yeah, discrimination. The respondent who belonged to the excluded category had challenged the notification. So, I am not troubling your lordship with that. Kindly come to paragraph 13 straight away.
13.
Yes, ma'am. 1-3.
Yes.
It is thus beyond any pale of doubt that the justiciability of a particular notification can be tested on the touchstone of Article 14 of the Constitution. Article 14, which is treated as basic feature of the Constitution, ensures equality before law or equal protection of laws. Equal protection means the right of equal treatment in similar circumstances, both in the privileges conferred and in the liabilities imposed. Therefore, if the two persons or two sets of persons are similarly situated, they have to be treated equally. At the same time, principle of equality does not mean every law must have universal application for all persons who are not by nature, attainment, or circumstances in the same position. It would mean that the state has the power to classify persons for legitimate purposes. The legislature is competent to exercise its discretion and make classification. Thus, every classification is in some degree likely to produce some inequality, but mere production of inequality is not enough. Article 14 would be treated as violated only when equal protection is denied, even when two persons belong to the same class or category. Both are manufacturing bevo. One class of MO in bevo prohibited, whereas every other vegetable oil is allowed to be used for the preparation of bevo or manufacture of bevo. Article 14 would be treated, yes. Therefore, the person challenging the act of the state as violative of Article 14 has to show that there is no reasonable basis for the differentiation between the two classes created by the state. Article 14 prohibits class legislation and not reasonable classification. What follows from the above is that in order to pass the test of permissible classification, two conditions must be fulfilled. Namely, that the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from the others left out of the group, and that the differential must have rational nexus to the object sought to be achieved by the statute in question. If the government fails to support its action of classification on the touchstone of principle, whether classification is reasonable, having an intelligible differentia or national basis, German to the purpose, the classification has to be held as arbitrary and discriminatory. And then the quote Sube Singh, I am not on that, that is there. So then after that, my lord, the notifications are considered. At paragraph 16, my lord, your lordship will find the conclusion basically.
Yes.
In the present case, we find that the two notifications, both dated so and so, pertain to same goods, those falling under the head 72.515 and 73.09 so and so. Customs duty is leviable on these goods under section 3 of the Customs Act. The said duty can be paid under any of the two methods. When two methods are permissible under the statutory scheme itself, pausing here for a moment, it is still permissible to manufacture Bebo with MO because my lord, the food additive regulations permit me to do so. Is that the assessee to choose any of the methods to pay customs or duty thus paid is to be naturally treated as validly paid merely because with the adoption of one particular method, the duty that becomes payable is lesser would not mean that two such persons belong to different categories. The important factors for the purpose of parity are the same. In the instant case, viz. The goods are same, they fall under the same heading and the custom duty is leviable as per the act which has been levied. Therefore, the impugned notification giving exemption only to those persons who had paid a particular amount of duty, namely 1,400 rupees per LDT, would not mean that such person belonged to a different category and would be entitled to exemption and not other persons like the respondent herein who has paid duty on the same goods under the same act, but on the formula which he opted and which is permissible, which the rate of duty comes to rupees 1035 per LTT. Well, this is a discrimination test. Now, the next judgment would be, yes, man, in paragraph 20, your lordship may also kindly take note of another judgment rendered by the Honorable Supreme Court in Deepak Fertilizers, where my lord, distinction was being made between two classes of my lord, ammonia fertilizers was discussed and my lord relied on. Now, the next judgment in this line would be yes, Ayurveda. 1989 2 SCC 285. What was the case here is that it was a case of Ayurvedic medicinal preparation.
Yes.
Prohibitory rate of tax was levied on Ayurvedic medicinal preparation since they have high alcohol percentage, and that became the subject matter of challenge before the Honorable Supreme Court. Kindly take, my lord, paragraph 3. Where, my lord, the counter affidavit filed by the government of Tamil Nadu is considered. From the counter affidavit filed by government of Tamil Nadu, my lord has got paragraph 3.
Yes.
In writ petition, out of which one of the present appeals arises, it appears that higher rate levy of sales tax on arishtams and asavas was introduced by the state legislature to curb abuse of medicinal preparations for their alcoholic content by drink addicts and to eliminate mushroom growth of Ayurvedic pharmacies preparing substandard arishtams and asavas for purposes other than medicinal use. The appellants contend that arishtams and asavas manufactured by them are essentially Ayurvedic medicines and that in any event, the object of controlling consumption of liquor is amply served by several other existing statutes including Medicinal and Toilet Preparations Act 1955, Drug and Cosmetics Act 1940, Spirituous Preparation and Control Act 1955. It is said that there are over 130 allopathic medicines containing alcohol which are portable and as portable as against only 3 Ayurvedic medicines, and that therefore the levy of tax at 30% on arishtams and asavas alone, while other medicinal preparations are subject to tax at the rate of 7%, results in an invidious discrimination against the manufacturers of those Ayurvedic preparations, thus violating Article 14 of the Constitution. It is contended that the impugned rate of tax also offend 19(1)(g) of the Constitution, the appellant so and so. Article 301 was also pleaded. So, my lord, then we kindly take, my lord, paragraph 6.
Yes.
We think that the appeals are entitled to succeed. Item 95 mentions the rate of 7% as the tax to be levied at the point of first sale in the said state. Item 135 provides a rate of tax of 30% in respect of arishtams and asavas at the point of first sale. We see no reason why arishtams and asavas should be treated differently from the general class of Ayurvedic medicines covered by item 95. It is open to legislature or the state government, if it is authorized in that behalf by this legislature, to select different rates of tax for different commodities, but where the commodities belong to the same class or category, there must be a rational basis for discriminating between one commodity and another for the purpose of imposing tax. It is commonly known that the consideration of economic policy constitutes the basis for levying different rates of sales tax. For instance, the object may be to encourage a certain trade or industry in the context of the state policy for economic growth, and a lower rate would be considered justified in the case of such a commodity. There may be several such considerations bearing directly on the choice of the rate of sales tax, and so long as there is good reason for making distinction from other commodities, no complaint can be made. What the actual rate should be or is or not a matter for the courts to determine generally, but where a distinction is made between the commodities falling in the same category, a question arises at once before the court whether there is justification for the discrimination. In the present case, we are not satisfied that the reason behind the rate of 30% on the turnover of arishtams and asavas constitutes good ground for taking those two preparations out of the general class of medicinal preparations to which a lower rate has been applied. Then, my lord, in so and so, this court considered whether the Ayurvedic medicinal preparations known as Mrita Sanjivani Sudha, Mrita Sanjivani Sura, prepared in accordance with an acknowledged Ayurvedic formula could be brought to tax under the relevant State Excise Act, when medicinal preparations liable to excise duty under Medicinal Toilet Preparations Act was a central act. The court act held that the three preparations were medicinal preparations, and observed that mere circumstance that they contained a higher percentage of alcohol could be used as a alcoholic beverage could not justify their being treated differently from other medicinal preparations. We are of the opinion, well, it is quoted, that similar considerations should apply to the appeals before us. The two preparations, arishtams and asavas, are medicinal preparations even though they contain a high alcohol content. So long as they continue to be identified as medicinal preparations, they must be treated for the purpose of sales tax law in like manner as medicinal preparations generally, including those containing a lower percentage of alcohol. On this ground alone, the appellants are entitled to succeed. Now, my lord, there is a recent judgment regarding, my lord, Article 14. This is, my lord, 2024. এটা করা আছে? আচ্ছা। 2024 SCC online SC 3432. This was a case of distribution of largesse. What was challenged was allotment. Preferential treatment was given in the matter of allotment of public land to, my lord, members of IAS, IPS, judges, MLA, MPs, and journalists. Your lordship will find the facts at para 4.
Yes.
Well, kindly take from paragraph 48. Well, I will not trouble your lordship with the entirety of the judgment.
48.
48.
Yes.
The test of reasonable classification developed several decades ago continues to be a dominant test permeating our constitutional discourse. It consists of two prongs. Well, this is that age-old test, I need not read, this is there. Then, referring to the twofold classification test, a constitution bench of this court in Subramaniam Swamy emphasized that there must be a nexus between the basis of classification and the object of legislation or policy under consideration. The court also referred to its earlier constitution bench decision in Ramakrishna Dalmia, where there's a Commission of Inquiry Act matter, which observed that legislature is free to recognize varying degrees of harm and may confine its restrictions on classification to those cases where the need is most evident. There is no evident need at all. Then, my lord, in paragraph 52, your lordship will find, my lord, again relating, again, my lord, laying down that class discrimination is prohibited. Now, 53, my lord, your lordship will find the Honorable Supreme Court relies on, my lord, Anwar Ali Sarkar and Kathi Rani Rawat.
Yes.
Now, my lord, kindly take 56 and 57. But this is the summary. It follows that the rigors of Article 14 cannot be interpreted in a narrow, pedantic, and lexicographical manner. My lord has got that? The doctrine of classification is neither a mere restatement of Article 14, nor is it the objective and the end of that article. In a catena of judgments, this court has held the reasonable classification doctrine is a judicial formula to assess whether legislative or executive actions are arbitrary, thus amounting to a denial of equality. It is arbitrariness that lies at the heart of reasonable classification test. The principle of reasonableness, both legally and philosophically, is an essential element of equality and or non-arbitrariness, pervading Article 14 like a brooding omnipresence. Then, my lord, now these recent judgments are quoted. I'm not troubling your lordship with that. Then the conclusion your lordship will find at paragraphs 87 and 88. But this is how, my lord, the law has been, my lord, propounded by the Honorable Supreme Court and by your lordships in a catena of judgments. Now, my lord, now I take your lordship to the other angle of the matter, my lord, that is the rule exercise of the regulation making power. Because, my lord, my case before lordship is that having regard to the language used in section 92, which kindly take, my lord, section 92 for once. Read with, my lord, section 18.2 C. A regulation, my lord, which is framed without having regard to the policy and guideline test laid down in section 18.2 as a whole or 18.2 C in particular, my lord, would be exercise of rule regulation making power, my lord, in derogation of the statutory basis for which the power has been confirmed, has been conferred. Kindly take 92. Under 92, these regulations have been made. The lordship will find that 92.1, my lord, is for to carry out the provisions of this act. 92.2 says, in particular and without prejudice to the generality of the foregoing power, such regulations may provide for all or any of the following matters, namely so and so. But the regulation, if read, the preamble of the regulation, if we see, the lordship will find 92. Kindly take, my lord, the regulation for once, which is in the compilation. But I must make it clear, my lord, the compilation, incorrect ache na? Yes. My lord, the pre-amended regulation, my lord, instead of pre-amended regulation, my lord, what is annexed at page 56 to 64 and, my lord, 65 to 75, but it is the, my lord, the both are post-amended. My lord, it's a mistake. My lord, we will give the pre-amended one. Kindly take 65 to 75, which is the post-amended regulations. Your lordship will find that it refers to, it says that the regulations have been made in exercise of the powers conferred by section 92, page 65. My lord has got that. But having regard to that, when we look at 18.2C and at section 92, but the logical conclusion would be that the the regulation making authority or the food authority or the FSI could only exercise the regulation making power having regard to the policy and guideline laid down in section 18.2. Which has not been done so because I have tried to establish in my own humble way that there is apparently no scientific basis for this decision to be taken and for this regulation to be amended. Now, my lord, having regard to that, my lord, basically the FSI as a regulation making authority has transgressed its statutory limits provided for in section 92, read with section 18.
Why?
Because, my lord, in the sense, my lord, when the policy and guideline test itself has been defined in the act, and when somebody is exercising power without having regard to the policy and guideline test, then it is a transgression of authority in my most respectful submission. My lord, this is like, my lord, when the policy and guideline test is laid down, there is no abdication of legislative power. Had no policy and guideline test been laid down, there would have been abdication of legislative power. That is one test. The other test is that when it is laid down, it is obligatory for, my lord, the regulation making authority to follow that policy and guideline test.
And
Or,
which is
my lord,
which already provided
it
here.
is already provided in the statute itself.
So they cannot take the.
So they cannot frame any regulation or amend any regulation in
On their-
derogation of, my lord, the policy.
On their views.
On their views or in derogation of the policy and guideline test as, my lord, provided for in the statute itself. So it is a transgression of their statutory limits in my most respectful submission, subject to your lordship's kind consideration, obviously. My lord, couple of judgments, then I conclude. Kindly take, my lord, the celebrated judgment of the Honorable Supreme Court, my lord, the Company Law Tribunal judgment, Roger Matthew versus South Indian Bank. My lord, all the cases went up to Supreme Court. I will take your lordship to only couple of paragraphs. Yes. My lord, paragraph 132. My lord, we referred to, my lord, MCD versus Birla Cotton and Spinning Mills.
Yes.
My lord, kindly take, my lord, I just read a couple of paragraphs. A year later in MCD versus Birla Cotton and Spinning and Weaving Mills, this court, however, upheld section 113, which has empowered the corporation to levy certain optional taxes by observing there were sufficient guidelines, safeguards and checks in the act which prevented excessive delegation, as the act had provided maximum rate of tax. It was observed that the nature of the body to which delegation is made is also a relevant factor to be taken into consideration in determining whether there is sufficient guidance in the matter of delegation, also when delegation is made to an elected body accountable to the people, including those who had paid taxes. Well, then it is quoted, after quotation, thus the guidelines in form of providing maximum rates of taxes up to which a local body may be given discretion to make its choice or provision for consultation with the people of the local area, and then fixing the rates or subjecting the rate of tax so fixed by the local authority to the approval of the government, which acts as a watchdog, were treated as satisfying the policy and guideline test. Then, my lord, 133, again, my lord, reference is made to this Birla Cotton and Spinning Mills, Spinning and Weaving Mills. Then MK Papaya is also followed. I will not trouble your lordship. Well, just your lordship may kindly take note of, subject to your lordship's kind consideration. And now kindly come to 145. 145.
Yes.
Well, I will not trouble your lordship with the entirety of the paragraph. First, again, my lord, MCD 143 speaks about, my lord, refers to MCD, which means, my lord, Birla Cotton. Then, my lord, at 145, my lord, it is placitum G. It is always open. My lord has got that. It is always open to a constitutional court on challenge made to the delegated legislation framed by the executive to examine whether it conforms to the parent legislation and other laws and apply the policy and guideline test. So, my lord, I beseech your lordship, my lord, it is my humble submission before lordship. When your lordship would be examining the regulations, your lordship would kindly have a look at section 18(2)(c) and 92. My lord, what has happened, my lord, the inbuilt safety mechanism, my lord, has been practically ignored. My lord, policy and guideline test, in my most respectful submission and in my humble understanding, it is a kind of inbuilt safety mechanism.
Already available.
Already available.
So not to go beyond that.
Not to go beyond that.
To act in accordance with the what is provided.
Absolutely, absolutely, absolutely. These are my respectful submissions. These are my respectful submissions.
Thank you.
Within 3 I have concluded. But nobody believes me. I'm otherwise
practice in your chamber. 1 hour.
No, my lord. Generally, my lord, nobody believes me, but I'm generally economical.
Thank you.
So grateful to your lordships for your lordships. But my lord, I reserve my right to give reply, my lord, whenever they.
Naturally.
But now that your lordship has heard the matter substantially, now it can be made heard in part. Now, my lord, your lordship has heard the matter substantially. One part is concluded.
One side is concluded.
Everybody, my lord, these parties are added.
That is the problem for this court. Giving hearing them.
This is a very good case.
Well, your lordship may kindly hear it in part, and my lord, then my lord, your lordship will hear them. Obviously, they will. Your lordship will hear.
Yes.
Second week of March.
Yes,
From
personal
today.
difficulty.
I don't think my diary will also not permit before April.
Then when March, my lord.
देखो नहीं पहले कुछ है डेट मार्च में
তুই করে দে না তোর পার্টটা তুমি তো রুল মেকিং রেগুলেশন মেকিং অথরিটি
Policy decision করে একটু বলুন।
হ্যাঁ ওই তো পড়েছে ওই তো
আগে policy বলেছে তাই জন্য।
March.
But Mr. Kundalia very cleverly left it to the juniors to point this out. And they scooted away. Then Mal kindly make it hard in part, Mal.
6 March at 12 noon.
Mal kindly make it hard in part. Kindly make it.
Oh. आगे देखो.
Mal kindly make it hard in part. ঠিক আছে ওরা যখন বলবে আমি থাকি না থাকি ওরা করে দেবে তারপর আমি ফিরে যাই কোথায় যাচ্ছে বিপুল আর ওকে যদি কোর্টে দেখতে পারি আমি পরের সপ্তাহ থেকে তাও দেখছি আমি
सेकंड वीक में देखो 10 11 12 13
ও ঠিক ঠিক सब है any day after 9th March my lord right
है ना फिर क्यों रखेगा 12 बजे है 13th March 12 noon.
My lord, in the
hard in part, my lord. Kindly, my lord, this kindly make this.
Then at counsel for the petitioner has concluded his argument.
Yes.
Full stop. Due to paucity of time, and counsel for the respondent could not argue the matter. Let the matter appear on 13th March at 12 noon as parted matter.
Grateful.
Well, next 2 p.m. matter,
yes,
because of the paucity of time may not be taken, but the interim order would be expiring on Friday.
Friday.
Who
is for the other side? Item number 9.
8 and 9.
8 and 9. In both the interim orders?
Yes. It's identical matters.
Who is European? So I am extending the interim order. Affidavits completed?
Yes. All are completed.
Though the matter is fixed today as a specially fixed matter at 2 p.m., but due to paucity of time, the matter could not be taken of hearing. Then at counsel for the petitioner submit that interim order is till 6th of February 2026, according place for extension of interim. This court findeth that petitioner already enjoying the interim order and pleadings have been completed. The matter is
covered by already lordship's order. It will take not more than 15 minutes. Banning without any show cause.
That's, I think, entire submission.
What, willful?
Yes.
Willful default?
Sorry?
Willful default?
No. This is, there was a criminal proceedings in 2018. That's all. In 2025, no show cause, no
directly.
direct. And I've got that lordship judgment and series of judgment. Nothing.
We have made our submission.
I will see here. No, I am not passing judgment. Don't worry.
This is only for the purpose that it will not take time.
List the matter.
Purely point of
इससे
law.
पहले 6 तारीख था ना 6 का 6 मार्च खाली था ना extended. Let me see that list. Just you tell na 6 March is 12 noon. 6 March 12 noon.
Interim order
Interim order is extended till 6th March or until further order, whichever is earlier. Or interim order is extended till
It has been
11th.
extended several times. Kindly keep it till disposal.
Interim order is extended till 11th of March 2020. I will take the matter.
Yes.
Or until further order. Next.
Obliged.
Yeah, original. Now what to do? खाली वो होता extension of time. उन्हें एक को बुला दे, कोई को बुला. वो एक छोटा सा एंट्री में चलने दो, बीच में करना, लास्ट में करेगा.
May I have kind leave to mention a matter not in my lord's list, but after 4 extensions, the respondents have finally filed their affidavit in opposition, that too much beyond the last date provided by your lordship's last order. We have accepted that because otherwise it would linger. But all I'm saying, because your lordship has made the matter returnable on the 11th, but we would need some time to use our affidavit in reply. On 11th, may I hand up the
11th of Feb.
On February. So, my lord, I was mentioning only for seeking extension for a fortnight, my lord, and if the matter could appear on any
It's
days,
not in the list.
it's not in the
Okay,
list.
You do one thing, you prepare it. If the 16 it is listed, come, I will extend it. No problem. Because the file is not here.
Right.
So you have been.
May I have a lordship's leave to mention this suit, my lord? It was marked as the application filed in the suit was marked part hard by your lordship. And since then, the matter has not been heard by your lordship.
What is the application for?
For rejection of the plaint, your lordship, it was by the defendant.
You are for the plaintiff.
I'm for the plaintiff.
Who is for the defendant?
Your lordship, I've served them
So
via
what you
mail.
want? It is not in the list.
Not in the list, your lordship. Kindly have it included
That's
in
the
the
list
list for
one.
hearing.
Yes, next.
To mention one matter. This matter is I was praying for inclusion as a new chamber application. As a new chamber application. This is the application for deletion of my name. The bank has financed certain loan. The loan has been settled between the two parties.
That two brother two.
One is the company, another one is the who has mortgaged the property. Now we have released the title deed. I am only seeking for deletion of my name. So if it could appear as a new chamber application any day, subject to my lordship. Very short application.
Suit यहाँ है.
It is a specially assigned before your lordship. I'm grateful.
Yes, call the list.
Your Lordship, I'm appearing on behalf of the petition. Your Lordship, it's coming on my instance for extension of interim order. The interim order is expiring today, Your Lordship.
Petition challenge is so-called notice when the bank intending to declare the petition account failed. Or the concern? Yes.
The pleadings are complete, Your Lordship.
You are for the plaintiff. Petitioner.
Petitioner, yes, Your Lordship.
Which was the respondent? PNB? So what is the interim order you are enjoying?
Pleadings have been concluded.
Kept for hearing? Yes. When it can be kept for hearing?
Your Lordship, I'll just beseech that I'm being led by Mr. Sabyasachi Chaudhary. So Your Lordship may not kindly fix a date, keep it in the list, Your Lordship, any day subject to your Lordships, because I need to see his availability also. That's the
3 p.m. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for extension of interim order. Counsel for the respondent submitted the pleadings have been completed. The matter can be taken up for hearing on merit. Had the learned counsel for the parties, this court find that the petitioner already enjoying the interim order accordingly. Enjoying the interim order fully. So let the matter appear on 2nd April. 2nd April at 3 p.m. Under the adding especially fixed matter, interim order is extended till 2nd April 2026 or until further order, whichever is available.
Your Lordship, same order in item number 2.
Same order on the bank has filed.
WPU.
That is a matter of Vikas Agrawal.
Yes, Your Lordship, it's arising out of the same show cause notice, Your Lordship.
Same show cause notice.
Yes, Your
एक ही दिन रखो देखा जाएगा. Same order कर दो. Second maybe, yeah. Item number 2 maybe. Next.
Grateful, Your Lordship.
The appearance
ये Thomas, ये क्या है?
My lord, I'm for the writ petitioner. My lord, recall, my lord, this is the matter, my lord, where, my lord, I'm an NBFC. My lord, the right to shut
Yes,
shop.
yes, 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 yes.
My lord, this is the first order which my lord passed, my lord, on 13 January.
On that day, he has given some. Have you
No, my lord, yes, my lord, I've got that. My lord, kindly look at, my lord, Judge Sahib, copy.
Yes, it is.
My lord, kindly, my lord, look at this. I don't know, my lord, what kind of, with great respect to my learned friend. My lord, kindly see, first they say on the our comments, my lord, which is their comments. As per para 38 of chapter 3 of Reserve Bank of India, such principal business criteria is defined as ratio of financial assets total assets. No difficulty, we know that. Then 2, company was served an explanation letter for not meeting the PBC as on March 31, 2024. Company did not respond to the letter. Said letter instead applied for voluntary cancellation certificate of registration accompanied with the auditor's certificate. Lord, we do not have any such letter, first of all. And my lord, I don't know how March 31, 2024, my lord, I do not meet the criteria because it was increased, my lord, from 2025. Then my lord, 3, as the company, then kindly see my lord, 2 and 3 itself, my lord, are contradictory. As the company was meeting the PBC as on December 31, 2024, company's request for voluntary cancellation was rejected. Then they say further, as per the return submitted by the company as on March 31, 2025, company continues to meet the PBC, which makes it necessary for the company to hold on to the certificate of registration. Quite naturally, that's my complaint. I'm saying unless you give me permission, I can't reduce it. Then Malad, they says, interestingly, 5. It is also submitted that for the purpose of voluntary cancellation, reducing the PBC to less than 50% while holding the CO is not in conflict
with the terms and conditions.
Yes. So kindly give me a time, my lord. I was not aware of it. Kindly give me, my lord.
So I will record this.
Yes.
And will allow you.
Yes.
Within 2 weeks.
Correct.
You reduce
2
it.
weeks I can't, my lord, reduce. My lord, kindly give me a little time, my lord.
Whatever time. So I will record this.
Yes. 5 and also, my lord, 2.
And
kindly see, my lord, 2.
The PBC may be reduced to the liquidation.
By liquidation of financial investments and equities of mutual funds or other investments, like correct. And my lord, my surrender application will be on that basis. No difficulty.
Yes.
Because 5, this is the first time they're saying all this.
So that's why on the
yes, correct. On the last occasion, my lord asked this, post this.
Your colleague said that it is not in the sign envelope. Okay, I will take in my order.
Yes.
If they are not given on sign or sign a signature, so I will take this on
Yes,
the order.
correct. Because that's the instruction come from them. Correct.
I will take in the order and I allow you to reduce it.
Yes.
And once you reduce, you apply for that. And
yes. Malad, original, Malad, my registration is still there because I've asked Malad, saying Malad that. Just a minute, right? The original application, Malad, for cancellation is still there.
That is there.
Because I've challenged the cancellation. Yes.
Once you reduce, you inform the authority.
And then they will, Malad, in terms of
your
original, yes. Original application.
My lord, exactly what my learned senior friend says, my lord, once their total assets.
That's why I propose to, I will record this, serial 5 and serial 2I.
Yes,
I record this and I will allow to reduce this in terms of this instruction given by you. And once they have reduced this, then they reduce it, he will inform to the authority and authority will take appropriate steps in terms of the
Application made on 18 March 2025.
My lord, this application has already been rejected. My lord, they will
I've challenged that.
My lord, they will need to file another chartered accountant certificate showing that they do not meet the principal business criteria. So, my lord, a fresh application would perhaps be a better way of going at things. My lord.
Difficulty, we will file a fresh certificate, but my lord, it will be in terms of my lord, the initial application made. Because now my lord is providing for the order.
So then you no, then you do one thing.
My lord, because I will be hauled up then. My lord.
That's why you do this. Once it has been reduced, you take this certificate and file a review application for recalling this order and take the appropriate action because there is already an order.
My lord, that's the challenge because my lord, my challenge is
challenge.
So that can be set aside. My lord, the challenge can be set
Otherwise,
aside.
that has to come here. Then this court has to pass an order for setting aside and considering.
Yes. So my lord will have to pass, my lord, because otherwise, my lord.
Then first you do that and bring that.
So, my lord, may I just, my lord, first, my lord, the court will have to set aside that order because it's been rejected. Otherwise, my lord, I can't even reduce. So, my lord, my challenge is, my lord, to that cancellation. So the cancellation, my lord, can we kindly, my lord, look at, my lord, my
recall and rescind the order.
Yes, July 4. My lord will find that's the first prayer. So July 4 has to go.
No, but already that's why that is to go. So what I propose to do, first you apply for it. First you apply for reduction in terms of this clause 5.
Yes, but my lord, with July 4, I can't do anything.
No,
because July 4, my lord, is the cancellation of.
I will.
Where?
First you apply for.
Very well.
Once it has been reduced, you file a supplementary before this court by way of supplementary affidavit, and I will set aside that order and directing to take appropriate steps in accordance with the certificate.
And my lord, in terms of my original application.
That's why I will set aside.
My lord, kindly provide for that in the order itself.
So I can dispose of herein now. That's why.
Very well.
If you want to dispose of, I
would have been very happy, but my lord, kindly, my lord, keep it back, my lord. Then, my lord, kindly give the order, my lord, will come back.
Herein now.
My lord, insofar as the prayer for dismissal of that order is concerned, my lord, I'm objecting to that. My lord, because their own CA certificate says that they still today meet the principal criteria.
That's why I'm telling. That's why unless and until it will come, then the court will record that and I will set aside and demanding to reconsideration and pass appropriate order. Neither the order will be renewed nor you will be in any difficulty.
Lord, I was suggesting that this writ petition could be disposed of. My lord, with time, they would reduce their total assets and financial assets and file an application
then we have
afresh.
to comply again because you have now increased the limit from 10 crores to 25
Lord, that
crores.
is a different matter altogether.
No, that's
That
not
is-
a different matter. That's the
that is
whole
net owned
purpose.
funds. That is net owned funds. We are with principal business criteria. My lord, these are two different.
I am on the question of, my lord, I cannot be, my lord, forced to comply, my lord, with criteria which, my lord, I never wanted. I have applied, my lord, on 26 March 2025. You have kept my petition hanging. And then again you come and say that, no, you increase it. Then when I insist on it, you say, no, I'm refusing your registration.
My lord will
I'm
kindly see
refusing
page
your
1 to
cancellation.
6. My lord will kindly see page 1 to 6. My lord, the application of 26th March was not allowed because of their own documents.
Correct. That's why I'm telling. So so I am not disposing of this application. Let they get the reduce the PBC.
Yes.
From 50%. Once they reduce, then let they file a supplementary affidavit
Very
before
well,
this court. Then the court will pass
Very well.
appropriate order. By the order of the court, it will be set aside. Then they have to consider the original application.
Very well.
Kindly provide for all that, my lord. Otherwise,
well.
my lord, it will be.
That will be better.
तो order of court है, 4 steps की करूँगा.
In terms of the order passed by this court dated 13th of January 2025, the bank has submitted its comments. The petitioner submit that if the petitioner is granted time, some indicated in terms of the order passed by this court dated 13 January 2026, the bank has submitted the comments in which clause 5 and 2 with in which serial number 1, answer to serial number 1 within bracket 5 reads as follows. And answer to serial number 2, query number 2, the answer reads as follows. I. Full stop. As the respondents is of view that for the purpose of voluntary cancellation, reducing the PBC to less than 50% while holding COR is not in conflict with the terms and conditions subject to which COR was issued to the company, as the company wants to voluntarily surrender the COR. Accordingly, the petitioner is given liberty to take necessary steps for reducing the PBC to less than 50% within a period of 1 week from date.
My lord, their investments, my lord, at least, my lord, 4 weeks, my lord.
Within 4 weeks? Within 4 weeks from date? And within 4 weeks from date?
Sorry, my learned friend correctly points out, my lord, the markets are also quite down. 4 weeks apart,
within 4 weeks from date. And when the reduced PBC is granted to the petitioner, the petitioner is liberty to file supplementary affidavit before this court after supplying the copy to the learned counsel for the respondent. List the matter.
My lord, only one, my lord, request. I'm sorry, my lord. This is in, my lord, connection, my lord, with my application dated, my lord, 26 March 2025. That's very important. Otherwise, my lord, they will say that no, you are not in compliance, and my lord will pursue.
File an application for reducing the PBC to less than 50%.
On 18 March 2025.
Less than 50% in connection with the application submitted by the petitioner dated.
My lord, 18 March 2025, which is at page 79.
18 March 2025.
Yes, sir.
18th March 2025.
Which is page 78.
2025, which is appearing at page 79 of the
78, my lord.
78. 78 of the present application. Once it has been reduced, once the reduced PBC is granted to the petitioner, petitioner is liberty to file supplementary affidavit disclosing the same before this court after supplying the copy to the counsel for the respondent. List the matter by way of supplementary bola na. List the matter on 17th March.
My lord, one thing, my lord. My lord, reduced PBC as certified by a chartered accountant certificate, my lord.
Yes, we'll give a choice. When we indicate, we'll give a choice.
Certified by a chartered.
Of course.
Reduce PBC as file supplementary affidavit by disclosing the reduced PBC as certified by the chartered.
Yes, absolutely.
Grateful, my lord.
This is the matter on
16th or my lord, 18th. My lord, can it be 18th?
18th? 18th? Okay. That's the heading to be mentioned.
My lord, can it be, my lord, a partly hard matter, my lord? Because then it can be disposed of on there, my lord. Otherwise, my lord, again, my lord, we'll have to.
Again, I am getting all these parted matters. That come on that day. I mean, March, nothing will happen.
This is the assurance, my lord, which we.
March.
My lord, kindly, my lord, make it.
It's already assigned matter.
Assigned matter.
Read matter.
Whatever, it will take 1 minute, my lord, before my lord. That's my lord, only reason. Grateful. Back. I'm grateful.
Vikram Birla.
The contempt application. The contempt application was by the chief.
Who filed the contempt application?
Oh, sorry.
You are the petitioner in the contempt application. And you are also filed the GA. And you also filed the petition, GA.
The new petition.
What is the GA for?
And yes, I'll point out, my lord, your lordship will kindly see after the content was filed, my learned friends. And they have, at first kindly comes to the order, my lord, will also kindly get the new application. And that is the first order is at page 23, my lord.
Yes.
Paragraph 19, my lord. Lordship will find me that page.
Considering the man agent assigned respondent restrained from posting any action. That one.
Now, my lord, obviously, my lord, they violate that. For the content petition, but kindly comes to page 57, rule was issued, madam.
47.
57.
57.
Para 4, madam, 58.
Para 4. This court finds that the alleged contempt is in spite of having the knowledge, the court has passed the entry of extended time. Yes.
Now, madam, he appeared after several occasions, madam. He appeared and madam will kindly come to page 59. Is the order of 26 November 2025.
Hmm.
And your lordship, madam, he surrendered. And then, madam,
Surrender the volunteer before this court. For the time being, warrant is kept in abeyance. Contender submit that he may be granted to 1 week time to file. Yes.
then para 3.
Contender namely, so undertake.
Henceforth, he will not publish any contents against the petitioner will appear with the court as and when required. Now, madam, on 1st of this month, we come across, madam, kindly comes to page 61. Again, madam, some kind of madam, publication against my client on his personal website now. Initially, that was being done on Facebook, madam. Now kindly see, madam, it's pariveshshukla.com. At the top corner, madam, where we generally write down the domain name, madam, and madam, kindly see, founder of Ralph Motor accuses Aditya Vikram Bill of fraud and fraudulent share transfer. So, madam, again, he is uploading and publishing the same thing in spite of the undertaking. So, madam, we have taken out this application, madam, your lordship, madam, for the purpose of restitution and also, madam, for punishment. Because, madam, today, madam, your lordship, madam, in spite of the undertaking given in the content petition, madam, this is happening. That's why it got the application for your lordship.
Yes. Who is appearing?
My lord, I am appearing for the alleged contempt. My lord, this is a changed brief. My lord, I have received it only today. My lord, even the Wakalatnama has not been filed by the learned advocate on record. My lord, kindly gives me 2 weeks to come back, my lord. I'll ascertain the facts and come back with all documents, my lord.
Why are you doing this? Because he has appeared in person, he made a submission, he will not do, and the court has recorded that again he has done. So, now you are appearing.
The third lawyer, I don't mind.
That's why. Now you are appearing every time. First he has appeared in person, then he have engaged the lawyer, then now he engage you, and he is doing this. How soon he will come?
My lord, kindly gives me 2 weeks to come back.
2 weeks.
But consider praise that event. At least this shouldn't be continued with publication.
Already there is an order. What?
Only for this one, paragraph 24 deals with 1st February. On the Saurabh Ganguly picture. Easy for identifying. It's got nothing to do with Mr. Ganguly. Yes, because he has also been, for some reason, also drawn into this. I don't know why. It's his case. If he wants to, we are available. But now we are pursuing Mr.
Ganguly has not got.
No, he is not as yet.
Yes.
My lord, in the first, my lord, in the contempt application, my lord, the pleadings are complete. The alleged contender has filed his reply, my lord. In this application, my lord, kindly give me time to come back and file my reply as well. In the meantime, my lord, I'll ascertain the facts and come back. And also file the
The
Wakalat.
contempt pleading completed?
Yes, but he's admitted.
Admitted. So why you have filed this? That can.
Because I wasn't too sure that they will be appearing. But again, it's a new. That's why I have to, madam. Because it's in this application.
The petitioner has filed the present application being Can 1 of 2026. Praying J1 of 2026. Praying,
whether they file the compliance report, but I'm not too aware of
praying for.
I saw your reply, affidavit in reply.
Praying to punish the alleged and the respondent for violation. Punish the alleged, punish the respondent by sending him and by imposing sentence for imprisonment, by violating the undertaking given before this court that he will not publish any contents against the petitioner, but in spite of the undertaking, the respondent has again published in its website, namely praveshshukla.com, on what is the date? On 1st of February 2026. 26?
1st February 2022.
1st February 2026, within inverted comma, with the photographs, with inverted comma, founder of Craft Motors accuses Aditya Vikram Birla of fraud and forgery in share transfer case. Inverted comma close. Full stop. And so appearing for the for the respondent, and prays for and submit that just he has got the instruction to appear in the matter on behalf of the respondents, and he prays for time to file wakalatnama and to file reply affidavit in opposition. Counsel for the petitioner submit that in spite of the undertaking given by the alleged respondent, time and again the respondent is publishing an article against the publishing the articles defaming the petitioner, and as such he prayed for an interim order in terms of prayer A of the present application. B, sorry. B or C?
But I will be happy with B, but the police will
C. Prayer C. Prayer C. At the learned counsel for the respective parties. Police stop. As the application is appearing in the first time, the respondent is given liberty, the learned advocate appearing for the respondent is given liberty to file wakalatnama within a week in the department. Full stop. The respondent is directed to file affidavit in opposition within 10 days. Within 10 days, reply if any be filed within a week thereafter. In the week thereafter, this the matter on on 26th February 2026. In the meantime, the respondent is restrained from causing any further publication or display any kind of defamatory statement or words or dialogue in any form or in any manner or in any nature till the next date of hearing.
May I like the compliance report? No, whether they filed the compliance report.
Content may declare. The learned counsel for the petitioner has filed reply to the compliance report. Let the same be kept in the record. Both contempt and the application be filed on 26th of February 2026 for hearing.
The next day might be that your lordship also consider the criminal contempt. I'll try and assist your lordship.
Let it come with the what instruction.
Yes, madam. Grateful, madam.
Compliance is not filed.
Then it is the first day after 20.
How in that? Where is your compliance?
Lord, I don't have.
Call the next one.
May I please your lordship? This is my application under review. Your lordship's judgment dated 8th August 2025.
8th August
2025.
Yes.
Dismissing my application where I have sought for revocation of the dispensation of the mandatory requirements of under Section 12A of the Commercial Courts Act. Now, at the time of filing of the application or even till 8th August, we never had the plaint. Despite repeatedly we requested serve a copy of the plaint. The plaint was served on us on 12th August after the judgment was delivered. From the plaint, it appears the pleadings that apart from a bare reference under paragraph 42, the entire plaint is silent as to why this there is urgency, because the plaint is silent as regards to the date of knowledge also. They refer first in paragraph 20 with regard to July 2024. Paragraph 20, page 37.
Where is the order?
Lordship.
Where is
The order is
judgment?
at page 56.
56. 8th August 25.
Lordship.
Yes. You are appearing for defendant number 2 and 3.
2 and 3.
Praying for revocation of the leave. Clause 12. Section 12.
12.
Yes. So how you are filing this review? On what ground you are filing the review application?
The review, because since we never had the occasion
Hmm.
to refer to the plaint at the time of hearing, certain facts which ought to have been
So
submitted,
without going to the print, how you filed it?
because at that point of time, because the plaint was not served by them, they were pressing for the application for injunction after getting the 12-way dispensation. So we filed an application that there is no urgency. We also wrote them letters, hand over a copy of the plaint, which was never done. They said, no, it's my prerogative. I will serve when I want. So finally, it was served on us on 12th August after the judgment. So if your lordship kindly takes paragraph 20 of the plaint,
20 of the plaint.
Plaint at page 37.
Yes.
The first reference to the cause of action first is at paragraph 20, that sometime in July 2024, the plaintiff was surprised to receive a notice from the Learned Mediation Center for mediation of a commercial dispute filed by defendant numbers 1, 8, and 9 against the plaintiff and defendant numbers 2, 4, and 6. This is the first reference. Thereafter, if your lordship takes paragraph 25,
Yes.
24. That on August and September 2024, they came to know of the arbitral proceedings, the main dispute, which was where the plaintiffs are not part of, as they were not party to that
Paragraph
agreement.
24.
23 onwards, upon perusal of the order dated 4th August, the plaintiff came to learn for the first time of the first arbitral proceedings initiated by the defendants in connection to the SPS, which is the share purchase agreement. However, none of the parties to the tribunal gave notice thereof to the plaintiff, in spite of being fully aware that 18% of the total shares were assigned to plaintiff, which is a completely false statement, because plaintiff only had an agreement to get the shares assigned. The shares were never assigned. So it's a completely false statement. Then in these circumstances, plaintiff addressed an email dated 11 September 24 to defendant number so and so. Defendant number 4, by its letter dated 18 September, replied to the plaintiff's email along with forwarding the copies of the AP-COM and copies of the plaint. The contents of the letter are incorrect and so and so. So by August and September 2024, the plaintiffs are aware there is another arbitration agreement, arbitration award. There is a section 34 which is pending. In that section 34, a sum of rupees 26 crore is deposited with the registrar, and they do nothing. They keep silent. Then, after all these were disposed of, if your lordship kindly takes paragraph 41, where the first they say the commercial 42. This is the only paragraph with regard to urgency, suddenly why the dispensation is required.
42.
42.
Yes.
There is at page 47.
Yes.
There is extreme urgency in the matter. By letter dated 12th May 2025, defendant number 1 has forwarded the order dated 9th May, made in SLP number so filed by it, from which it appears the defendant number 2 has been permitted to withdraw 19 crore 92 lakhs. So this is only because the Supreme Court has passed an order. He says that there is an urgency, but he was aware of it. This suit was filed in May 2025. From August 2024, he was aware of it, that there are proceedings, sums are deposited, matters are going towards Supreme Court, but he is silent. He never filed.
But the plaintiff has taken the ground, because as per the agreement, unless the amount is come to him, then only the amount. So that's why he was waited till the Supreme Court order. Once he find that the Supreme Court order, Supreme Court has allowed to withdraw, then immediately he has filed. That is the case which, as
Right.
far as I remember that.
Lordship is absolutely right. Here, your Lordship, my most humble submission is that for the section 12 requires that it's a mandatory requirement. It's a simplicity money suit. Since 2014 till 2024, 2025, while the suit is filed, for all these years, the plaintiff was completely silent. They paid. They never took any interest. They not even a single demand that you have assigned, I have paid, give me my money. Suddenly, once this money comes, plaintiff wakes up from the slumber. I need this money, comes to the court, files an urgency because on 12th September, I have received this letter, which I don't know how they have received because I presume it's a speed post because on 13th September, which was also surprise, the morning, the first item was before the executing court. We have annexed the order. The plaintiff appeared, but the executing court or the High Court did not entertain them. They said, Honorable Court said that if you have anything to say, go to Supreme Court. They don't go to Supreme Court, they file this suit. So today, everything could have been done or resolved if had they exercised the mandatory requirement of 12A. So since they were completely silent, and if your Lordship's judgment also on that, it's that only that judgment, Lordship at paragraph, the final paragraph, from 16. Lordship started dealing the issues from 16, and from 24, your Lordship came to the finding that in the present case, plaintiff has made out a specific case for dispensation on the pretext that plaintiff was not the party to the proceeding, wherein award was passed on 29 June 2023. Thereafter, after dealing with it, your Lordship, at the last line of paragraph 24, subsequently on 12th May 25, plaintiff came to know that from communication, defendant number 1, as per the order dated Supreme Court, has withdrawn a sum of rupees 19 crores. Then at 26, the Lordship decides that on receipt of the communication from the defendant number 1, plaintiff immediately filed the present suit. This court considered the urgency, cause of action, and the prayers made in the plain and did not find any reason to revoke the leave granted. This was your Lordship. But the fact that they came to know was in August 14 or August 2024. That part we couldn't address because the plaintiff was not handed over to us, despite even at the time of arguments, we repeated requestedly, but they refused. So if the cause of action, they know that from August 2024, this money is with the registrar, sleeping on that entire issue. I'm not on that why they have not made any demand for more than a decade, sleeping on that issue. So once suddenly, just because Supreme Court had passed an order, now my urgency has come, cannot be the ground for dispensation of the Section 12. So this is the only short point on which this review has been filed, your Lordship. So I am seeking that if your Lordship may kindly consider these submissions which are being made in the plaint. So this dispensation which has been granted by this Honorable Court ought to be revoked. Because on 18th September, they had all the papers. By 18th September, they had all the papers. And if your Lordship may also see that page 69, since 2014, they were aware that there are disputes between the other groups in the company where the emails were also written and where they were copy marked, the plaintiff's director and the plaintiff, which is at page 69, those emails. Though 2014. So since 2014, plaintiff knew that there are disputes going on with the other shareholders. If your Lordship may kindly allow me, at page 69, the email is from Jagdish Shada, which is defendant number 3, to Prakash Damani, another share purchaser, and RVNL _ Rajiv at Hotmail is the plaintiff's director, Rajiv. Prakashji, there is no Cold War. I'm still talking and going to DSM and his office, and definitely when called, there may be business differences for which you had intervened and concluded on the issues. We are making our own assumptions and interpretation. You need to clarify what you had said. Of course, that if anyone does not listen, you and Rajiv can definitely tell me. And in all our previous meetings, even DSLA has said the name. So all these things, they were all part of the disputes, and they were trying to intervene and get the resolve between the two warring groups of the shareholders. So today, they can't just say that we are not aware of anything, and suddenly, just because they have communicated, now I am in great urgency. In reply at the bottom, if your Lordship says, in spite of my best effort, dear all, in spite of my best efforts, I could not be able to settle the differences between DSM and JS. The Cold War between them has damaged the trust and spirit of partnership. It is impossible for me to continue in this partnership. Thus, I would request you all to give me an exit route. In last 3 years, I had a wonderful time. So they were aware of everything.
July 2014. Yes.
And this is of July 2014.
Correct.
Para 43. And if your lordship just, my learned junior wants me to just refer to once, para 43 of the plaint, the defendant number 1 has instituted CS 764, which is another suit which has been filed prior. Page 47, para 43.
43.
43, paragraph 43.
Yes.
The defendant, they say that the mediation is not required, but in another suit, defendant number 1 has filed a suit where the defendant number 1 has instituted CS.
That's why in that he has made a prayer that he can he already deposited the money, it can be taken out.
No. In that suit, the release are mostly against the plaintiff and the defendant number 1. The plaintiff has filed his written statement there. I am a party, but I have not filed my written statement because the prayers technically doesn't bother the applicant here. That's why we have not also gone for the mediation. But that cannot be a ground for another suit of another cause of action that look, in that suit they have not appeared in mediation. So this suit I am not opting for mediation. The mediation will be a futile exercise. That cannot be the ground.
Okay.
So these are my short submissions. If your lordship may kindly consider these, and the order may be revoked.
Yes.
Not much to say. My learned friend should have told your lordship when he placed pages 68 and 69 that these are not part of the plaint.
That's it.
And there is no explanation why he did not rely on these emails when he made his application for revocation of the leave which was granted under section 12. 68, 69, your lordship sees the narration at paragraph 6 of his application. I'm sorry. These are emails which are referred to in paragraph 11, sorry. Plaintiff has also suppressed the communication between the parties, wherein the director of the plaintiff, Mr. So-and-so, was aware of the dispute that had arisen in which defendant number 3, who had issued an email expressing his displeasure in the manner in which 5, 7, director of the plaintiff were conducting themselves, participating in all meetings. There's nothing to do with my money claim. He's saying I was aware of disputes inter say the shareholders. And that is also not on record. It's not part of the plaint. If he wanted to rely on this document, he has to show under the provisions of review that something prevented him. Where is the cause shown? That without that in spite of exercise of due diligence, kindly see. He has to show. These are emails which he has. He says, I have suppressed. But then he has to make out a case why, in spite of exercise of due diligence, assuming not admitting that these emails are at all relevant.
Yes.
He has to show why, in spite of exercise of due diligence, kindly see, any person, any person considering himself aggrieved by a decree, etc., and who, kindly see, who from the discovery of new and important matters or evidence, which after the exercise of due diligence.
Where from are you reading?
Order 47, Rule 1, please, my lord.
47, Rule 1.
Yes, please, my lord.
Yes.
And who, your lordship sees, and who from the discovery of new and important matters or evidence, which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or order was made. So there's no explanation why these emails were not disclosed by him if he found these emails were relevant. He is saying, I have suppressed. A, these emails are irrelevant. But 2, why he did not disclose them in his application, there's no explanation.
I thought it would be part of it.
Now, my lord, he said, he draws your lordship's attention to the paragraphs of my plaint. Kindly bear in mind, my lord, this order was made in GA3. What I did not argue, which I should have, which the coordinate bench pointed out to me when arguing GA2, that how could GA3, which is an application for revocation of 12 leave, be filed after he has filed a section 8 for stay of the suit. GA2, without having a plaint, just to avoid the interim injunction, which is GA1, this defendant goes to the length of filing GA2, which is for stay of the suit without having copy of the plaint. Then he becomes wiser, he files GA3 for revocation of section 12. So if there is no section 12, where's the question of section 8 being entertained? Now kindly see, he says that I did not have the plaint, therefore I did not know all this. He should show your lordship GA2, which he filed on the basis of my petition, which was served on him. All these paragraphs are stated in my interlocutory application. Except, my lord, paragraph 46. Except paragraph 46, all these paragraphs are stated in GA3 because the plaintiff is reproduced in the interim application. That is GA1. After receipt of which he goes and files GA3 without having a copy of the plaint.
Where is the GA? You are not disclosed.
Why is he not disclosed his GA3, which was rejected?
It's not disclosed here.
GA3 is
Not disclosed here. Because this application is
GA3 is the application.
This order
which
is
has been
disposed of.
dismissed.
This order is passed on GA3.
GA3, yes. Let him show GA3.
Where's the
GA3 annexes the petition,
Correct.
which has all these paragraphs of the plaint, which is now saying I did not know have. GA3 টা hand over করো না soft copy.
তুই প্লেন যদি সার্ভ করে দিস তাহলে ঝামেলা
আমি প্লেন্স না সার্ভ করলে তুমি অ্যাপ্লিকেশন বার করে দিলে বাহ
ও GA3 is not here. If your lordship wants, I can share the soft copy.
Yes, give the soft copy. No difference. Now, can you see what does paragraph 43 say? Can you see the third sentence? The defendant number
43 of plaint.
Of the plaint at page 47.
Yes.
The defendant number 3 will take advantage of the delay caused by mediation and withdraw the monies deposited in this honorable court to defeat the claim of the plaintiff. This is the urgency which was cited and has been appreciated by your lordship. GA3 was decided on the basis of the petition. All these was served after the petition was filed.
The master summon. Where is the affidavit? This is there.
All this narration of facts which your lordship found was on the basis of the petition made in GA1, which your lordship finds in the order, which is under review now. And there was an opposition, there was a reply to this. This was after pleadings. You're absolutely incorrigible. क्या करेगा? All these facts which are which my learned friend narrates, kindly see your order. My lord's order records all these facts. Mr. Banerjee's submissions are recorded. Kindly see paragraph 4 of the order under review. Abuse of process, my lord, with the greatest of respect. Kindly see, Mr. Banerjee submits that the plaintiff has filed the instant suit by the strength of an arbitration proceeding filed by the defendant number 2 and 3, and an award was passed in favor of defendant numbers 2 and 3. Applications under section 34 of the act were filed, but the same were dismissed by the judgment dated so and so. He submits that thereafter an appeal was preferred under 37 and the appeal was also dismissed. He submits, now kindly see, he submits that the plaintiff had the knowledge with respect to the award dated 29 June 2023, exactly the same paragraph which was shown to your lordship, but the plaintiff has filed the suit in the year 2025 after the period of 2 years from the award, and thus there is no urgency. Cause of action, then kindly see, my lord, paragraph 5, he relies on Dhanbad fuel. The court has to see the cause of action and the prayer for urgent relief. He submits that in the present case, the cause of action alleged to have arisen in the year 2023 and the plaintiff has filed the present suit in the month of May 2025. As such, it cannot be said that the suit was filed by the plaintiff in contemplation of urgent relief. Then all these facts which are narrated in your lordship's order in great length are on the basis of, kindly see by referring the memorandum, because GA1 was then considered by your lordship and all these narration of facts is from GA1. Kindly see paragraph 12 at page 22, where your lordship has been pleased to record my submissions. Mr. So-and-so submits that being aggrieved with the order passed in an appeal under section 37, so-and-so had preferred the SLP before the Honorable Supreme Court, whereby by an order dated 9th May the 9th May 2025, Honorable Supreme Court has passed an order permitting the first respondent to withdraw the principal amount of 19 crores 92 lakhs from the registrar of this court. It was further directed that the registrar remaining amount shall be invested by the High Court fixed deposit. Defendant number 1 has received the amount as per clause 9, ought to pay the amount to the plaintiff but has not paid. Accordingly, on 14th May, the plaintiff has filed the suit. And the letter of 12th May is referred to.
Yes.
So GA1, in which all the facts were narrated, were considered by your lordship. They placed the application on the basis of GA1. GA1 is a reproduction of the plaint except paragraph 46. And all these facts were duly, whatever they thought relevant, they placed. There is no case for review made out, my lord.
Firstly, why I have disclosed the email here and not there? Till the plaint is served, I am not aware what are the exact annexes of the plaint. Today he is saying that it's reproduction of the GA1. The GA1 is reproduction of the plaint. But unless I receive the plaint, it is not possible for me to know or ascertain in any manner what is there.
So
any
if-
application, it can be a summary part of the.
If suppose the court will go by your statement, yes, the plaint was not there. If the plaint was not there, so how you have filed an application GA3 for revocation of the leave without the considering?
Yes.
Because as per the settled position of the law under the section 12A, the court has to consider the pleading, cause of action, the prayer, then the 12A has to be given. And you have filed an verified petition affidavit containing about 19 paragraphs, 22 paragraphs. So without and you have not stated, there is no argument on that. Yes, you have prayed for the not to take this application unless the prayer is the plaint has been served to you, Mr. Banerjee, because I appreciate this matter was taken after about 1 or 3 or 4 days continuous hearing. Then
And no, even during course, we insisted that the plaint has not been served. We wrote to them. Even then, Mr. Thakkar's submission was, I will serve plaint as per my convenience.
no, that is why that also I am clarifying. It is in the court. There was a altercation between the parties because you persons wanted the plaint to be served so they can.
We can address on
But
plaint.
but they have taken you have taken the leave from the court to verify the plaint.
No, plaint was not. Plaint your lordship,
see the plaint and
your lordship, in course of argument, plaint was referred.
Okay, whatever that I am not going into that.
Right.
Okay.
So
we got an order. The defendant has filed the present application. Defendant number, co-defendant.
2 and 3.
Defendant number 2 and 3.
2 and 3.
Defendant number 2 and 3 filed the present application GA Com 1 of 2025. Praying for review of the order judgment passed by this court dated 8th of August 2025 in GA Com 3 of 2025 in CS Com 70 of 2025 within bracket Tirupati Vencom Private Limited versus James Glenday and Company Private Limited and others, wherein this court has dismissed the application filed by the defendant number 2 and 3 for revocation of leave granted by this court under section 12 of the Commercial Court Act. Full stop. Counsel for the defendant number 2 and 3 submits that the in the plaint submit that at the time of hearing of the application being GA3 comma so was not with the defendants, and as such the defendant could not refer the plaint. He further submit that after the dismissal of the said application, comma, the plaintiff has served the plaint, and after going through the plaint, comma, the defendants number 1 and 2 came to know that in the plaint at paragraph 20, 23, 24 and 25, The plaintiff has categorically admitted that the plaintiff had the knowledge about the dispute with regard to the amount claimed by the plaintiff, but the plaintiff failed to file the case and all of a sudden in the month of May, when he filed the suit? May 2025. May 2025 has filed the instant suit, and this court has granted leave under under section 12 of the Commercial Code Act 2015. Counsel for the and the defendant number 2 and 3 has further draw the attention of this court to the emails dated 14th July 2014 and submit that from the email it is also proved that the plaintiff had the knowledge with regard to the dispute, but the plaintiff has not taken any steps for filing of the suit for recovery of the money. The plaintiff further submits that, and the defendant number 2 and 3 further submit that the plaintiff in paragraph 42, in paragraph 43 has stated that the defendant number 1 has instituted the case being CS number 64 of 2024, and as such there is no requirement of institution of the pre-mediation. He further submit that the suit filed by the defendant number 1 in others cannot be correlated with the instant case, and if ought to have initiated the mediation process before institution of the present suit. This court has he submit that there is error apparent on the face of record, as this court, while rejecting the application filed by the defendant number 2 and 3 being GA3 of 2025 failed to consider, has not considered that in the plaint itself the plaintiff has admitted with regard to the knowledge of the dispute, but the plaintiff has not initiated the case, initiated the suit, and only in the month of May 2025 the plaintiff has initiated the suit without initiated the pre-mediation process. Per counsel, an advocate appearing for the plaintiff respondent submits that this court, while passing the judgment dated 8th of August 2025, have categorically recorded the statement submissions made by the counsel for the respective parties. He further submits that in paragraph 4 of the judgment, this court has recorded that the plaintiff has submitted, and the defendant counsel for the defendant number 2 and 3 has submitted that the plaintiff had the knowledge with respect of the award dated 29th of June 2023, but the plaintiff has filed the suit in the 2025 after the period of 2 years from the award, and thus there is no urgency. He further pointed out that in paragraph 13, this court has also paragraph 13 of the judgment, this court has also recorded that the defendant number 1 has received the amount as per clause 9 of the memorandum of understanding, and the defendant number 1 ought to have paid the amount to the plaintiff, but the defendant number 1 has not paid the said amount. According, the plaintiff has filed the suit on 14th of May 2025. He further submit that this court, while passing the judgment dated 8th of August 2025, have considered each and every aspect and passed the order rejecting the application for revocation of the leave, and thus such the review application, and thus there is no error apparent on the face of the record. He further submit that the email which the defendant is now relying upon, which is disclosed in the present writ application page 68 and 69, comma, the said document has not been was not been disclosed by the defendant number 1 and 2 in their application. And in the present application, the defendant number 1 and 2 also not shown any cause why the defendant number 1 and 2 has not disclosed the said application, and as such, this said document cannot be taken into consideration in the review application. Full stop. Heard the learned counsel for the respective parties peruse the materials on record and the judgment under review. Full stop. The defendant number 1 and 2 have filed the application being GA3 of 2025 in CS Com 70 of 2025, praying for revocation of the leave granted by this court under section 12 capital A of the Commercial Code Act on the ground that the plaintiff has admitted in the plaint that the plaintiff had the knowledge with regard to the dispute since the year 2014 and subsequently he had also knowledge about the arbitration proceedings and the SLP filed before the Honorable Supreme Court, but the plaintiff has not taken any steps of filing a suit. But immediately, all of a sudden, the plaintiff has filed the suit on 14th of May 2025 with taking leave from this court under section 12 capital A of the Commercial Code. This court find that at the time of that this court, considering the total considering the pleadings of the plaintiff plaint, comma, prayer and the cause of action comma, this court has not inclined to revoke the leave granted under section 12 capital A of the Commercial Code Act. In the impugned order dated in the order under review, this court has categorically recorded that the plaintiff has made out a specific case for dispensation of the provisions of section 12A of the Commercial Code Act on the pretext that the plaintiff was not the party to the arbitration proceeding initiated by the defendant number 1 and 2, wherein an award was passed on 29th of June 2020. Subsequently, the parties to the arbitration have filed an application under section 34 of the Arbitration and Conciliation Act 1996, challenging the arbitration award. After the dismissal of the application under section 34, an appeal was filed under section 37 of the Act. The defendant number 1 has also instituted a case under case in CS Com 764 of 2024 for discharge of his liability to pay the amount to the plaintiff, as the defendant number 1 has deposited the said amount with the registrar of this court. Subsequently, on 12th of May 2025, the plaintiff came to know that from the communication of the defendant number 1 that as per the order passed by the Honorable Supreme Court dated 9th of May 2025, the defendant number 2 has withdrawn the said amount. Accordingly, this court was of the view that only on the plaintiff was waiting for the decision of the proceedings of the arbitration decision of the appeal pending before the Honorable Supreme Court with regard to the arbitration proceeding. But in the meantime, the Honorable Supreme Court has allowed the defendant number 2 to withdraw the said amount, which withdraw the said amount from the registrar of this court. But as per the suit filed by the defendant number 1, the amount is to be taken out by the plaintiff. When the defendant number 2 has taken out the application, immediately the cause of action was arose and the plaintiff has filed the suit by taking leave from this court, taking leave from the court under section 12A of the Commercial Code Act. Considering the above, this court finds that there is no error apparent on the face of record and there is and the application filed by the plaintiff is misconceived and defendant number 1, 2, and 3 are misconceived. According review application is dismissed.
Grateful, my lord.
2, 3, 2 and 3. 2 and 3. जो जगह होगा ना defendant number 2 and 3 का.
Grateful, my lord.
Yes. J1 disposal.
Good.
ना दोनों J1 क्या है? Interim है. Interim क्या है? 3 to 5. Setting.
Yes. Along with the affidavit.
J1 and the review.
Your Lordship has called item number 5, no?
I'm opposing number 5.
That I am for the petitioner. Your Lordship will permit me to address your Lordship virtually today. I'm not well. I've not been able to come to court.
Yes.
That I was only praying. This was my application is coming up for the first time. If you could come back on the 5.
5 or 6. This is number
6. 5 is over.
5 is over. 5
6. 6. I'm sorry. 6.
I can give my opposition immediately, though I can do without opposition also, but then within a week I can give my opposition.
No, Milord,
So,
we'll be praying for some interim orders in this at the ad interim stage. Milord, I was only beseeching your Lordship if it could be taken up on the 18th of February.
For that I shall give my affidavit and I shall.
No, Milord, we'll be.
Let the affidavit completed. I will dispose of the J1 itself.
On the 18th.
Very
How soon you file the affidavit?
By next week. Well, by 11th.
You are on 5. By 12th.
By 12th.
And you file affidavit in reply 19. So then I will fix the matter on 23rd, 24th.
Milord, then may I only pray for this? Milord, instead of the 18th, could I come on the 11th? Milord, before affidavits, I'll be making for some prayers. Milord, there's a blatant fraud.
Kudha Billah dispute. Once again, they brought it up.
No, Milord, I'm entitled to ad interim prayers. Milord, I'm just praying for a week's time. If he can give his affidavit by the 6th, then it's
dismissal
fine.
on the next day. Okay. If it's 11th, I shall give my opposition before the 11th. Lordship kindly keep it. 11th, then I shall give my opposition by 10th.
No, then I'll have to give a reply. Milord, he'll not be entitled to an opposition as a matter of course. I'm entitled to ad interim. Lordship will keep it, kindly consider it could be kept on the 11th. I'll come. If your Lordship feels that it, because anyway, his application is there on which he's obtained the order.
Recalling of my order.
Yes, no, recalling of an order passed by your Lordship in execution, where an application was filed, deposed the decree. And your Lordship was induced to believe that the parties had settled it and therefore it was done. Well, whatever his application is worth, it was worth on which he's taken the order. Whether he's entitled to an affidavit to further explain that application is a matter of arguments. Kindly keeps it on the 11th. We'll come back and trouble you.
If it's 11th, I shall give my opposition by the 9th.
This opposition, whether he'll be at the.
Then your counsel for the respondent, what?
Respondent number, the decree holder.
Counsel for the decree holder press for time to file affidavit in opposition. Counsel for the judgment debtor. You're the judgment debtor.
No, he's the third party.
No.
Third party.
I am actually the decree holder. Interloper has come and obtained that order.
You're the decree holder.
I am the decree holder. Someone else has come claiming to be my representative and has come and obtained the order.
That daga. Okay, this is an application by Krishna Damani.
The decree holder and the counsel for the applicant raised objection submitted. There is an urgency and press for interim order. This court fully stop. Consider the submission made by the counsel for the parties. Let the affidavit in opposition be filed by 10th of February 2026. Reply, if any, by 13th of February 2026. Release the matter on 17th of February 2026.
Only one prayer, one indulgence, considering I have a temperature. Instead of the 17th, it could be the 18th.
And it's your urgency. It's your urgency.
One day.
18th.
One day. Grateful to Lordship.
Item number 7.
7, my lord, I appear for the plaintiff, my lord.
Recalling application.
Application for recalling, my lord. I would humbly praying, my lord, if I may be granted an opportunity to file my affidavit in this.
Who has filed the application?
My lord,
Where is the order?
my lord, your lordship's order of 12th June.
12th June issues.
That was not done. The matter was made to go out of it. Thereafter, the matter did not appear at any point from 2000, the last order is 26. The matter was never listed. Before it comes, it is transferred to the commercial. My learned senior friend, my allegation is that the notices for mentioning of the matter those were not received by my advocate, but sent to some other advocate, who was the erstwhile advocate, where we had only entered the matter.
What you want? Why the review? Why the recalling? Yes, 2012 you not disclose. What can be done? What?
My application, I stated short paragraph 6 and 9, I stated that when the matter, because from 2016 24, the matter was never in the list. But under the bona fide impression that the matter was in some form disposed of.
Mr. Mukhopadhyay, you are the regular advocate appearing before me in the original side, and how you can say that you are not under the impression, you are not the impression that the matter will be taken up by this court?
Nothing has happened in this, and what further?
Yes, what will happen if the inspection is not carried out? Okay,
Your
this issue
lordship, my lord.
I will not touch the issue. Let the inspection be carried out. What?
My lord, your lordship would kindly see this application has come up in January.
Whatever
The
it
order
may be,
passed.
whatever it may be.
No, the order
If
passed.
suppose the court is granted for inspection, I am not allowing this. I am keeping it, but giving a liberty to inspect the document. Come with the next date. How? Can it is possible?
My lord, matter has been proceeded with. My lord,
What is the stage of the suit?
My lord,
Evidence is started.
Evidence date was fixed.
Evidence is started.
my lord, I have taken out an application because documents have been misplaced. My lord, the matter was taken up today, my lord. Due to my ill luck, my lord, the honorable judge was pleased to. The honorable judge was pleased to release the matter on personal ground this morning, my lord.
They have filed an affidavit in that also.
My lord, the affidavit in.
And this is a defective application. No,
Two persons are giving the one or
Lord,
the other clue to the one bench, and
Your lordship would kindly appreciate one thing, my lord. There is no prayer for a delay of condonation of delay.
No
Admittedly, my lord, 7 months have passed by before your lordship's order was passed. My lord, no pleadings and no prayers, my lord. I'm carrying my limitation act, my lord, which says 30 days time is for. Your lordship, my lord, keeping the point of maintainability open, if your lordship kindly grants me a short period of 10 days, I will come back with an opposition. For affidavit in opposition, because this is not maintainable without a, my lord, a prayer for condonation of delay.
No, not explained. No prayer is
There's no prayers there. Your lordship would kindly consider the prayer.
where is the prayer for this delay in filing the recalling application?
There's no separate this is original side.
No, prayer has
Sorry, original side cannot go beyond the limitation act.
Original side without
My lord,
without prayer.
goes beyond the limitation act, my lord.
Good.
That is my.
Court is not telling the limitation is not applicable to the original side, but it is not that in the original side no prayer is required for the. Don't think I am not practicing the original side, but some normal thing I can know.
Absolutely, no question.
Okay, let me file the application.
Point of mentality to be kept open.
Counsel for the. You are for the defendant.
I'm for the plaintiff.
For the plaintiff. press for time to file affidavit in opposition in connection with GACOM 4 of 2026. Let affidavit in opposition filed by
10 days, my lord.
10 days, reply within a week thereafter. Let the matter appear on 5th March.
Lord, your lordship could be kindly pleased to keep the point of maintainability open
Counsel
because
for
this.
the plaintiff raised the point of nature of this application, the same is kept open.
Lord, I'm deeply obliged.
Okay, okay. Let the affidavit complete.
Deeply obliged.
You explain in your reply. Next. Yes. Opposition affidavit filed by 21st of January after serving the copy. The way subject to payment of cost. Who is appearing for the? You are for? Huh? Person by petitioner or contemner? You are the petitioner. Huh? You are the petitioner plaintiff number 1. Who is for the contemner number 1 to 6?
Lord, I appear on behalf of the respondent numbers
1 to 6. Let me understand who is appearing. Let me understand, then I will come to you. So you are appearing for 1 to 6. What about the 12, 7 to 12?
8 to 12, I am appearing.
7 and 12.
7 and 12, I am appearing.
Oh.
7 and 12, I am appearing.
You are appearing. And 13?
13, my lord, I need to appear virtually, my lord. I am appearing.
Okay. So all are.
I am appearing virtually, my lord.
Yes. So who has filed the affidavit in opposition? 1 to 6. 1 to 6.
1 to 6, my lord, have not filed their affidavit in opposition for only for one reason, lord. There were certain deeds that were executed by them. These deeds were, my lord, in the teeth of an order of injunction. It appears that there was some miscommunication, as a result of which they could not understand the import. There are 2 contempt petitions pending. One before your lordship, lord, in connection with one phase of the injunction order. The other before Justice Kaushik Chando in connection with the other phase of the injunction order. One is initially when it was passed. Second is when it was made absolute. So contempt petitions are running parallelly before both the honorable forum. Now, my lord, before Justice Chando, my lord, we've appeared. We've candidly confessed that these we were not within our knowledge or there was some misunderstanding. And in order to purge ourselves, because before we say anything on oath, including seeking an apology, it will be a blank apology, my lord, if I do not undo the actions that I have done. Therefore, I have advised my clients, and my lord, we would humbly inform your lordships that out of the 6 deeds that had been executed in the teeth of the order of injunction, where there was an order not to create third-party rights, 2 have already been cancelled. And cancellation instruments have been made, Lord, before the concerned registrar in Muzaffarnagar. I mean, there I have documents for 2. Remaining 4, the process is underway. It's only after that I get all those 6 deeds cancelled that I hold the stand, Lord, of coming before your lordship and saying a word. Today I can't even utter a single word. I have no defense today. Kindly permit me.
Yes, 7 and 12. 7 and 12.
We are on the process of cancelling it.
Huh? You are also pursuing the cancellation on the deed. And 13?
My lord, 13, I am the authority before whom the documents were placed. And I was not aware of, my lord, I have already filed my affidavit. And my lord, if the instrument comes, my lord, I will take necessary steps so that your lordship's order is upheld, my lord. This is what disclosed also.
And my lord, we had made our position clear, my lord. The authority there was not allowing a reconveyance because of the fact that it was apprehensive because it's a party in the contempt. Coordinate bench has been pleased to clarify that in the event we undertake any action of reconveyance or the like, the concerned registrar will extend his cooperation. In the light of that, my lord, already 2 deeds have been cancelled. 4 are yet left to be cancelled. It's only after I have all 6 cancelled and immediately that I have a right of audience. Before that, my lord, I have no defense.
My lord, I have one submission.
Argument I will come later on. Let the affidavits come. What was the direction? I am asking you, tell me what is the direction?
to pay 40 lakh, 7 lakh, till the total, till the my lord, after my lord, deposit will 80 lakh to the restaurant before the ordering right, as well as third rejection was my lord. Like they were likely to submit the profit and loss account and did not my lord. As well as the first rejection was. The order was met absolute, they took that to anything and the total of fraud on the month of 18th of 11. Since the crystal of order.
So
Kindly allow me at least, my lord, since 1 to 6 they are, that is the special property of business by lord, that we are covering. And they have sold out to the 7 to 30, 7 to 12. That is the very start. And summary, we are not getting a student. Side addiction, passed by not by lord. We are not can go through the short of argument to get short the pattern to so that this is available to his daughter to pass out the
where is the order?
my lord, order is and the order is my lord at page 76, my lord. Dr. Kali jump to page 8. That is started from page 76.
So this is, what about this 40 lakhs? The court finds the defendants are ready to pay rupees 40 lakhs each to the plaintiff, but the installment and the according, yes, who are they in the who are the party? Defendants? Who are the defendants?
2 to 7. 1 to 6.
2 to 7.
2 to 7.
This one.
Number 2.
2 to this one. So you are appearing, Mr. Banerjee. So what happened to this order?
As far as these amounts are concerned, I am told, my lord, that there would be an application, my lord, seeking recall, something which I have resisted doing now, because first of all, there are two limbs of this alleged contempt. One is contempt on the face of it, there has been conveyance of a property by there being an order of injunction.
Correct.
Now that there is absolutely no defense until I come clean. There also thereafter there may not be a defense. I may still be sent to prison. I was wanting to show that I am in a position to purge myself of the contempt there and come up and answer to your lordship regarding that part. Regarding the other part, here is the classic case between the tenancy and the business. The business was a proprietorship business. The tenancy was a hereditary tenancy.
No, whatever it may be,
Now, I'm trying to therefore explain why that 40 lakhs of rupees we said that we'll pay. The plaintiffs have challenged the award and defendants have said they are ready to pay. There is there is a bit nebulous thing here, because the award that was made on the basis of law and understanding, where the parties proceeded on the wrong basis that the business itself was a hereditary business. Business was not a hereditary business. Tajri Dawakhana is the personal business of my immediate ancestor, and from there, Milord, we have got the property. Now, therefore, this is for us to explain. I have deliberately, Milord, and at the risk of being reprimanded by your lordship, refrained from putting in even a line of explanation today until I have purged myself of the contempt on the face of it. There's a contempt on the face of it, and there's a miscommunication in that. Now, Lord, I want to purge myself of that and then explain the situation to your lordship, which might show that I will not be guilty of deliberate or willful violation of the court's order. 40 lakhs that was directed to be paid is in respect of an award which the plaintiffs have challenged, and the defendants, if your lordship can see page 5, learned counsel for the plaintiffs submits that the plaintiffs have challenged the award. And if the defendants are ready to pay the said amount, the same may be deposited over the register original side of this court without prejudice to the rights and contentions of the plaintiffs. He further submits that the defendants are taking benefits of all the properties, etc. Now, my lord, on the basis of that, the Honorable Court was pleased, my lord, to direct that The plaintiff said if they want to deposit, let them deposit. But we are not accepting that deposit because we have challenged the award. Now this makes the entire substratum slightly nebulous.
That's correct, but there is
But it has ultimately translated into an order. I am not, I telling you.
So this order is now.
As far as this order, compliance of this order is concerned, I will explain out why, according to me, Milord, this order would require a revisiting. But I can't do that until, Milord, I have purged myself of the contempt on the face of it. Kindly permit me to purge myself clean of that and come back to your lordship. 2 out of 6 deeds have already been cancelled. The remaining 4, I am told, will be cancelled within a month. Justice Chanda has been pleased, my lord, to grant my lord some time and make the matter returnable on March. I am not suggesting for a moment that my lord will give me a similar benefit. But my lord, if your lordship can see Justice Chanda's order just once, I can make it returnable slightly later. One.
Yes.
There also the question arose as to what should be done. Now,
What is the matter before the Justice Chanda?
there initially the interim order was made, that interim order was made absolute by your lordship. Now, because now a double contempt has been filed. One there because they say that during the pendency of the interim order, some deeds were executed, and before your lordships, because after the order was made absolute, some deeds were executed. Now, I am not going into that question. I would not try to argue something that it is quasi-criminal and therefore it's not proved against me. I am not on that. This is contempt on the face of it, according to me. If I do not purge myself of contempt, I do not have the right to make a single defense. Therefore, Lord, kindly permit me to come back after a month.
So what has happened to the my 14th January order? They have not filed the affidavit.
The earlier
how you can file further? There
I
is a
cannot
condition.
file further, Lord. As far as the affidavit is concerned, affidavit in answer to the rule. If a rule has been served upon me, Lord, I have lost my chance to file an affidavit in answer to the
You
rule.
lost already. They are not filed. In
Yes,
spite
they-
of the direction, they were
Yes,
responding.
my lord, why I have not filed, Lord, I'll tell you, Lordship. Why I have not filed, I'll tell you, Lordship. Lord, initially, perhaps, the Lordship may recall it took some time to get all the persons served. Then they have come up. Today, my Lord, my humble prayer before your Lordship is kindly permit me to purge myself of the content on the face of it and explain. Then, Lord, if I can't explain, Lord, I'm before you. But if my learned friend wants to say that an award out of which he does not himself admit the correctness of the award, he has challenged it, and the 40 lakhs of rupees he says ought to be made in terms of the award, which he has made an order of court, then I will be required to explain out that position, Lord, and place the facts before the honorable court, Lord, for your lordship's time. I am not for a second suggesting that I have an unlimited right to file an affidavit in answer to a rule. But I would perhaps try to explain my conduct in regards the second part of the order and seek recall of that after I have purged myself of the first part.
Which order?
The second part where my lord has directed Lord the 40 lakhs to be paid in installments, that comes out of an award which is under heavy dispute even by the plaintiffs. They are not admitting, they are saying that one part of the award which is to their favor, they are saying
And with regard to the monthly maintenance allowance of 20,000.
it's also something which goes on the premise, my lord, that the business, my lord, is a ancestral business. The business I can show from the papers on record is not an ancestral business at all.
But your
My advocate, I'll tell you, Lord.
It's an appear before the
My
court
advocate
made
was
the
present.
submission.
Therefore, Lord, it's ugly the way I'm trying to explain. It might turn out to be ugly. I was represented by.
See,
My lord, I'll tell you, Lord. I'll tell you.
See, Mr. Banerjee, let this court proceed with the contempt because you are not. Then let they come and go to the appropriate place. Then you take appropriate steps because the order is staring in the face. The order is staring in the face. You have not filed any application for review. You have come before this court and undertake that you file the affidavit. You have not filed the affidavit. Now you are taking the another stand, and this order is of which date? September 2024. Now we are on 26. So you take whatever step. Let them. I am passing an order to let them surrender. Otherwise, I will pass because you lose your chance to file affidavit. You are also not filed on 14 January. This court has given chance to file affidavit subject to payment. That has also not been complied with. So this court is no other way to pass appropriate order for conviction. Nothing else.
There'll just be only one submission which I'll
record an order.
I'll just one humble submission. One humble submission which I'll make. There are two aspects of this order.
Maybe, sir, 2 aspect, 3 aspect. As on date, what is the order before this court? This court has to consider that. What will happen tomorrow? What will happen day after tomorrow or after 1 year? This court cannot consider in the contempt application. And your client is not so diligent to whatever the every day they could have been filed the report. Yes, I have taken this stand, I have taken this stand, I have taken. Willfully, you are not appearing before this court. When on the last occasion I pass an order for cost of rupees 10,000. Now today you are appearing. On the last occasion there was a halla gulla, but you persons are not there. Record an order. The petitioner has filed the present contempt application on the allegation that the alleged contemners, content number 1 to 6, have violated the order passed by this court dated 25th of September 2024, wherein this court has directed that the defendants shall pay rupees 40 lakhs. Which who will pay? Yes. Who will pay? The defendants क्या बोला? Rupees 80 lakhs with the registrar original site in 6 installments of rupees 13 lakhs in 6 installment of rupees 6.5 lakhs each from the month of October 2024 till 31st of March 2025, and the last installment would be rupees 15 lakhs. Last 13 lakhs. 24 March 2020, and last installment would be rupees 15 lakhs within bracket 7.5 lakhs each. This court has further directed defendants to pay the monthly allowance of rupees 20,000 to the plaintiff number 1 and rupees. You come and dictate. And rupees 1,15,000 to the plaintiff number 1 only up till November 2018, and thereafter the defendants have not to pay any monthly allowance. It is found that the defendants have neither paid rupees 80 lakhs nor are paying any monthly allowance, nor have paid any monthly allowance up till the month of November 20. Have not paid the monthly allowance and directed by this court. This court have after issuance of the rule, the contemners have appeared before this court in person and pressed for time to file affidavit in opposition. This court has released the alleged contemners on personal bond with the direction to file affidavit. In spite of the direction passed by this court, no affidavit has been filed. On 14 January 2026, this court was, and the contempt application was taken of hearing. On the said date also, this court has granted liberty to the alleged contemners to file affidavit in opposition subject to payment of cost of rupees 10,000 each, but till date the affidavit has not been filed. Thus, this court is of the view that alleged contemners have willfully and deliberately violated the order passed by this court and also not filed the affidavit in spite of several opportunity given to the respondent. Thus, the alleged contemners are directed to appear before this court in person on where they are residing, and to appear before this court on 17th of February 2026 at 3 p.m. On 3 p.m.
My lord,
Yes.
Lord, in respect of contemners number 8 to 12, my lord, we are the persons who have bought the property, lordship, under the, because we were not aware of the order. I have only one submission, my lord. I have been informed, my lord, that these contemners have been asking them for reconveyance. However, since no assurance of repayment of the money paid is being forthcoming, they have not executed.
First I will tackle
Yes,
them, then I will
yes,
tackle
lord. I
you.
shall not. I have asked them not to take any steps since the matter is pending before your
Once you are
lordship.
not going to, how Mr. Banerjee, your deed will be cancelled. They are not ready to cancel the deed. How
Lord,
to-
we are ready, but there is no payment. Assurance of payment is not forthcoming. Therefore,
which are already cancelled. 4, I am told, talks are underway.
Yes, my lord.
Surely they will take back what they have given, otherwise they are not going to cancel. Court will not wait for an eternity for them. If they are
My lord, we
take
will,
back the time, my lord,
my lord, we will execute as and when your lordship directs, we will do so, lordship.
Let me. Hmm. Okay, next.
Grateful. Dada, 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 Dada.
Item number 9.
China. That comes for holidays with his family. His wife and son had left, and he was stopped at the immigration center. I am not saying he was correctly advised, he has got the 590. Now he has got a letter. I'm only seeking to WhatsApp and the same manner is covered by your lordship judgment.
Tomorrow, how it possible? कल 2 बजे है, कल 2 बजे मैटर है. Leave granted and to list the matter tomorrow at urgent matter within 10 matters. Within 10 matters. Over, original side over. Yes, what is the matter? Come next day, come next day.
My lord, I appear on behalf of the alleged contemner number 1, 2, 4, 5, 6, and 7. My lord,
What is your instruction?
my lord, kindly give me 15 days time. My lord, the alleged contemner will appear and they will pray for.
Who is the alleged contender? Why you are not appearing? So and so.
My lord, this is
Notice has gone
my lord,
so
this
many places.
My lord, this is
Then I have to take
my
the.
lord.
I have to direct the police authority to bring you. Now you are coming.
My lord, this
And
is
that to
change
15
breed.
days
My
you
lord,
required.
liberty may be given,
What?
my lord, to file the Vakalatnama. No objection, Vakalatnama also Anindo Sundar Das advocate has given, but I could not file it in the department. They are telling the Vakalatnama is in the name of the farm, my lord. That is the difficulty, my lord. If the
name of the firm, if the person is appearing, then you do one thing.
My lord.
When your person will appear before this court.
My lord, 15 days, my lord.
15 days I
My
will
lord,
not.
kindly, my
I am
lord.
fixing on 11th if your client is coming. Otherwise, I will direct to bring.
My
Come
lord.
on 11th.
My lord.
Okay, I am not passing an order. Come on 11th.
Grateful, my lord. Grateful. My lord, liberty may be given for filing.
On that day, then I will allow you. If your petition will present here, then you take the signature and file in the department.
Grateful, my lord.
Matter will remain in the list. Let it come.
My lord, shall I give my name?
हाँ?
Shall I give my name?
एकटा काम करो उसमें कोई है नहीं है चलेगी okay you I will record next Tuesday next Monday ना कल आएगा Monday कल आएगा tomorrow I will record
We will come back, my lord.
yes
Grateful, my lord.
give the order yes where is the order? Where is the interim order?
Being ordered on 24th, 2025.
No, 24th?
12,
12 December 2025.
Yes, sir. First order.
Yes, considering the prima facie case, balance of convenience, respondent allowed to continue the awarding work, ignoring the claim. Respondent allowed to continue the awarding work, ignoring the claim of the petitioner. The petitioner is accordingly restrained for finalizing the tender.
Yes, sir. My lord, they wrote a letter for contempt on 7. That day matter was called in my absence because you gave me notice that matter.
There is an order of.
My lord,
Please hear me. 24 December, this court has restrained you for finalizing.
Yes.
So, what is the condition of the tender now?
my lord, kindly look into the. I have handed over the minor court matter. One reply on dated 12 January 2026.
Give. You. Where is that? With this one? 16 December. Just a minute. Yes.
What is the instruction from the department? But as per instruction of the department, I am suitably replied his letter for contempt. My lord. But,
Leave aside the contempt. Why I am
no,
telling?
this is not a contempt. He wrote a letter.
Sir, today is not the contempt application. Today he has only mentioned for the extension of interim order. So what is your submission on that?
My submission is that, my lord, in page 2, my lord, of my letter, that all the bid documents has finalized prior to the interim order.
So you file the affidavit. I am continuing the interim order. You finalize.
Sir, can you keep the record, my lord, the two letters written by the
File affidavit.
Yes, my lord.
The matter is listed as to be mentioned on the supplementary list. Counsel for the petition submit that initially the interim order was granted by this court on 24th of December 2025 till 8th of January 2026. And on 8th of January 2026, this court has further extended the interim order till today. And he prays for extension of the interim order. Learned counsel appearing for the respondent submit that after the interim order passed by this court, the petitioner has issued a notice and a notice for initiation of the contempt proceeding, and on receipt of the notice, the respondents have replied to the said notice informing that before the interim order is passed, the respondent authorities already concluded the tender. Full stop. Whatever the issue, full stop. This court consider the submission made by the counsel for the respective parties as there is a existing interim order. Let the same be continued till 5th of March 2026 or until further order, whichever is earlier. In the meantime, when you file the affidavit, the respondent shall file affidavit in opposition within 2 weeks. Reply, if any, there to be filed within a week thereafter. Leave the matter on 5th of March.